Good evening, chat. Hello. We have day. No dos, strength, Cinco of the Connor Grubb murder trial. We're going to get that going here. Sorry for the delay, but the groceries came in and I had to help 2.0 do all that stuff. So, no underwater piano recital this time. It was merely just me helping 2.0. Your Clyde content withdrawal is painful. Well, don't worry. There'll be some Clyde content in a bit. There will, I promise. 2.0 is probably holding me hostage until because the plans are at the Bullbean factory. Yes, that's true. That's true. And then Chugi Show's been a member for 11 months. Is All Hail Clyde, the Slayer of Greys, the Peen Destroyer. Yes, and thank you for 11 months of support. I appreciate it very, very much. Tilly says Sean fell down the well. Wait, that's a toilet. It'd be a big fucking toilet. Let me tell you what, buddy. And Edward Jones says everybody's jonesing for their Clyde fix and can't type straight. I know. You're gooning to this chat? Well, hey, yeah, we all got to goon to something. Been there, done that says, I was on DSP's show. Yep, that's exactly where I was. Jim Cox has been a member for 21 months. Thank you, Jim. Says, how do I turn this off? You mean your membership stuff? You have to go into your settings tab on YouTube here, and then it says billing and payments. And you can go through there and take care of that stuff. Purchases and memberships is how you do that. And you can check all your super chats, but you can also check out all your memberships. And that way you can manage those as you want. So if you want to, that's where you do it. Just finished watching Nate's video from earlier today. Yes, Nate is, guys, oh my God. You know, it is so amazing. It is so amazing Nate is doing well. Nate put that up in the Layback Law chat, and it was like 12:30, and I was on the way to court. I was like on my, like during my lunch break. I was going between courthouses. And I just like popped into, I clicked the StreamYard link, and it was going to be in the back room, and I was just going to type Nate, you know, just hello, and I hope that he's doing well and can't wait to talk to him when I get a chance. And Nate was sitting there with Eric Hunley. Him and Eric Hunley were just bullshitting. And Nate brought me up, and, you know, him and I were talking for a couple minutes. Eric and all three of us were talking. It's good to hear him. And, you know, I told him he needs to take the hair and see if he can comb the dreads over. But other than that, though, yeah, Nate's doing good. And thank God. Thank God for that. Still waiting on the information, but yeah, thank God that Nate's doing well. Lona Laskin says, been a member 15 months. Thank you for the support. Says, Fat Man never fails to be late. Exactly. Thank you. So, but anyways, guys, I just want to say, does he speak with the Nigerian accent now? No, I brought that up. You know what? I told him, I hope he realizes there are so many people out. And I heard a clip though about so many people called the hospital. They gave him like a private like a special number and things like that. But yeah, so many people were checking in on him. All of you did that. Thank you so much. Those well wishes, that positivity, all that's, you know, that he needs every bit of that, you know, the prayers, the well wishes, the positivity, every bit of it. Thank you very much. So I'm glad he's through. Nate felt very VIP. Yeah, I heard that clip. Yes, I heard that part of it. It was very funny. Let's see what else I'm going to say. Yeah, that's it for right now. Yeah, so we're going to get started. Guys, remember, Connor Grubb is accused of murdering Takia Young, or Takia Young, however the hell you want to pronounce it at this point. We don't, you know, it's... So anyway, she was caught stealing alcohol from the Kroger in Blendon Township. It's outside of Columbus. And as she's sitting there, you know, she won't get out of the car. They're trying to arrest her. And she does all this nonsense, and they order out the car. She starts the car, and then they kill her. And they have to shoot her and kill her. And here's the body cam. If you guys don't remember, this is where the cops were already working at the scene of the crime. They were already working, helping some old lady get out, like her car unlocked. And this is Connor Grubb working on the car.
Attend to 29-3705 Managua, 3705. A female is hallucinating. Too much of a loss for attend.
Out of the car. Out of the car. Out of the car.
Clinic 7 back in service, 1828.
Get out of the car. Then get out. No. Then get out.
Get out of the fucking car.
Get out of the car.
Get out of the fucking car.
Get out of the car.
Shots fired.
Shots fired. Stop the goddamn car. Stop the goddamn car.
We're going to have a 44 on the customer now. He's going to be out.
Guys, that's from Connor Grubb's side. This is the sergeant who's working with him. We just saw him testify yesterday, Eric Moynihan. Here's his view.
Attend to 29-3705 Managua, 3705.
What's that?
Female is hallucinating. Too much of a loss for attend.
Hey, stop. Hey, out of the car. 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 They said your stole stuff, do not leave. Get out of the car. Then get out. No, then get out. Get out of the car. Get out of the car. Shots fired. Stop the goddamn car. Stop the goddamn car.
And there you go. That's it. Now we're going to move on to day 5. This is now Seth Stoughton. This is the guy who was the expert in the Kim Potter trial. He was like a cop for 20 minutes down in Florida at like FSU, and now he's like a world-renowned police expert on the use of force and all kinds of other garbage. So it's very interesting how this goes. So, and remember, we watched this. The defense had to call some witnesses out of turn. The state is in the middle of their case right now, finishing up. But yes, Kim went to jail. Yes. And Greg says, "Hey, Sean, happy Turkey Week." Yep. Registered says, "Any funny moments in this trial?" Not necessarily funny, but just I still don't understand how in good faith they tried this. The prosecutor's like, this one was clearly. Like, I don't understand why they thought this was a good idea to try and take the trial. Like, this, they should be fucking ashamed of what they did here. If I was a prosecutor, I'd be embarrassed about this. Absolutely fucking embarrassed. There's no excuse for what the fuck they did. Really. And actually, I think we're on day 6 here. Hold on. I got to check this chat. Hold on here. Let me see. So day 1. So November 10th, 12th is 2, 13th is 3. 14th is 4. Yes, the 18th is number 5. Sorry, I was just trying to catch my things up for my thumbnail, because my thumbnail game, I did not get it ready because I was a little occupado. And I was working on that. So sorry, making sure I got the right thing. Okay, guys, so we are going to get this here. This is day 5. Let's get this rolling. Wait, why is... Oh, there we go. Wrong thing here. Don't forget about the case where the prosecutor's wife is unfaithful, tried where the cop was fighting with some black guy, and they tried that. I don't know which... And then, let me see. It's clear why he should be charged. Yeah, yes, I understand why they say that. Yes. Lauren says, sad about Comey or James. Yeah, they could still get charged again. I'm praying a naval pilot who served in 39 combat missions will be jailed because he said the military should refuse orders that aren't legal. If that's what you think, that's what you think. This is now our greatest hope. Oh, I hope he has fun and squirming in front of a court-martial. Fuck him. Fuck him and his potato-brained wife. Erica, congratulations. Heard you had a sex change or something you went in for, so congrats. All right, so let's get started here, guys. Let's get started. So let's get started here.
I did want to put Stephen informed me that I needed to put a couple things on the ground. Okay. Because the next witness, I believe, is Professor Stokes, right? We would ask that renew our request that the court do an in-camera inspection of his grand jury testimony. You ruled on that, but I believe procedurally we're supposed to bring that up now, as well as renew our objection to the officer created for any type of testimony being allowed into that. We don't believe that that would be appropriate.
Any response on behalf of the state?
Judge, similar response as to our file response as to relating to grand jury testimony. We would stand on our original response to that. There's not been any particularity shown.
Now, chat, remember, this expert testified, which is weird. They brought an expert into the grand jury, it sounds like. That's a very unique thing. That's not a very common thing that you order. You have a grand jury expert testimony. It tells you a lot. They couldn't find any cop in the area to testify against him. That's what I indicate. That's what that means at this point. So, yeah, this says a lot about how shitty their case is. This says a lot about how shitty their case is. Let's see here. What, did I miss something? No, I think we caught everything else. So let's go. Let's go.
As it relates to the officer created jeopardy in the court ruled yesterday, that's not to be considered as a factor. The court is not going to instruct on that on jury instructions, so that it can't be considered the totality of the circumstances reasonable evaluation. And I believe the testimony would be appropriate for that. And her testimony yesterday from Davis concerning his opinion as to what we should be considered for.
And note your objection. Anything else we need to put on the record prior to beginning the jury? Go to the jury.
But you're going to say something that this was the witness we're going to take out of order?
I can.
That makes sense.
I can't believe we're starting on time. Crazy.
See, chat, it's not just me. It's not just me, chat. So just, like, leave it alone.
All rise.
All right, everyone can have a seat. Everyone have a good evening last night? Good, good. What we're doing, the next witness was taken out of order. He was unavailable to be here last week, and this would be the state's case in chief. Is there any further witnesses on behalf of the state of Ohio?
Thank you, Your Honor. The state call says so.
little maze around here.
DK, this trial went from November 10th to November 18th, and then the jury took like 2.5 days to deliberate. But remember, there were just some broken up days in there. Like Veterans Day happened in the middle of it. They had a couple days that were half days. So this probably could have been like a 4-day trial at the end of it, really, if you want to know the truth about it. It just took about 2 weeks.
Raise your right hand. Do you solemnly swear or affirm under penalty of perjury your testimony in this case to be the truth, the whole truth, nothing but the truth?
I do.
Have a seat. Pull yourself up close to the microphone.
Thank you. May I proceed, Your Honor?
Okay.
Thank you. Good morning. Could you begin, please, just by stating your first and last name and spelling it for the record?
Good morning. My name is Seth Stoughton, Sethstougton.
What is your current occupation?
I'm a law professor at the University of South Carolina, Joseph F. Rice School of Law, and I'm the faculty director there of the Excellence in Policing and Public Safety program.
And how long have you been a law professor at?
I mean, I fucking hate this guy too. He's fucking pathetic. This guy's a faggot.
And I'm the faculty director there of the Excellence in Policing and Public Safety program.
And how long have you been a law professor at the University of South Carolina?
This is my 11th year there.
What courses do you primarily teach, or what are your main areas of research?
In the law school curriculum, I teach criminal law, which is a first-year required class. I teach criminal procedure. I teach police law and policy, and a seminar on the regulation of vice. I've also taught a class called Advanced Topics in Criminal Law, which I haven't taught in a while. It's been 8 years or so. With the Excellence in Policing and Public Safety program, or EPS, I teach principles of leadership and management, collaborative communications. I assist with evidence-based policing, critical incident and sentinel event review, sound agency management, collaborative communications, co-production of public safety. I feel like there's one more that I'm missing in there. Oh, civil rights for law enforcement leaders.
And do you teach exclusively in the law school? Do you do undergraduate as well?
I've taught an undergraduate class. I've taught my regulation of vice seminar at our honors college, but no, my work with the law school is exclusively in the JD program and in the policing program.
And Professor Stoughton, going back to the beginning of your law enforcement experience, what did you do prior to becoming a law professor?
I served as a police officer with the Tallahassee Police Department about just under 5 years full-time, and stayed on as a reservist for another 6 months, a part-time officer. I was an investigator with the Florida Department of Education's Office of Inspector General, doing administrative and criminal investigations as it related to the Department of Education, sort of like the internal affairs unit of the Department of Education. And then I went to law school.
And what period of time were you a police officer in Tallahassee, Florida?
That was 2001 until the end of 2005, full-time, and then until May or June, I think, 2006, part-time.
And what type of area is that? Is it big, small, rural, metropolitan?
Tallahassee is Florida City. So it's the city itself is 90 square miles or so. We had 350 or so officers at the agency. The metro population was in the 200,000 to 300,000 range, something like that. I'm sorry, the city population was in that range. The metro area was a little bigger. Mostly suburban, I would say. A little bit of urban for what counts as North Florida urban, and then suburban, with a lot of rural outlying areas that were mostly outside of the city limits.
And what were your roles and responsibilities when you were a police officer in Tallahassee?
I was assigned to the Uniform Patrol Division. I was a Uniform Patrol Officer, which just meant I was in uniform riding around on patrol, answering calls for service, self-initiating activity like traffic stops or business checks, just your normal beat cop. I had some additional duties beyond the assignment. I
Sorry, Chad. Everything went down. I'm coming back. Yeah, Nick got me. Sorry, Chad. Hold on. I got to back this up here. Hold on. You want to hear this guy blow V8? Here we go. Sorry. Sorry about that.
Just by stating your first and last name and spelling it for the record.
Good morning. My name is Seth Stoughton, Sethstougton.
What is your current occupation?
I'm a law professor at the University of South Carolina, Joseph F. Rice School of Law, and I'm the faculty director there of the Excellence in Policing and Public Safety program.
And how long have you been a law professor at the University of South Carolina?
This is my 11th year there.
What courses do you primarily teach, or what are your main areas of research?
In the law school curriculum, I teach criminal law, which is a first-year required class. I teach criminal procedure. I teach police law and policy, and a seminar on the regulation of vice. I've also taught a class called Advanced Topics in Criminal Law, which I haven't taught in a while. It's been 8 years or so. With the Excellence in Policing and Public Safety program, or EPS, I teach principles of leadership and management, collaborative communications. I assist with evidence-based policing, critical incident and sentinel event review, sound agency management, collaborative communications, co-production of public safety. I feel like there's one more that I'm missing in there. Oh, civil rights for law enforcement leaders.
And do you teach exclusively in the law school? Do you do undergraduate as well?
I've taught an undergraduate class. I taught my regulation of vice seminar at our honors college, but no, my work with the law school is exclusively in the JD program and in the policing program.
And Professor Stone, going back to the beginning of your law enforcement experience, what did you do prior to becoming a law professor?
I served as a police officer with the Tallahassee Police Department, about just under 5 years full-time, and stayed on as a reservist for another 6 months, a part-time officer. I was an investigator with the Florida Department of Education's Office of Inspector General, doing administrative and criminal investigations as it related to the Department of Education, sort of like the internal affairs unit of the Department of Education. And then I went to law school.
And what period of time were you a police officer in Tallahassee, Florida?
That was 2001 until the end of 2005, full-time, and then until May or June, I think, 2006, part-time.
And what type of area is that? Is it big, small, rural, metropolitan?
Tallahassee is Florida City. So it's the city itself is 90 square miles or so. We had 350 or so officers at the agency. The metro population was in the 200,000 to 300,000 range, something like that. I'm sorry, the city population was in that range. The metro area was a little bigger. Mostly suburban, I would say. Little bit of urban for what counts as North Florida urban, and then suburban, with a lot of rural outlying areas that were mostly outside of the city limits.
And what were your roles and responsibilities when you were a police officer in Tallahassee?
I was assigned to the Uniform Patrol Division. I was a Uniform Patrol Officer, which just meant I was in uniform, riding around on patrol, answering calls for service, self-initiating activity like traffic stops or business checks, just your normal beat cop. I had some additional duties beyond the assignment. I developed and taught self-defense classes in the community. I developed and taught some children's self-defense classes. I was a founding member of our special response team and on that for about 2 years before I left.
And then when and where did you obtain your degrees?
My undergraduate degree was at Florida State, which I started before I became a cop and finished after I was an investigator. So it took me 10 years to get my 4-year degree. And then I went to the University of Virginia for law school and completed that one shockingly.
Which, guys, University of Virginia is no slouch. That's actually a very impressive law school. It's a very difficult law school to get into. So I'll give him credit there. But I love how he's like, I gave children self-defense classes. It's like, yes, kids, when you see a guy that looks like him, kick him in the balls and run away.
On time.
Well,
And Professor Stone, since you have been a law professor, have you published extensively in your field?
I have, yes.
And what are your primary focuses?
I'm a policing scholar. I study the regulation of policing, which essentially means I look at the legal and the extra legal rules, things like agency policy and culture that shape officer behavior. A lot of my work is focused on tactics and the use of force, but I've looked at a range of other things, everything from off-duty employment to the development of Fourth Amendment rules that affect policing, to the relationship between state law and agency policy and Fourth Amendment doctrines.
And what type of works have you published?
I've done academic articles both in law reviews, which is the type of publication in my field as a legal scholar, along with criminology articles. I work with a group of criminologists to do empirical work on a whole range of things. I've done book chapters on some of the same topics, and I have co-authored one book.
And is your work extensively cited and relied upon in the field?
Yes,
And do you present on the topics of your focus as well?
all the time. Yes, I present pretty broadly, both to practitioner audiences. So especially in the context of use of force review, the Washington, D.C. Metropolitan Police Department does something called their Police Leadership Academy. They bring in 70 or 80 officers from all over the country, and usually about half dozen or so international for 3 weeks of training. They have me come up to do the use of force review piece. The most recent time was actually pursuits and use of force review. I've done the same thing with regional police leadership trainings with Charleston Police Department. In a couple of weeks, I'm going to Nashville. There's a Tri-City Police Leadership Academy that's doing the same thing. So I also work specifically with agencies on request. That's one of the things that my program, the Excellence in Policing and Public Safety program, does, is work collaboratively with agencies in South Carolina to provide technical assistance on some of these issues. Beyond practitioner audiences, I present all the time to academic audiences. I was just last week at the American Society of Criminology conference. I present to judicial conferences. I've been here presenting on aspects of use of force review at the Ohio Judicial Conference, for example, to attorneys at both prosecution conferences, defense conferences, combined conferences. So yeah, I present sometimes more than I want to.
And are you regularly involved in actual training of police officers on use of force and tactics?
Not usually with line officers, but often with investigators, supervisors, and command staff on reviewing incidents, yes.
And Professor Stoughton, do you get retained to provide an expert review of officer-involved use of force cases?
Yes, I do.
Roughly how many times do you think you have been retained to provide expert analysis?
At this point, it's hovering around 150 times.
And what type of individuals or entities will hire you for your services?
It's a mix. So it's across, in civil litigation, it may be a plaintiff's attorney or a defense attorney. Plaintiff's attorney being the one who was initiating the lawsuit, suing someone else, the defense attorney being the one who was defending that lawsuit from the plaintiff. In criminal litigation, I've been retained by prosecutors at preliminary review stage, at grand jury stage, at trial stage, as well as by criminal defense attorneys.
And have you offered opinions? Have you offered opinions both that an officer's actions were reasonable and unreasonable? Have you provided testimony as to both sides?
Yes.
And how many times roughly would you say you testified in court before?
In court is probably around 20 times, testifying in trial, 18, 20, 22, maybe something like that.
What courts have you testified in before?
Oh boy. Georgia State Court, Ohio State Court, Nevada State Court, federal courts in South Carolina, in boy, kind of a lot. I can look at my CV if you want the full list, but sort of all over the place. State court in Pennsylvania, New York, federal court in, I think, Virginia. Yeah, kind of all over.
And in the previous times that you've testified in court, have you been declared an expert?
Yes.
In what fields have you been declared an expert in?
Primarily in police tactics and use of force, or generally accepted practices relating to police tactics and use of force. In a couple of cases, it's been, Minnesota, I forgot about Minnesota. In a couple of cases, it's been police procedures more generally, sometimes investigative procedures or things like that.
Your Honor, at this time, the state would move to have Professor Stoughton declared as an expert in policing and use of force, generally accepted practices.
He can render his opinions.
Thank you, Your Honor. Professor Stoughton, were you retained to provide expert analysis in the shooting death at Takaya Young that occurred on August 24th, 2023?
Yes.
And what is your normal rate that you charge when you're retained to provide expert analysis?
It's changed a bit over the years, but in this case, if you don't mind, I will refer to my report to remind myself of what that is. It depends on when I was retained. In this case, it was $415 an hour.
450.
I'm sorry, 415.
And how many hours would you say roughly you've spent thus far working on this case?
Oh, that's a great question. 30, 35 hours, maybe?
And is that pretty standard?
Yes.
And Professor Stoughton, is your rate, is that kind of industry standard? Is that high, low?
I don't fully know. I know I charge more than some people. I know I charge less than some people. So I think I'm within sort of industry norms on that.
And what is it that you do when you are retained to provide expert analysis? Is it always kind of the same methodological approach?
It is. So usually the retention starts with a preliminary phone call. The phone call is laying out the sort of type of case that we're talking about. There are some aspects of policing where I can help guide an attorney towards an expert, but I am not the guy who's going to be helpful. Assuming that the case is something within my area of expertise, then the question turns to the sort of facts of the case. There are some occasions where I know, even from the preliminary conversation, that I'm unlikely to be helpful to the attorney in litigation. So if they want an informed opinion, I'd be happy to share that. But if they're looking for someone to help them make their argument, maybe I'm not the best person. If we get through that portion of the conversation, then there's usually a formal retention and I'm provided the materials. Usually I get all of the materials in the case. Sometimes attorneys will curate the materials a little bit, so I'll get a subset of the materials in the case. And then the methodology is very consistent. I review the materials, I identify what the issues are. Once I identify what the issues in the case are, then I identify what generally accepted police practices were relating to those issues as of the time of that incident. And then I compare that standard to the officer's decisions or actions to determine whether the officer acted consistently or inconsistently with those generally accepted principles or practices in policing.
And Professor Snowden, what is the difference between a generally accepted principle and a generally accepted practice?
So generally accepted just means it is broadly accepted in the field. Any reasonably well-trained officer anywhere in the country would say, yeah, that's more or less the way we do things. Policing is a little weird in that way because we don't have a centralized sort of top-down set of instructions. It's not like accounting where there's a book of generally accepted accounting principles. In policing, we identify what's generally accepted by seeing what bubbles up from the bottom to see what practices in the field actually look like. With the difference between principles and practices, principles are a little bit more abstract. They are concepts that inform policy or officer behavior, but they're not specific instructions. So a tactical principle, a generally accepted principle like tactics and using tactics to navigate the dangers of particular situations would be a generally accepted principle in policing. We want to manage officer safety and public safety in a way that balances safety against the police mission, right? Whatever the goal is in that particular interaction. When we're talking about generally accepted practices, that's much more granular. That's a little bit more specific. So in, for example, a high-risk traffic stop context, there is a protocol, a high-risk or felony stop protocol that officers will use that has been developed by policing over decades of practical experience. So it's literally a series of steps, and we would say that's the generally accepted practice in that particular context. Not everything in policing has generally accepted principles or practices, but there are certainly enough areas that do that we can say that is in fact generally accepted.
And as a policing expert, what do you do, or how do you go about determining whether or not a principle or practice is generally accepted in the field?
Yeah, this is where doing a lot of broad review is necessary. So looking at agency policies from all over the country, looking at training documents when they're available or information about police training, sometimes even things like national or representative surveys of officers to identify what's standard in policing, along with looking at the way that we communicate information to police practitioner audiences. So, for example, there are police-specific publications, including non-academic, non-scientific publications like Police Magazine or Police One, that are used to get information to officers about police practices, or that are used to reflect common information between officers. There's also statements from groups like the Police Executive Research Forum or the International Association of Chiefs of Police that will develop model policies or consensus papers. And the important thing to note with any of those is something is not authoritative because the International Association of Chiefs of Police said it. It's not generally accepted because they said it. It's actually exactly the opposite. The reason that the International Association of Chiefs of Police is saying something is because it is generally accepted. That's how it gets into a consensus paper or a model policy.
And are you constantly staying abreast of developments in policing and law enforcement?
Yes, police tactics, police principles and practices change over time. Sometimes they change very abruptly, and we can identify a specific incident, a specific point in time. For example, if we look back into the mid-1990s, the police response to an active shooter situation was very, very different prior to the Columbine shooting than it was after the Columbine shooting. So sometimes there are, if you'll forgive the expression, triggering events that lead to a noticeable change in police tactics.
You see what he did there?
Sometimes we just see a gradual shift as technology changes, for example. As body-worn cameras become more standard, we see slight changes in police practices.
And did you apply the general methodology you described in your role as an expert in this case?
I did, yes.
And what materials did you review in this case before rendering the opinion?
There were kind of a lot of materials in this case. I think I have something like 7 or 10 pages of materials, but the very short summary would be video, audio recordings, and written reports.
And did you review video in this case?
Yes.
And Professor Snowden, did you synchronize the different videos that were provided in this case?
Yes, it did.
And were you able to determine the timing of different events throughout the interaction?
Yes.
And Were you able to synchronize the different videos so you could provide screenshots of different videos happening simultaneously?
Yes. So I load the videos into an editing program called VSDC that allows, first it allows you to import the video in their native format, their native
That's what
frame
I
rate.
use.
So if a video comes in at 30
That's my video editing software.
frames per second or 29.97 or
VSDC is a very good platform, chat. Highly recommend.
32 or whatever it is, it will load that into its native frame rate. You can load multiple videos into it, and then you can display the videos side by side with run timers. So you can see either how many frames have been going since that video started, or the elapsed time from the start of that particular video.
And did you synchronize Officer Grubb's body-worn camera, Sergeant Moynihan's body-worn camera, as well as the Kroger surveillance video?
Yes, I did.
And how are you able to line up the times in the different videos?
So there are two different sort of things to check when you're trying to line up these videos, right? One of which is you look for audio events, like things you hear on the video recording. If you know, like an audio waveform, the little stereo symbol, you can use that visually to help identify, particularly when there are peaks in it. You can identify when those peaks overlap between two videos, and then it's a matter of lining up that audio waveform. You also listen to the video as you watch it, and when you have videos where the audio is out of sync, it's very distinctive because you're hearing the same thing ever so slightly off of each other. So when I synchronize videos, I don't turn either of the video's audio off. I leave all of the audio on, and then listen for a complete overlap where it sounds like a single audio source instead of two different audio sources. Now that's when I have audio, and one of the videos in this case, the security camera video, didn't have audio. So without audio, or even in the videos with audio, you're also looking at visual events. You're looking at identifiable events that happen between videos, which might be a door opening or someone's arm moving up and then down, where you can identify in the video the frame at which the hand hits its apex before going down, and you can line those up between videos.
And were the embedded timestamps in the different videos consistent with one another?
No, not at all. And that's actually very common. The embedded timestamps, even in two videos, like two body-worn camera videos with the same manufacturer, the embedded timestamps will be fractions of a second or even entire seconds off. In this one, I'd have to go back and look, but the timestamp between the security camera video and the body-worn camera video was substantially misaligned. So you'll see different times in the embedded timestamp at the same time that the same events are happening.
And will you always synchronize video when you're retained as an expert to assist you in your analysis?
Not always. Sometimes synchronized video is provided for me. Sometimes there's only one video, there is nothing to synchronize, or there is no overlap in videos, so there is nothing to synchronize. But it's pretty common. I would say I do it in the majority of the cases where there's multiple videos.
And did you provide freeze frames in your report of the different videos at the same time?
I did, yes.
And were those put into a PowerPoint?
I did not put them into PowerPoint, but yes, they were.
Your Honor, may I publish this as demonstrative evidence to assist with the testimony? Okay, Professor Stoughton, what are we looking at this screenshot you provided here? Is this kind of a setting of the scene?
It is. So I will break down the different little pieces of it. So in the bold, what you see is the source of that video. This is Kroger parking lot security video. Then you see the timestamp that is on the video itself, which is 18:27:48. The number in the parentheses is the runtime of this video. That is, at this particular frame, this particular video has been playing for 13 minutes, 47 seconds, and 0.700 seconds. Cropped and marked underneath that indicates what I did to this image. So I cropped it, which is why you don't actually see the embedded timestamp. That is, I've zoomed in a little bit on it, and marked because I have labels that obviously do not actually appear in the original video. So the labels with their little arrows point to different things of note. And yes, this is relatively early on, sort of setting the stage for the reader of the report.
And is this shortly before the use of force incident occurred?
It is, yes.
And what are we looking at these freeze frames?
So this is the point at which Officer Grubb has moved in front of the vehicle, as visible both from his body-worn camera on top. Again, you can see the title of the video, the runtime, the parentheses, the embedded timestamp, the parentheses is the runtime. And then both of these videos are cropped. This is the Officer Grubb's body-worn camera on top and the Kroger security video on bottom.
And have we moved slightly forward in time here?
We have, yes. So if we, the easiest way to sort of track the time, for me at least, is to look at the runtime, the number in the parentheses. So here, Officer Grubb's body-worn camera on top, that is not cropped. That's the full picture of his body-worn camera. And then on bottom is the Kroger parking lot security video at the same the same point. That one is cropped, and obviously you will note that the quality is not perfect.
And what has happened thus far at this point in the screenshot?
So at this point, Ms. Young has turned the steering wheel to the right. Officer Grubb has drawn his firearm, and you actually see it there in his right hand in his body-worn camera at the very top right of that picture. You can see his arm out with the firearm pointed.
And had the vehicle moved at all yet?
I don't believe it had moved at this point. I can look at my report to make sure, but I don't think it had edged forward initially. If you'll give me just a second, I'd like to confirm that. Sorry, it's a long report. Give me just a second. No, I don't believe so. Wait, sorry, I'm just checking. Yes, I'm sorry. I believe her vehicle had edged forward.
She turned the wheel, chat.
His
Look, the wheel's turned. She's turning. She's cooming, chat. She's turning the wheel. Oh no! Wait, what the fuck is this gonna do?
hand on the front.
Does the putting of the hand on the front of the hood happen right after the vehicle first moves forward?
I think it happens after the vehicle moved forward for the second time. So the vehicle sort of moves forward a little bit, stops for a second, and then moves forward again. And the hand goes on the vehicle, as I recall, after the vehicle starts moving the second time.
And what are we looking at in these videos?
So this is a lot. The page is very busy, and I apologize for that. But this is synchronized videos where they are synchronized in horizontal order. So on that top row there, all of those videos are depicting things that happen at the same time. And that's true as you go down every row. So although the embedded timestamps and the run times are obviously different because the videos have different embedded timestamps and they start at different places, what you're seeing is screenshots of the synchronized video. This is not every frame of the videos. This is instead every 0.2 seconds, every fifth of a second. There's a jump to sort of the next row. So there are some frames in between these.
And what is happening right now during these synchronized screenshots?
So you can see in the leftmost column, which is the Kroger parking lot security camera video, you can see Miss Young's vehicle moving forward and to the right. In the middle column, that's Officer Grubb's body-worn camera. You can see the perspective from his body-worn camera. And on the right is Sergeant Moynihan's body-worn camera. So you can see the perspective of that camera depicting the same incident at the same time, but from different perspectives.
And are these rows moving forward in time?
Yes, every row moves forward 0.2 seconds. So if you look at the embedded timestamp, it's not super helpful because I'm breaking things into smaller than 1 second increments. But if you look at the runtime, that number in the parentheses, you'll see, for example, the Kroger parking lot security video goes from 1414.533 to 1414.733, 0.933. That's just that jump forward in 0.2 second increments.
And does this series of screenshots lead up to the moment that deadly force was used?
It does, yes. This is a continuation. All we are doing is advancing time in that 0.2 second, that 0.2 second increments. So you can see again the vehicle continuing to move to the right. Officer Grubb sort of moving to the right, his hand remaining on the vehicle there. And from Sergeant Moynihan's, you start to see aspects of where, like in the third column, second row, you can see a little bit of where Officer Grubb was.
That's the one we were previously on.
Yes. So there were 3 pages of that 0.2 second progression, right? I think we skipped through either the second or the third one of those, but that's what they show.
That'd be the first one.
That's the first one, and then the second one, and then there's one. So that's the one that we were just looking at, where you can see Officer Grubb in column 3, row 2. And then there should be one more.
And is that where you can see Officer Grubb? Is that Sergeant Moynihan's body cam?
Yes, Sergeant Moynihan's body cam, the center most row there, you can see Officer Grubb.
And then the Officer Grubb video in the centermost row, is that the exact same time as you see Officer Grubb on Moynihan's body cam?
Yes. And this is the third of the 3 pages. Again, it's continuing to show the same thing, just different events because time is progressing. So here you can see this Young's vehicle continuing to move forward. Officer Grubb now sort of moving over to the left of the vehicle, both on the Kroger security camera video, on his video, and you can see it on Sergeant Moynihan's video.
And is this still before deadly force had been used?
It is, yes.
And then what do these screenshots?
So these are the 2 frames. This is now not separated by 0.2 seconds. It is instead separated by 0.033 seconds, which is 1 frame of these 2 videos. And it's the difference in frame, the frame immediately before the shot and the frame immediately after the shot. That is, there is no frame of the video between these 2 things, right? It is literally 1 frame to the next. In the top frame, we do not have the bullet hole. In the window. In the bottom frame, we do.
So here can we see that the shot occurred between this 366 thousandths of a second and 4 thousandths of a second?
Yes.
And what is the timing of when the gun was discharged?
I'm sorry, I'm not sure I understand your question.
Do you use, well, I guess you could use run length of the actual video, run length of the synchronized video?
Oh, yeah. So you can, I mean, if what you're asking is just how do we identify when that shot was fired, we can identify it on that body-worn camera video, right? The runtime of 5 seconds, 5 minutes, 33 seconds, and 4/10 of a second. We can also use the runtime for the approximately synchronized video, which has a different runtime because that entire approximately synchronized video starts at a different spot than this particular video.
So is the 5 minutes, 33.4 seconds, is that the runtime of Officer Grubb's body-worn camera?
It is, yes.
And is that the time you can pinpoint that the shot was actually fired?
I think the better way to put that would be we know that by that point the shot had been fired, right? I have about a 30th of a second there where I don't know exactly where in that time the shot was fired, but I can tell you it hadn't hit the glass on the top frame and it had hit the glass by the bottom frame.
Were these screenshots of where the car finally came to rest after force was used?
Yes, that's correct.
And Professor Stoughton, what are we looking at here? Is the in relation to the moment that deadly force was used?
Sure. So this is now, instead of presenting all 3 videos separately, this is consolidating the 3 videos into my, what I refer to as the approximately synchronized video, approximately because I still have I still have a 30th of a second of play just on the nature of when those videos start and stop. So this is as close as I can synchronize these videos. And what you see, if you look at Officer Grubb's body-worn camera, the runtime there, the top one is 5 minutes, 33 seconds, and then 0.333 seconds. That's slightly before the 0.366 that we saw earlier. It is 1 frame before that. The bottom one is the 5 minutes, 33 seconds, 0.4. And you can actually see in the corner there, the bullet hole. That is the first frame of that video in which the bullet hole appears on the screen. So this tells you what was happening on all 3 cameras, looking at them simultaneously, 2 frames before, and then the first frame at which the bullet appears, the bullet hole, excuse me.
So is Moynihan's body cam at the bottom? Does that show Officer Grubb at the moment the bullet hole appeared in the windshield?
Yeah, so in the bottom compilation of videos, that is approximately synchronized video, 14 minutes, 16 seconds, and 1/10 of a second, 0.100, that shows all 3 videos at the same time. So you can see the bullet hole on Officer Grubb's, which is the top right image, and you can see a little bit, at least, of Officer Grubb's positioning in Sergeant Moynihan's video, which is the top left image, along with the not cropped, so it's zoomed out version of the Kroger video at the bottom of those 3.
And then here, is this actually immediately after the gun was discharged?
Yes, so this is 0.266 seconds after that bullet hole appears in the windshield. And maybe the easiest way to track that is, again, looking at Grubb's body-worn camera video. In the runtime, we saw the bullet hole appear at 5:33.4. This is 5:33.666. So that's 2.266 seconds, just over a quarter of a second.
And where can you see Officer Grubb on Sergeant Moynihan's body camera?
Sergeant Moynihan's body-worn camera is the top left image there. You can see Officer Grubb sort of to the side near what I would describe as the front quarter panel of that vehicle, the driver's side front quarter panel.
And how long was this after the bullet hole appears in the windshield?
It was 0.266 seconds, just over a quarter of a second later.
Professor Stoughton, after you reviewed all of the materials in this case, based on your training, education, and experience, were you able to render any opinions?
I was, yes.
And what were the opinions that you rendered in your report?
As you see them displayed on the screen there, I had two opinions, one of which related to Officer Grubb's decision to move in front of and take a position in front of Ms. Young's vehicle. That was tactically unsound. It was unreasonable. It is unjustified risk-taking under the circumstances, and it's a position that is foreseeably likely to contribute to a officer-involved shooting. The second one relates to the decision to remain in front of the vehicle and to use deadly force rather than to get out of the way of the vehicle. When that's an option, that's what we expect officers to do. So that decision to draw his firearm and then use deadly force as opposed to moving out from in front of the vehicle where he had put himself is also just professionally inappropriate and not consistent with generally accepted practices.
Now, Professor Stoughton, to break down the first opinion first,
Sure.
Could you describe or define what tactics are in the world of policing?
Sure. Tactics, in a nutshell, are how officers manage the risks of a situation and how we balance priorities. So one priority is for the officers to do whatever it is that they're trying to do. That might be investigate someone or serve a search warrant or apprehend someone, whatever the sort of police mission is in that particular context. But there are also risks and dangers and the potential for threat in any type of police action. So we use tactics to try and advance the police mission in the way that is safest for the officer, for the public, for the suspect themselves. Tactics are how we engage in that balancing. That's kind of abstract and academic. So the practical way is tactics are how officers keep themselves and the public safe while doing the job that we want them to be doing.
And are the reasonable tactics to use, and is it always context dependent?
Yes, absolutely. There are entirely different tactics that we expect of officers, for example, in an armed barricaded subject situation, as opposed to an active shooter situation. It would be wildly inappropriate to use reverse tactics, right? With an armed barricaded subject, you set up a perimeter, you take lots of time, you have negotiators, you set up lines of communication. You don't do any of that with an active shooter situation, right? So the tactics are very much geared towards the facts of the particular situation.
And when you are asked to provide an expert analysis on whether or not an officer's actions were reasonable, do you offer your opinions on what the best tactic should have been or what the reasonable actions should have been? Or
No. My opinion is based on what the generally accepted practices were at the time. That is what's reasonable at the time, keeping in mind that reasonable is not best. It is unrealistic to expect officers to make the best possible decision, especially in a high-stress, time-pressured environment. But they still have to be professionally appropriate and make reasonable decisions and take reasonable actions in those situations. So we don't expect in this context, right, when I'm assessing a case as an expert, I'm not looking for best possible outcomes. I'm not applying best practices. I'm looking at what the field has generated as generally accepted in that particular context.
Is there, in any given situation, is there typically a range of reasonable responses?
Yes, very often there's an entire range. It could be that X was reasonable, Y was reasonable, and Z was reasonable. The right way to think about reasonableness, I think, especially in the police tactical context, is not as a coin, right? Where on one side you have heads and that's reasonable, on the other side you have tails and that's unreasonable. But instead think of it much more as a spectrum. There's a range of reasonable options, some of which might even be more reasonable or less reasonable, but there's a range of reasonable options. At some point on that spectrum, however, there is a line that says there's also a range of unreasonable options. So to a significant extent, what I'm trying to do is figure out, based on what generally accepted practices were at the time of the incident, where on that spectrum an officer's decisions and actions should be plotted.
And how, in the world of policing, how do you go about assessing someone's tactical decision making?
So I can give you the complicated version or the simple version. The complicated version is you actually do something of a decision tree, right? You look at the different points at which an officer acted or made a decision, and you ask whether, under the context of this situation, that decision was appropriate or inappropriate, whether it was reasonable or unreasonable, whether it was consistent or inconsistent with generally accepted practices. The way that you actually answer each one of those questions at the different points in the decision tree for tactics is basically weighing the tactical benefits against the tactical costs. It's kind of a risk-benefit analysis or cost-benefit analysis. What are we going to get out of this, and what kind of danger might it create? That's important because we expect officers in many circumstances to put themselves in harm's way, and it's professionally reasonable and appropriate to do so. The active shooter situation that I mentioned is sort of the best possible example of that. It is very dangerous for officers to rush in somewhere when they're dealing with an active shooter, but we expect them to do that because we view the danger created by the officer's actions as worth the potential risks. Saving the innocents from the active shooter are worth that danger. In other situations, it doesn't make sense for an officer to take risks when they aren't justified by the situation. So one example that I use in training is if an officer is trying to apprehend a jaywalker and he sees someone jaywalking and then the light changes, and the only way that the officer could go and apprehend that jaywalker is to throw himself into traffic on a busy road with cars traveling at high speed. And if he doesn't do that, the jaywalker is going to get away. Well, in that case, it's still not worth the risk of doing that. Stepping into traffic is very high risk, and the reward of apprehending a jaywalker is pretty modest, right? So in a situation like that, we would say the risk vastly outweighs the potential benefits.
And is it generally accepted in policing that situations are often dynamic, so a tactical decision-making can change as that same situation continues to develop?
Yes, absolutely. Officers' decisions have to evolve as a situation evolves. There are situations where it may have been tactically appropriate to take one position, but it's not tactically appropriate to stay in that position, for example, right? The fancy police terminology is often tactical repositioning there. You were fine here, now you're not fine here, so you move to another area that provides some tactical advantage. Yeah, officers have to change and adapt as the situation changes.
And is it also, in assessing an officer's tactical decision-making, is it generally accepted in the realm of policing to avoid hindsight bias?
As you're reviewing an officer's incident, yes, you want to avoid hindsight bias. Hindsight bias is this really pernicious little human cognitive bias that it affects the way we view things based on the outcome of those things. And that was wildly academic, so let me try and break that one down just a little bit. When we're analyzing an officer's actions, when we look at that point in the decision tree, we ask, was that an appropriate or reasonable decision based on the information that we knew at the time, based on the information reasonably available to the officer at the time? We don't ask whether it was a good decision based on the outcome of that decision, because sometimes a good decision can still have a bad outcome. That doesn't make it a bad decision. It was a good decision at the time, even if it led to a bad outcome. The same thing is also true in reverse. Just because there's a bad decision does not mean that it's a good outcome and therefore everything is okay, right? A bad decision is still problematic and potentially worth addressing, even if the outcome worked out just fine. So hindsight bias is the potential for the outcome and our knowledge of the outcome to affect the way that we evaluate the decision at the time. And we have to address it by being very deliberate about looking only at the information at the time and separating it from the ultimate outcome.
So does avoiding hindsight bias mean that officers' decisions can't be reviewed and assessed at all?
No, absolutely not. To avoid hindsight and what the Supreme Court has referred to as the 2020 vision of hindsight, all that means is we don't use information developed after the fact to assess an officer's decision-making, because the officer couldn't have been aware of that information at the time. That is, that information couldn't have affected their decision-making because they didn't have that information. So that's what we mean by avoiding hindsight in use of force review.
And Professor Stoughton, when it comes down to policing tactics, how does the element of time factor into it?
Time is the most important tactical concept. Time is what officers need to make better observations, to go through a better decision-making process, to get the additional resources that they may need to deal with a particular situation, even to move from one position to another, right? That takes time. So a large focus in police tactics is in creating time, giving officers more time to address a particular situation. A use of force incident can happen very, very quickly. The phrase that's often used is split second, right? It can happen in a split second. Tactics, to a very significant degree, are designed to avoid putting officers into a position where they have to make an actually split-second decision. The goal is to give officers as much time as the situation allows so that they can make the best possible decision and a professionally reasonable and appropriate decision in that context.
And then in that same regard, what is tactical restraint?
Tactical restraint is the idea that sometimes moving forward is not the best tactical approach, that it can create some dangers that are not justified in the situation. So if officers could go into one position that is dangerous or they could stay in a position where they have some relative safety, they have some tactical advantage, tactical restraint would say, well, unless that moving forward and taking the dangerous position is specifically justified, unless there's some compelling reason to do that, you should actually exercise restraint, wait the few more seconds or minutes or whatever it is to maintain that tactical advantage, which might be improving officer safety or public safety or the safety of the subject.
And Professor Stoughton, can you just describe to the jury what is the concept of officer-created jeopardy?
Sure. Officer-created jeopardy is just a phrase that refers to unjustified risk-taking. It's not a magic phrase. It doesn't have any independent meaning. It's a term of art that was developed by the Savannah Police Department in the early 1990s that refers to officers putting themselves into positions where the dangers outweigh the benefits, right? It is a risk-taking behavior that is not justified under the circumstances.
And if someone were to state that that is purely an academic concept and isn't present in peace officer training curriculums, what would your response to that be?
I think that's wildly ill-informed. Tactics made their way into police training when we started formalizing police training in the 1920s. The very earliest records of formalized police training have a discussion of tactics, and tactics are about making professionally appropriate risk balancing decisions, right? About not taking unjustified risk. So we see in the annals of criminology from 1929, a discussion of police tactical training. We see an explosion in police tactical training starting in the 1960s and then really getting into the 1970s with practical work by, among others, NYPD Lieutenant Jim Fife, who developed a whole set of tactical principles in his work at the NYPD to help address an increase in officer-involved shootings. In fact, Jim wrote an essay on the split-second decision-making that he called split-second fallacy, pointing out tactics are what save us from making split-second decisions, right? So we use good tactics to avoid putting ourselves into time-pressured situations where we can't figure out how to respond, so we may have to escalate in a way that if we took a more restrained, a more tactically sound approach, we wouldn't have to at all. Tactics are part of the training of every police academy in the country, including here in Ohio in the basic officer certification program. There's an emphasis on tactics and approach. You don't always see or hear the phrase officer created jeopardy, but that's because the vocabulary is not universal. The concept is certainly universal. In the same way that when we're talking about when officers walk up to a car, a lot of places call that an approach, and some of the Ohio training material refers to it as a walk-up. It's not the vocabulary that's important, it's the concept that that vocabulary is trying to express.
And did you review some Ohio police officer training curriculum materials in the course of this case?
I did, yes. My understanding is they were the materials in play at the time of Officer Grubb's basic recruit training.
And did you observe tactics in there consistent with generally accepted principles and practices?
Yes.
So if not the term officer created jeopardy, are you saying that concepts related to officer created jeopardy are prevalent throughout these officer training curriculums?
Yes.
Yeah, I mean, guys, everything he said, it's a lot of rehashing of what he said at the Kim Potter trial. But yeah, this is a bunch of fucking bullshit. It's all he gets to say, oh, I determine if this was unnecessary or not. And that's obviously that's what he's going to say. And that's what he's going to say here. He is right, though. There were a lot of police massacres. Like, very famous one is in Norco, California. A couple police got murdered at a truck stop, rolling up on a couple of dudes. A lot of police tactics are based off of a couple of times where one or two dudes wiped a whole fucking side. You know, it was like 2-on-5 or 2-on-6, and they all got fucking wiped. So it's not an uncommon thing. It's not an uncommon thing to deal with tactics like that or talk about them. So, that's kind of what they're getting at here.
Absolutely. The idea that officers should use good tactics and that using bad tactics can put officers into unnecessarily dangerous situations, which is why we use good tactics, is ubiquitous in policing.
And what is the generally accepted position in policing on officers placing themselves in front of a vehicle's path of travel?
Don't. It's very straightforward. Vehicles can run you over. They can hit you, they can drag you, and that's a capital B bad thing. So the way to remove that as a possibility is to not move into, and certainly not to remain in, a vehicle's path of travel. Don't be in front of the vehicle, don't be behind the vehicle. Vehicle can't really hurt you if you're standing next to it, so do that.
Is this a topic that has been considered extensively in the realm of policing?
Yes, absolutely. It pops up in training presentations by the Police Executive Research Forum. Going back at least to the late 90s, there's a discussion of officers not standing in front of vehicles. There are articles in police media from 2005, 2006, all through the 2010s about not taking or maintaining a position in a vehicle's path of travel. The basic rationale for all of that is standing in a vehicle's path of travel will typically offer very little in the way of tactical advantage. It might offer some, depending on the situation, but it's typically not going to be much different than the tactical advantages offered by standing next to a car. But it exposes the officer to a substantial amount of tactical risk. Again, vehicles can hit you or drag you or run you over if you're standing in front of them or behind them. So when the risk outweighs the tactical benefits, as a general matter, police tactics would say, don't do that.
Are there any tactical benefits to an officer placing himself in a vehicle path of travel?
There can be, depending on the situation, but it's often pretty modest. There can be some visual benefit. Maybe the officer gets a perspective that they can look into a vehicle that they might, in a way that they might not otherwise be able to. That does have some tactical benefits to it. However, if the officer can look into other windows, whether those windows are open or there are other officers looking in, or the windows are not darkly tinted or mirror tinted or something like that, we can't ignore the fact that we might get the same tactical benefits from a different position, right? It may not be the only way to get that tactical benefit. One of the tactical benefits, I suppose, is communicating to the person in the car, hey, you're not free to leave right now because here I am standing in front of you like a human traffic cone. Again, that might have some tactical benefit, but it's not really distinct from the tactical benefit of telling someone the same information while not standing in front of the car. Minimal tactical benefit, maybe no increase in tactical benefit, and again, exposing officers to a substantial amount of risk. Depending on the situation, there may be some other tactical benefits, but usually they're relatively modest. And there is always a substantial risk of the car moving unless the car is inoperable, right? If the car is inoperable, then it doesn't have a path of travel, so we get the same tactical benefits without those tactical risks.
And how is an officer standing in front of the vehicle, how does that relate to the concept of officer-created jeopardy?
Sure. So again, officer-created jeopardy just referring to unjustified risk-taking, or the idea that the position of an officer has to balance the risks of that position or action against the benefits of that position or action. If an officer steps in front of a vehicle when the tactical risks substantially outweigh the tactical benefits, we'd say that is not justified risk-taking. And the term of art that we might use there is that's an example of officer-created jeopardy. In fact, in the book that I wrote, which is Evaluating Police Use of Force, my co-authors and I use this example exactly as the paradigmatic example of officer-created jeopardy. There was an officer, Kimberly Rasso, who was working off-duty at a mall and investigating a shoplifting incident and stepped in front of a car and ended up shooting the driver when the car moved towards her. And the point is exactly the tactical benefits are pretty limited. Not that there's no goal in stopping that car and apprehending that shoplifter. Of course there is. But the tactical benefits are substantially outweighed by the risk presented to the officer, especially when it's foreseeable that if the car moves forward and the officer says, oh, I'm in danger, and uses deadly force, now we've just shot someone in a shoplifting investigation.
Now, guys, I understand some of you are upset here, but he's trying to say, okay, the car isn't off, but you have to think ahead as an officer. I'm going to stand in front of this. Oh, my God, what happens if they start the car? Then what do I do? So, you're tactical to your list of annoying words. Well, yes, in this situation, 100%. And yes, Anonymous for $2 says the book drop. Yep. Stacy, they're not saying she gets a pass. He's just saying that was unnecessary to get in front of the car. But I agree, and I can't wait for him to hear about explaining about the crossfire and whatnot. But they're arguing he didn't have to do it that way. So that's what they're arguing here.
And Professor Stoughton, what is considered a better position or the generally accepted practice when it comes to approaching a vehicle?
So there are a ton. And again, this is where there are a whole range of reasonable options rather than a specific reasonable option. If officers are trying to maintain visual contact, that is, they're trying to look into the car, and we have two officers, right, where one of them, in this case, Sergeant Moynihan, is standing on the driver's side of the car, it's possible, but maybe not highly beneficial for the two officers to just stand next to each other, right? More tactically beneficial would be a sort of standard traffic stop approach where you have an officer standing on either side of the car. Officers certainly want to avoid the potential for a crossfire situation, but there are a number of ways to do that, including standing in front of what's called the A-pillar, which is that line of metal between the windshield and the driver's window or the windshield and the passenger window, right? If both officers are standing slightly in front of that A-pillar, they still have visual contact from both sides and also are not in a position where, in the event of gunfire, they will be aiming at each other. Same idea, you can have officers standing behind the B-pillar. The B-pillar is the line between the driver's window, the driver's window and the driver's side rear passenger window, or the front passenger window and the back passenger window, right? If officers are stepping back a little bit, they can look into the car, keep the visual, and also not put themselves into a crossfire situation. Or some combination where you have officers not like this, but in sort of a V shape, if that makes sense.
And we talked about the general position of policing on an officer situating himself in front of the vehicle's path of travel. What about the defendant?
Very good point. Very good point.
Himself in front of the vehicle in this particular case.
It's a really bad idea. The tactical benefits are marginal or modest at best, and the tactical risks are substantial.
And Professor Stoughton, if someone were to claim that standing in front of the vehicle was the best tactical position in order to potentially avoid a crossfire, what would you say to that?
Not when you have motorists sort of immediately behind the vehicle in the line between the position in front of the vehicle, the driver of the vehicle, and what's known as policing as the backdrop or the backstop. That is the thing behind your potential target.
And do you have the person marked here in this screenshot?
Yes. So over on the bottom left, you can see the person with the little tag, the mark as motorist. That's a motorist associated with the car that the officers had been helping with just a few minutes ago. You can also see in the sort of yellow top there, I believe that's the Kroger employee. Additional, if minor point, Autoglass does some really weird things to bullet trajectories, so we don't always know where the bullet is going to go after it.
Okay, that's not 100%. Like, we know where it's going roughly. Like, the idea could go any direction. No, it's like the idea is if I'm aiming at you through automotive glass, because of the lamination, but also because of the angle of it. My shot may go high or my shot may go low, but it's not going to go every direction. You generally can I took a class once where we shot through the glass. Basically, it's kind of what you do in Heat. You just start shooting once or twice till you get a hole and you keep going through it. Auto glass is not that big a fucking mystery, especially at this distance. It's going to go right fucking at her.
Strikes, well, anything, but especially not the glass or metal from a car.
And does a tactically sound position approaching a vehicle eliminate the possibility that the vehicle could even be perceived as a threat?
Yes. If you remain to the side of the vehicle cannot run you over. It lacks what we refer to as the opportunity to be used as a weapon against the officers.
And is the goal of tactics to conclude a situation in the safest possible way?
Yes, to try and achieve the police goal in a way that appropriately balances public safety, officer safety, and the safety of the subject with whom officers are interacting. To do so in what is hopefully the safest and least intrusive way.
And what is the generally accepted position in policing about how far officers should go in order to investigate a crime or apprehend a subject?
So it very much depends on the situation. I know I'm going to sound a little bit like a broken record, but the ultimate question is, are the costs worth the benefits, right? Especially keeping in mind that when officers are doing some kind of field investigation, there are different risks that officers may be worried about. One of the risks is being run over by a car. Another of the risks is the person that officers are investigating getting away. If we look at that, the risk of getting away, we want to stop that, right? If someone is going to be investigated or arrested for an incident, whatever criminal incident that is, that's certainly a police priority. But just like every other police priority, it's not a priority that we expect or want officers to pursue at all costs. They have to do so in a professionally appropriate way. And just because in a situation like this, just because a motorist does leave does not end an investigation. It's really a false choice to say officers either have to put themselves in life-threatening danger or they lose any ability to investigate this incident at all. Most shoplifting incidents are investigations that officers conduct after the suspected shoplifter leaves. So you use security camera footage or witness testimony to identify who your offender is, and you go and get a warrant in a normal investigative process. Like the jaywalker, the choice of do I just let him get away or do I create extreme danger to myself? There's kind of only one professionally appropriate answer to that question. But unlike that jaywalker hypothetical, it doesn't end with just letting them get away, right? It's not a police endorsement of the underlying activity to do an investigation that will result in a later apprehension. So we should specify that the risk of getting away isn't the risk of getting away scot-free and never getting caught. It's just the risk typically of delayed apprehension after investigation.
And is policing in developing generally accepted practices and principles, does it incorporate cases from the United States Supreme Court?
Yes, policing, so the standard that I'm applying is this generally accepted principles or practices in policing. Policing as an industry is certainly responsive to law. That is, principles from some of the seminal use of force cases by the Supreme Court have been incorporated into those generally accepted practices.
And has the Supreme Court spoken to this concept of weighing the balances against when to continue trying to investigate or apprehend someone?
It has. So in a 1985 case called Tennessee v. Garner, the officer in that case was investigating a reported home burglary, saw the burglary suspect fleeing from the house and starting to climb a fence, and knew at the time, if this guy jumps the fence, I'm not going to catch him. He is going to get away. And potentially, especially maybe given the state of investigative techniques and technology at the time, if he gets away, he's going to really get away, right? There's unlikely to be a later apprehension. In that case, the officer shot and killed Edward Garner, and the Supreme Court said that was unconstitutional. And their line in balancing that you're asking about is, it is not better that all felons die than that they escape. That is, sometimes in balance, to avoid killing someone, we just don't solve the crime at all. Now, again, that's a very different situation here where we have at least a witness standing by to provide information and video.
And my next question was going to be, in this case, had Ms. Young left, were there other investigative avenues that still could have been pursued?
Yes, absolutely. It does not mean for sure that they would have identified her and been able to apprehend her later. But yes, there was a professionally reasonable likelihood of being able to do exactly that.
How
does this particular case illustrate why policing has the generally accepted position on standing in front of vehicles that it does?
I believe it's actually an excellent example of why that principle exists, right? Why we have the practical guidance to not stand in front of vehicles, to reflect some of the points made in those 2005, 2006 articles that I mentioned. The human body is not going to win that interaction, right? You are not going to be able to stop the mass and power of a vehicle. Knowing that you can't actually have that effect, why would you put yourself in the position of being exposed to that degree of danger? Just stay out of the way and you can approach the situation a little more safely.
And What would you say to an explanation that it was done either to convey to Ms. Young that she wasn't free to leave, or to be able to see into the vehicle?
Sure, and as I mentioned, both of those provide some tactical benefit. But when you already have one officer who's telling someone that they are not free to leave, standing in front of the vehicle doesn't add very much to that information, right? It's not like she was unaware of that until someone stood in front of the vehicle.
Your Honor.
Please. You can approach.
Thank you, Your Honor.
Let's see where this garbage goes. Come on.
Testify as to what he and Young was aware of and those kind of things.
Yes, Your Honor. I apologize. That was inartfully said. What I should have, and the way.
Is there a question being asked?
You can ask a question.
I would say, was that information already being communicated to her?
Yes, and an officer applying generally accepted principles would certainly be aware that that information was being communicated.
Objection, Your Honor.
And Professor Scobie, is your opinion in number one, is that to a reasonable degree of professional certainty?
It is, yes.
And now moving to what is your second opinion?
The second opinion focuses on the decisions to draw the firearm and to use deadly force rather than remove oneself, Officer Grubb removing himself from that position in front of the vehicle.
And in policing, to unpack that, in policing, when is an officer permitted to use some force?
So any amount of force, right? The goal of any amount of force is to address the threat presented by a subject's actions. Officers have a particular set of goals. They might depend on the situation, right? But it might be to stop someone, to investigate them. It might be to conduct a search. It might be to arrest someone. It might be to protect property, protect someone from being injured, etc. When someone's actions present a threat to one of those police goals, the officer can use force to address that threat. Policing defines threat in a fairly particular way. That is, a threat exists or a threat is imminent when the officer would reasonably perceive in that situation that the subject has the ability and the opportunity and the apparent intention to cause whatever type of harm we're worried about. Ability here really refers to physical capacity. Someone with a knife has the physical capacity to stab an officer to cause that kind of serious bodily injury. Opportunity refers to whether someone is vulnerable to that particular type of harm. So someone might have a knife and have the physical ability, but if they're 60 feet away, they do not have the opportunity to inflict the stabby stabs that we're worried about with that knife, right? Intention is exactly what it sounds like. Can we tell from the person's actions that it looks like they might want to inflict that particular type of harm? So someone who has a knife, who is within arm's reach of an officer, but they're chatting about burglaries in the neighborhood while the person is cutting up carrots for dinner, has the ability and opportunity, but not the apparent intention to use the weapon. All three of those components are necessary to establish a threat, because in the absence of any one of those, we have the potential for threat. We have what's referred to as risk. And officers have to deal with risk all the time. Every scene that they drive up to, someone could potentially have a gun, right? So we use tactics to manage risk, and the use of force is appropriate when the person presents a threat or an imminent threat of some particular type of harm.
And so what are, under generally accepted practices, what are the steps in evaluating a use of force?
So the first is to look to see whether the officer has a...
Chat, the way you could think about this is they had ability, the 3-letter acronym for this is AIM. Ability, immediacy, and they had a method. So were they able to inflict harm on you? As he said, I have a knife. Well, am I immediately able to do it? Okay, I'm able to do it. I'm nearby. And do I have a method that can harm you? Well, a knife isn't a problem 100 feet away, but a gun is. So they are things here. They are there. So he is getting at these basic principles here. Reddit expert. Yes, well, he is basically. Yeah, the stabby stab thing is very Reddit-y, but whatever. He's probably a millennial or some gay Gen Xer.
Sort of legitimate police goal. Are they trying to do something that they're allowed to do? The second is, okay, if the police have some legitimate police goal, are the person's actions, is that in that circumstance, do they present some threat to that police goal? Are they going to delay or defeat the officer's attempt to investigate or apprehend? Are they going to injure someone, including the officer themselves, right? Once we identify that there is an imminent threat to some legitimate police interest, then we can say, okay, some amount of force may be justified here. It does not mean that any amount of force is justified, because the next question would be, if some amount of force is potentially justified, is the nature and severity of the force used appropriate or proportional to the nature and severity of the threat being presented? And this is sort of a sliding scale of severity, right? The more severe the threat, the more serious force officers can use.
And we've touched on this a bit, but what are the operative facts to be considered in evaluating the use of force?
So when you're talking about the operative facts, we really mean how should we understand that situation, right? Particularly if there are disputes about what the facts are. And the operative facts are the information that was reasonably available to the officer at the time. That is, if we take the actual officer and we pluck them out of the situation and we drop into the situation this sort of construct that we call the reasonable officer, what would the reasonable officer at the time have perceived and concluded?
And has policing also incorporated Supreme Court case law when it comes to the generally accepted practice in evaluating use of force?
Yes, absolutely. The idea of using that hypothetical reasonable officer as a construct, of using the facts as known to the reasonable officer at the time, that predated the Supreme Court, but the Supreme Court adopted exactly that framework in a 1989 case, Graham v. Connor, and policing adopted that same framework.
And so does that framework, considering use of force from the perspective of an objectively reasonable officer, does that take into account specialized training, education, and experience that an officer would have that they maybe would not?
It does, yes. The idea is what the officer would perceive and conclude, keeping in mind that officers may perceive things differently and may conclude things differently than non-officers. For example, a non-officer might view a particular interaction and say, oh, that's a weird little handshake. And an officer, on the basis of their training experience, might say that was actually a hand-to-hand drug transaction. But the reason that I know that as an officer is because of my training and experience as an officer. So we do use this framework not of the generically reasonable person, but the reasonable officer in that situation.
And Professor Stone, in this case, in evaluating the use of force, how do you identify the severity of the use of force?
So in this case, it's actually very simple because we have the discharge of a firearm, and that is deadly force. Deadly force is any application of force that is substantially likely to result in serious bodily injury or death. Discharging a firearm certainly fits.
And is it generally accepted in policing that an officer can only use force if there's some type of imminent threat?
Yes.
And I think you actually answered in in part of one of your answers, when is a threat imminent?
A threat is imminent when we have that ability, opportunity, and intention. The way to think about that is it does not require someone to be actually stabbing an officer already. It doesn't require the person to have pulled the trigger on the gun. The officer is allowed to intervene and use force to prevent that from happening, but the person still has to have and display the ability, the opportunity, and the apparent intention to do that thing, right? So if we go back to the knife example, someone who's sitting in the living room talking with the officer and there's a knife across the room does not at that point have the ability. That is the ability to stab the officer. On the other hand, if they bolt for the knife and grab it, that's a pretty good indication that they now have the ability and potentially the intention to use that knife in the context of that situation.
And what is, I think you also touched on this, but what is a risk as opposed to a threat?
Risk is just the presence of any one of those characteristics, ability or opportunity or intention, but not all three. And officers, one of my favorite quotes about this is officers operate in risk soup. They're constantly surrounded by risks, which is why it's so important to use tactics to manage those risks and to prevent those risks from becoming threats, because threats are what give rise to actual harm.
And in determining whether or not a threat is imminent in policing, does that depend on the facts and circumstances of each particular case?
Yes, very much so.
And is that both from the United States Supreme Court and incorporated into the world of policing?
Yes.
And in evaluating the use of force, what portion of the encounter is reviewed?
All of it. You want to look at everything that led up to or potentially contributed to that use of force. Obviously, the subject's actions, because that's where we get our nature of resistance and threat, and also the actions of officers or potentially even bystanders that may have contributed to that.
So does evaluating the reasonableness of a use of force incident, does that involve evaluating decision-making from the beginning of the interaction to the end?
Yes, it certainly should.
Carmen, how are you doing?
Anytime.
Let's see. Approach.
All right, chat. We're gonna take another break here. We're still getting to the. This is still the bullshit, but here we go.
Of the interaction. In policing, when evaluating the use of force, what part or what portion of the interaction are we supposed to review?
The phrase that's typically used is totality of the circumstances. Totality of the circumstances review. We look at all of the contributing events that led up to it, the subject's actions, the officer, the entire set of circumstances.
So, are an officer's decisions and actions leading up to a use of force considered in determining the reasonableness of the use of force?
They can certainly be relevant, yes.
And did the Supreme Court actually recently speak to whether or not the entire encounter should be reviewed when determining the reasonableness of the use of force?
It did. In, I think, April, the court released an opinion in a case called Barnes v. Felix. So Barnes v. Felix addressed a Fifth Circuit, United States Court of Appeals for the Fifth Circuit rule called the moment of threat doctrine. And in that approach, the Fifth Circuit and one or two other federal circuits looked only at the time the officer used force or the moment immediately before that, right? The time when the officer pulled the trigger or the second or two just before that. The idea was that in the Fourth Amendment context, it was appropriate only to look at the moment of threat. And the Supreme Court reaffirmed its earlier decision in the 1989 case, Graham v. Connor, and said, no, in Barnes v. Felix, we do have to look at the totality of the circumstances. We cannot, the court said something like, put on temporal blinders by artificially drawing the line. The court did not identify, in the Fourth Amendment context, the degree to which an officer's actions were dispositive, that is, the degree to which an officer's actions would make a use of force reasonable or unreasonable. But it said pretty clearly, we look at the totality of the circumstances without looking only at the split second in which force is used.
And Professor Snowden, could you explain your analysis in arriving at your opinion that the defendant's decision to draw his firearm and use deadly force instead of removing himself from the vehicle's path of travel was unreasonable and inconsistent with generally accepted police practices?
Sure. So opinion one is really about Officer Grubb's decision to put himself into the position in front of the vehicle. Opinion two is sort of taking as true that he has taken this position in sort of dead center in front of that vehicle. Now what? The idea in police tactics and the use of force is we want to use tactics or force in a way that will address the threat presented by the subject's actions. One way to address that threat is potentially to use force in a way that will remove the subject's ability or opportunity or intention to cause whatever type of harm we're worried about. That is, to take away the threat. Another way to address those situations is to use tactics that can do the same thing. So when we're talking about someone who is in front of a vehicle, stepping out of the path of travel of that vehicle removes not the ability or maybe even the intention, but it certainly removes the opportunity. That is, the vehicle cannot travel sideways. So if you step out of the vehicle's path of travel, there is no more threat anymore. In this case, we see Miss Young sort of turn her steering wheel to the right, sort of just after that, where Officer Grubb draws his firearm. At that point, if we're anticipating the potential for there to be a deadly threat, right, for the situation to evolve in a way where there is the ability and opportunity and intention to use the vehicle as a weapon in a way that could inflict serious bodily injury or death, instead of drawing the firearm and standing there, get out of the way. Officer Grubb was in front of the car, by my count, a little over 10 seconds and more than 4 seconds after drawing his firearm. So there's ample opportunity to, either instead of or in addition to drawing his firearm, get out of the way of the vehicle rather than wait until the vehicle moves forward and then employ deadly force to address that threat.
Professor Stewart, in your report, did you do a timing analysis of when exactly the different events took place during the entire interaction?
I did, yes.
Could you describe what we're looking at here in this diagram?
Yes, so this is a timing chart. And all of the times in that second column where it says approximately synchronized video, that is the runtime for the approximately synchronized video. That is all three videos put together. So I'm identifying specific events using that as the runtime instead of the various videos that make up that synchronized video. The event column specifies what happens, and that the second column, approximately synchronized video, identifies when it happens. The next three columns are lapsed time. That is how much time has passed. The third column, the one that says lapsed time from previous event, just calculates the amount of time between whatever line it's on and the one immediately before it. So it's just counting up the amount of time between row 1 and 2, between row 2 and 3, not in a cumulative way, just individually. The fourth column, total lapsed time from Officer Grubb stepping in front of.
Yeah, and that's the thing. I'm assuming the defense attorneys are going to point out, like, You're pointing it down to a point of a time we can't even comprehend or be aware of as mortal human beings. We can't fathom a thousandth of a second.
The vehicle starts with event 2. Officer Grubb takes a position near the center of the front bumper and counts the total amount of time that Officer Grubb was in front of the vehicle. The 5th column, total lapsed time from Officer Grubb drawing his firearm, starts about halfway down the row that says Officer Grubb draws his firearm, and then counts the amount of time in those other events from the time when he drew his firearm. That is, how long between he drew his firearm until the time that the shot was actually fired.
Based on your analysis, how much time was it total between when the defendant first situated himself in front of the vehicle to when the shot was fired?
10.467 seconds, almost 10 and a half seconds.
And how much time was it from when Takaya first inched her vehicle forward to when the time the shot was fired?
So the first inching of the vehicle is about 3.5 seconds. And the way that I'm getting that is I'm looking at Miss Young's vehicle moves forward and then going down to Officer Grubb fired.
And then how much time was it between when the defendant first drew his firearm and when he fired?
4.334 seconds. That's that last number all the way on the bottom right.
And how much time between when Takaya is first seen turning her steering wheel to the right and when he fires?
So that is right about just over 5 seconds, 5.033 seconds. And what I'm doing there is looking at the second column, going to the third number down, 14:10:966, and then going down to 14:16:1.
And Professor Stone, based on your timing analysis and your review of the case, what is your opinion?
There was ample time for Officer Grubb to remove himself from the front of that vehicle. Again, even assuming that he put himself there, right, ignoring that piece, there was ample time for him to remove himself from the vehicle, starting at the time he put himself in front of the vehicle. But even looking at when Miss Young rotated the wheel, when Officer Grubb drew his firearm, and sort of subsequent events, there's ample time to take the couple of steps that might have been necessary to get out of the path of travel of that vehicle.
And Professor Stone, what is the generally accepted position on shooting at a moving vehicle?
Yeah, so that's a good question. Generally in policing now, officers are instructed to not fire at a moving vehicle when the vehicle itself is the weapon. That is, we're not talking about someone who's shooting from a vehicle. We're talking about the vehicle itself is being used as the weapon in most circumstances. Small caveat, there is developing an exception for when the vehicle is apparently being used as a weapon in a potential mass casualty event, like driving into a crowd or something like that. But outside of that circumstance, officers are generally taught to not shoot at a vehicle when the vehicle itself is the only weapon, because shooting at a vehicle is highly unlikely to actually have the desired effect of addressing the threat presented by the moving vehicle. That is, if you shoot at the driver and miss, or you shoot and just injure the driver now has additional motivation to get the hell out of there. If you shoot and disable the driver of a moving vehicle, that is, let's say you instantly incapacitate them, you've now just created an unguided missile. You haven't stopped the vehicle. There's no way physically for the little tiny mass of a bullet to arrest the momentum of a vehicle. So you haven't actually addressed the threat presented by the moving vehicle, and you may have made the situation dangerous by incapacitating someone who would be able to drive that vehicle.
If a person is right in front of a moving vehicle, is shooting the driver likely to prevent the vehicle from hitting that person?
No.
And does this case illustrate the possibility of then an uncontrolled moving vehicle being the result?
Yeah, the vehicle kept moving after the shooting here. The vehicle kept moving and crashed, and that is the risk, or that is one of the main risks of shooting at a moving vehicle, where, again, if incapacitated, the driver has just lost the ability to avoid the proverbial lady with the stroller that they would have otherwise avoided.
And is there a concern about how bullets interact with hitting vehicles or the windows of vehicles?
Yes, I mentioned earlier, kind of any object has the potential to throw off bullet trajectories, right, to create ricochets. That's especially well known with auto glass. That's especially true with auto glass. Like, we can't predict with a great deal of precision where bullets that hit glass are going to go.
And Professor Stoughton, is this generally accepted principle that shooting at motor vehicles is rarely effective? Is that frequently reflected in peace officer curriculums?
Yes, training, often in policy statements, yes.
And is there a time, according to generally accepted practice and principles, where it would be deemed reasonable to shoot at a motor vehicle?
Yes, absolutely. So one example would be when it's not the vehicle itself that's being used as the weapon, but instead someone in the vehicle is using a weapon that has to be addressed through the use of deadly force. Someone in the car, for example, is shooting at officers or others. I already mentioned the potential for a vehicle in a mass casualty event. The other possibility is when there is no feasible option to address the threat of being hit by the moving vehicle. And maybe the clearest example of this is an officer who's standing in a narrow alleyway between buildings and the vehicle is coming at them. There is no opportunity. Excuse me, I should say that differently. There is no chance for the officer to reposition in a way that deprives the person of the opportunity to hit them, right? They remain vulnerable to being hit. In that situation, shooting the vehicle is still not likely to actually stop the vehicle. It's still not likely to be effective, but it's the best option that we have under the circumstances. So it's not likely to be effective, but it is more likely to be effective than doing nothing at all. So in that sort of limited situation, and the way that we see this in most policy guidance is directives for officers to not shoot at moving vehicles unless there is no feasible alternative to doing so, no way to get out of in front of the vehicle.
I have no further questions. Thank you, Your Honor.
Ladies and gentlemen, we're going to take a 5 to 10 minute break. Do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it's finally submitted.
All right.
Damn it, no breaks for us. Here we go, chat. Another break. Here we go. I hope she fucking tears him a new one. This has been so garbage already. This has been so absolutely awful. Yeah, none of these things happen. I agree. Is this guy's name? Well, actually, pretty much. Pretty much that's his name. Really. Chugi Show real quick says, late because I was researching whether or not to do makeup tutorials or stick with trial coverage. I mean, yeah. You know, I could start covering the Devin Michaels trial because apparently that one still hasn't been covered. So, Maddie B for $2 says, rip Erica. EDW says, rip Erica. Johan says, rip Erica. We hardly knew ye. Maddie B says, rip Sandwich Man. You'll live on in our hearts. EDWR says, rip Stream. EDWR says, F in the chat for Erica. And then BobTube for $2 said, so he's a younger, smarter, hotter Bronca. Yes. Everything is fine over here. Says he is no crash daddy. Very true. Very true. And yes, Brad, yes, this guy is presented to the Super Lawyers Conference. That's how important he is. Wouldn't surprise me at this point. And I agree, Will Makita. He could get pinched in between the cars, and that'll fucking cripple you. That's dangerous to be stuck between cars like that. Potentially fatal. So, Cross is going to be good, though. Here we go. Here we go.
May I proceed?
Okay.
Mr. Stone, I want to start off where Mr. Glennon left off. May I have the computer, Ms. Cook? Your second opinion there, the one that talks about instead of removing himself from the vehicle's path of travel, you indicated to the ladies and gentlemen of the jury that that was the preferred tactic, that was the better reasonable tactic in order for Connor to avoid being hit by the car, correct?
Yes.
Now, sir, you remember back in 2024 and 2025 when I sent you the seminal case here in the state of Ohio called State versus White, correct?
Yes.
Okay. And you would recognize that decision if I sent it, or if I showed it to you in court today, right?
Sure.
May I approach the witness, Your Honor?
Okay.
So this is the decision of State versus White that I sent you, correct?
Yes.
May I have it back?
Yes.
Thank you so much. May I have the Elmo, Your Honor?
Ms. Cook, about that.
Oh, I apologize. Thank you, Ms. Cook. Okay. So as you stated, this is the law here in the state of Ohio, right?
Yes.
And did you review this before coming in to testify to court today?
I have reviewed it a couple of times. I'm not here to apply Ohio state law, so
I'm not asking that.
specifically for this.
So you didn't review this?
That's not what I said.
Okay, I apologize. I must
I have reviewed it a couple of times, not specifically for this.
Get her.
You've reviewed it a couple of times, but just not for this case.
Yes.
Okay. Can you read this head note for us, sir, starting with, actually just read the whole entire head note. Starting with Graham's prohibition.
Sure. So head note 17, law enforcement officials, excessive force. Graham's prohibition from using the 2020 vision of hindsight.
remember, chat, you can do this because he's an expert, so he can do from learned treaties. This is actually out of Westlaw, and you can see because these are head notes. Actually, I think it's out of LexisNexis here. Yeah, this is out of Lexis. This is the fancy Lexis. But yeah, he's, remember, he's also a lawyer and a law professor. So it's even like double whammy on shit here. He's getting hammered hard. Yes. Suffer, bish. Suffer. And then, real quick, another one. Getting 5 subs, chat. That gets us in a woo tonight. Chat, getting a woo. So let's keep going. Thank you for your support, your generosity. Is he a non-practicing lawyer? I mean, yes, but he's still, yeah. Michael Gelke saying, why is Ohio law not relevant? Well, that's a whole nother issue. He's talking in generalities because Ohio law would not support him. So that's why he's not talking about Ohio law. Because he'll look like a bitch. Wait, why is this muted? Oh, here we go.
Into the prohibited territory of second guessing and armchair reflection. This includes comparative speculation, couched in backward-looking terms, about what an officer could have done or might have done differently, or whether he should have employed alternate or lesser means of force or different tactics.
Thank you, Professor. It says or different tactics, correct?
Yes.
Now, redirecting you back to the computer with back to your opinion. Your second opinion is that he should have used a different tactic to get out of the way of the vehicle. That's what you just testified on direct examination to these ladies and gentlemen of the jury, right?
Yes. That his tactic of remaining in front of the vehicle and drawing his firearm was professionally inappropriate. Yes.
But the law says that what an officer could have done, might have done, or whether he should have employed different tactics is comparative speculation. That's what the quote that you just read to the ladies and gentlemen of the jury said.
Sure, and I will leave it gracefully to the judge to instruct the jury on what the law is. I'm not here to apply Ohio state law. I'm not an expert in Ohio state law. I'm an expert in generally accepted police practices.
It's kind of important, though.
Ohio state law differs from my focus as a policing expert. That's kind of up to somebody else to figure out, not me.
So you testified on direct examination, though, that generally accepted police practices certainly come from state law, correct?
I would say that they are typically informed by a combination of law. My specific testimony was about Fourth Amendment law, but state law should also inform generally accepted practices in that jurisdiction.
And so you're an expert here in the state of Ohio, and you don't know what the state of Ohio's laws say?
That's not what I said.
I'm asking.
About what?
About looking backwards, about using hindsight in order to determine if an officer should or should not use a different tactic.
Yes.
Okay.
I'm familiar with the case and just read a head note, which of course is not the text of the case, it's the head note.
Do you need some time to read the entirety of the case, sir?
No.
Okay.
Oh my God.
Now, you're not a practicing lawyer, correct?
That's correct.
A practicing lawyer is someone who passes the bar, right?
Well, that's a necessary prerequisite. I've done that.
Okay.
Fuck you,
So
Nick.
just choose-
Rosita, wow.
You choose not to practice. You're not acting now.
Correct.
Now, either way, you've certainly spent a lot of time in the courtroom before, right?
Sure. I think that might depend on how we define a lot, but sure.
You testified in over 15 cases. I think you said on direct examination, 18 to 22 cases.
Yeah, something like that, plus more in depositions and the like, yes.
So you've been in the courtroom a lot, right?
Yeah, sure.
And based on your experience of being in the courtroom, you know it's my job as the practicing lawyer to ask questions, right?
Yes.
And it's your job as a paid opinion witness to answer those questions. True?
As a witness generally, sure.
Sure. Now, if I ask a question that you don't understand, do you promise to let me know so I may ask a better, more clear question?
Sure.
Thank you so much. And do you agree to answer my questions in the way that I ask them rather than another question that's not being asked?
I'm sorry. If you're asking me if I can answer your questions, sure. If I understand the question, I will answer the question that I understand you to be asking.
Sure, and if you don't understand, you'll let me know.
Yes.
And you'll answer the question as I pose it to you, yes?
Sure, unless the answer would be manifestly misleading of some part of my testimony or opinions.
What a bitch.
Sure, you can answer my question though, yes?
I hope so.
I hope so too, sir. And if you answer a question I didn't ask you, that will force me to re-ask you the original question, and that would waste everyone's time, won't it?
Probably.
So if I asked you what state you're in today as you're sitting here testifying about what a police officer did here in this state, how would you answer that?
I am currently in the state of Ohio.
Thank you, sir. Now, you went over this on direct examination.
I love
about,
this.
You being paid to offer an opinion, correct?
I'm compensated for my time. I'm not paid for my opinions.
Well, certainly fair to say that if you didn't give these guys the opinion that they wanted, you wouldn't be on the stand testifying.
I've used that
Yeah,
before.
that's probably correct.
Okay, so you gave them the opinion that they wanted, and now you're here testifying.
No, I gave them the opinion that my review led to. The fact that it's helpful to them is irrelevant to me.
Okay. So fair to say that prosecutors work for the taxpayers
Sure.
and were
I would
hired.
I would say broader than just taxpayers, right? They work for the public generally, regardless of whether they're taxpayers or not.
Sure, but certainly taxpayers are included in that.
Yeah.
Okay. And you were hired by the prosecution, right?
Yes.
Okay, so taxpayers fund the state of Ohio's budget, yes?
Yes.
And so you would agree with me then that the taxpayers are paying you $415 an hour to evaluate this case, yes?
Sure. Through an attenuated series. Sure.
And I think you testified on direct examination, you believe you spent maybe 30 to 35 hours that you have billed the state of Ohio?
I think that's right. I'd have to look at the invoices on this case to confirm that, but I think that's about right.
It's just an estimate, 30 to 35 hours?
Yeah, probably something there.
Okay. So at 30 hours and $415 an hour, the conservative estimate is you've billed about $12,450 to date, yes?
Sure. That sounds about right mathematically.
And if it were 35 hours, you would have billed $14,525.
I cannot do that math in my head, but sure, that sounds about right.
And you're testifying today, you've been on the stand for over 2 hours, but you bill for 8 hours of testimony no matter how long you're on the stand. Is that correct?
I bill at a minimum rate of 8 hours on days of testimony. Today I'll be traveling as well, so it'll be more than 8 hours today between testimony, the actual hours of testimony and travel.
Okay, so more than 8 hours. About how many do you think you'll bill for today?
I don't know. It depends on when we end and how much downtime I have between like getting to the airport and getting home.
That makes sense. But let's just call it 8 hours for conservative purposes, knowing
Sure.
that you're going to bill more than that. So that's an additional $3,320, true?
Yes, plus travel yesterday.
Thank you. And all of us think about work while we're doing other things like doing laundry or driving. Would you agree with that?
I try really hard not to think about work when I'm doing other things.
That's fair.
Um,
But certainly it creeps in, right?
It can.
Do you think that you probably have spent time that you haven't billed for, in addition to the time that you have billed for thinking about this case?
Sure. I'm sure there were like short phone conversations here or there, or like things like that, where it wasn't just thinking about the case. It was like actually working, and I just don't bother to bill because it's not worth it.
So fair to say total at the end of all of this, you'll probably have put at least probably close to 40 hours into this case?
Sure. That seems fair.
And while you were preparing your report to form your opinion, how many different angles of the incident did you review?
So there are 3 different cameras of the incident itself that best capture the incident. There are more security cameras from Kroger that informed the angles, but not to the degree that they actually captured a lot of relevant information.
Did you review that camera though also?
Yeah, I reviewed all of the videos that I have.
So you would agree with me then you've at least reviewed 4 angles. The RX video walk-up.
Yep.
The Kroger security camera footage.
The outside one, yes.
Grubb's body-worn camera.
Oh, yes.
And Moynihan's body-worn camera.
Yes.
So you reviewed 4 different angles before coming to your conclusion, correct?
At least that. I think there are actually more, but it's at least that many, yes.
Now, you know a lot about body-worn cameras, right?
Yes,
And you would agree with me when I say that these cameras can sometimes be outright misleading, yes?
absolutely.
Now, it's possible, sir, that some opinion witnesses in court cases bring biases with them into their work, right?
Sure.
In fact, you would agree with me that certainly everyone has certain biases that color their interpretation of the world around them, true?
Sure. That is the nature of the human experience and cognitive bias, yes.
And an opinion witness with a very strong bias could use his platform to unfairly affect a jury. You would agree with that, right?
So, no, I think you're confusing their bias and advocacy. You can separate those. A witness who's biased may affect their conclusions. Regardless of bias, a witness could inappropriately engage in advocacy, but those 2 things aren't necessarily related.
So is it your testimony today that a very strong biased opinion witness could not use his platform to attempt to unfairly affect a jury?
No, I just think those are separate things. Like that doesn't have to be the result of bias.
Okay, so that's not my question. I'm asking you particularly with respect to bias. Do you think that opinion witnesses can come in here and unfairly affect a jury with their biases?
Can you define what you mean by unfairly, right? Because the point of the adversarial system and a judge's instructions for limitations should address that unfairly point.
Correct.
If a trial is being well managed, then no, it wouldn't be unfair. It would be within the scope of a trial. If it's not, then sure, I suppose that could be unfair in some way, but it might depend on what you mean by unfair.
You're aware that the judge is going to give this jury an instruction saying, do not let your biases creep into the back of the jury room.
I am not going to presume to guess anything about the judge's instructions to the jury, but that would be a pretty standard instruction.
You would agree with that? right?
Yes.
And so if a witness comes in here with bias, you're saying that that bias can't have somehow bleed into the jury deliberating.
No, I guess I'm confused when you're focusing on unfair bias, right? The point of the adversarial system is to address the limits of unfair bias and to prevent a witness's, let's say, unfair statements, right, from being considered or adopted in the jury room.
And our system is perfect?
Hardly that.
Okay. So it's possible then that biases could affect what is presented on the witness stand, correct?
Oh, sure. Yeah, I agree with that.
Thank you. Do you have a copy of your CV up there, just in case?
I do not.
Okay. Would you like a copy of your CV? Because we're going to talk about the cases that you've testified in that trial.
Sure.
May I please witness, Your Honor? This is a copy of your CV, Mr. Stone. I tabbed in green where you start with your case citations.
Okay.
Okay. So, I'll let you get there. So,
All
for
right.
police use of force cases where you've actually testified and given trial testimony, like you are doing today.
Sure.
Let's start naming the cases in which you've given an opinion that stated that the police officer's actions were contrary to generally accepted police practices. Go ahead.
In trial testimony.
Yes, sir. In trial testimony.
Okay. So the first one, this is an older version of my CV. The first one is People v. Sean Grayson.
You said Grayson?
Grayson, yes. Grayson.
Okay.
Trial testimony.
Yes, sir.
The Christian Glass case in Colorado. I'm sorry?
I'm sorry. I said what others?
Taylor in Texas. Mead. Nigro, Nigro.
You can't say that word.
Glass on the civil side. Herndon, Herndon. Schurr, Schurr. Potter. Chauvin.
There we
Court.
go. Potter and Chauvin.
Jones. Rhines, Rhines. Rhines. Smith. Calmer, Calmer.
And that's one where the defendant shot and killed 2 police officers, true?
No, he shot and killed 1 officer.
Okay. But he shot at 2 police officers?
I don't know, but there were 2 police officers there. I don't think he shot at more than the one.
Okay. So he killed a police officer?
He did.
Okay.
That's what I have.
What about Grayson, sir?
That's the top one on there.
Oh, I apologize. I'm so sorry. Norton? Did you testify in the Norton case?
I did, not with an opinion finding fault with the officers, which is what you asked about.
So these are all the opinions that you testified in for a finding fault with the officer, true?
No, I understood your question to be, these are the cases in which I've testified at trial, in which I've had an opinion finding fault with the officers.
That's correct, sir. That's what I asked.
Yes.
Okay, so how many, going through your CV, have you testified in trial, given trial testimony, that you found not at fault with the officers?
Almost all of those cases also have opinions where the officers did things appropriately.
Sir, we're talking about your overall general opinion. When have you testified in trial on behalf of a police officer?
You mean without finding any fault at all with the police officer?
Sir, that the police officer hired
he
you
wore his shoes
Oh,
right.
well-
Good job.
in trial.
Okay, so you're asking about cases where I've been retained by whoever is representing the officer, and I've testified in trial without any opinions negative to the officer? Is that what you're asking?
Yes.
That's a series of limiting considerations. Let's see. I don't think all of those conditions have lined up. I don't think I've done any cases where all of those things are true and nothing else.
Thank you, sir. Now, you teach law students, true?
Yes.
Are you aware of a national website called Rate My Professor?
I have heard of it.
Okay. And these law students that you teach, oh dear. There we go. These law students that you teach certainly spend a ton of time with you, true?
I would object at this point. The state hasn't seen this, isn't familiar with it.
Oh,
Yes, my
About
students spend,
questioning him.
probably more time than they want with me.
How many credit hours do you teach?
I have criminal law is 3 credits this semester. Criminal procedure is 3 credits. My police law and policy class is 3 credits. Regulation of vice students can take as either 2 or 3 credits. I also supervise legal research projects.
And so for the credits that they spend, they have to spend X amount of hours, or in order to achieve those credits, they have to spend X amount of hours with you. You would agree with that, right?
Yeah, I think the ABA actually regulates by minutes, but yes.
Would you be surprised that at least one of your law students believes that you're not an expert in police self-defense?
I would be surprised if we could identify that anyone who rated me on Rate My Professors is one of my students. There's no verification.
Well, actually, so there is a verification. Are you aware of that verification?
Oh no, buddy, brother.
Yes, in some sense, but no,
Okay.
not specifically.
That's fine. One of your students here says it's difficult to understand how someone who had only worked as a police officer for 5 years could be considered an expert in the area. As the saying goes, those who can do, those who teach can't. That's true, right?
Which part?
That's what it says. Yes?
Yeah, that's what it says. I don't know what SCHC 38 is. That's not a class I teach.
So that's not what I asked you. That's what that.
That is what someone's anonymous comment says on the internet. Yes.
Okay. Well, it certainly says that you worked for a police officer for 5 years, right?
Sure.
That's an intimate detail about you. True?
No, that's widely available on like the internet all over the place,
Okay. So
including on my faculty bio. I don't talk about that in class.
okay, you don't talk about that in class.
No.
Okay, that's fair. Let's see here. Professor Snowden is a politically charged narcissist. That's what this review says.
Your
True?
Honor, I would object again. These are just random comments found on the internet by unidentified people. This is not.
I don't know about that. Suffer.
Thank you, Your Honor. That's what that says?
That is what it says. And Laws 672 is a class that I teach.
Okay.
I think.
All right, this next one says, made memes of himself to try to appear hip, shoehorns his personal politics into every discussion. Very unprofessional, right?
That's what it says. I can tell you I have never made a meme of myself, although sometimes students will make memes of me and pass it around.
And this says it was reviewed April 12th of 2021,
I'm sure all
right?
the cringes and
That's
gayest
when it was
memes
submitted,
ever.
yes. So that's, it also says A+, and that's not a grade that we can assign at my school. So I don't know who's, like, that's just not accurate.
Again, sir, I'm not asking you who wrote this review or anything
That's
like that. I'm just
good. I have
asking
no
you.
idea.
I'm sorry?
That's good. I have no idea.
Okay, yeah, all I'm asking you is that certainly this is a publicly available website, and it's got this review of you that says you shoehorn your personal politics into every discussion, correct?
It does. Other aspects of that make me think that I haven't had a discussion with that person, since it says no textbook, and my classes involve textbooks. It says A+, and that's not a grade that I give. It says not mandatory for attendance, and all of my classes are mandatory attendance.
That's right. So some internet troll just got on the internet then and just decided to destroy your reputation here.
I mean, if you look at the timing, this is around the time of the Chauvin trial. That may very well be the case.
Now, thank you, Ms. Cook. You live in South Carolina,
I do.
and more than 20 years ago, you were a police officer in Florida.
Correct.
But you're here today to talk about what a police officer did here in the state of Ohio, true?
Yes.
And as a paid opinion witness, you've already admitted to the ladies and gentlemen of the jury that you don't know a lot about Ohio law, right?
So having nothing to do with being compensated for my time, I do not apply Ohio law when I'm here as an expert to talk about generally accepted police practices.
You realize that police enforce the law, right?
Yes.
Okay, so, and you're testifying here today, again, as a paid
Yes.
opinion witness on behalf of these prosecutors.
Yes,
so you didn't review any
queen.
Ohio law before coming into court to testify.
I'm not answering legal questions with my testimony, so no, it would be inappropriate for me, like it would be for any witness, to offer a legal conclusion.
I'm not asking you for a legal conclusion, sir. Is there a reason why you don't want these members of the jury to know the answer to my question?
I think I'm answering your question.
I don't.
It would be irrelevant for me to review Ohio law because I'm not offering an opinion that backs itself or grounds itself in Ohio law. I'm applying generally accepted police practices. It would be a little bit like, did I review a cookbook? No, because that's irrelevant to the opinion that I'm actually generating. Now, Ohio law is clearly relevant to what the jurors are being asked to do, but I am not a juror applying Ohio law to the facts of this case.
Connor Grubb has to enforce Ohio law, sir, correct?
Sure.
Okay, and you didn't review that Ohio law before coming into court to testify today, yes or no?
That's correct, because it
Oh!
wouldn't matter to my opinion.
Oh no!
Thank you so much,
Stop
sir.
it! Stop the
There's no
fight!
belief that Ohio law doesn't matter to your.
Stop the
I appreciate
fight!
that.
Sure.
Now, you don't know what Ohio law says about what a police officer can use deadly force?
I'm sure I do. I've written about it elsewhere. It's just not relevant to my opinion in this case.
Can you name the Ohio Revised Code section that permits officers to use self-defense here in the state?
Do you mind if I refresh my memory?
Not at all.
There is none. If you
Also,
want
I
to
need
know
read
the
glasses.
truth about
My
it,
eyes just realized they were in their 40s.
I have readers back in my office.
I didn't expect to need to. Boy, they print these books really tiny. So we have a table of cases and state statutes in the opinion. In the book. One of the chapters is about the state law standard. I'm sure I looked. I don't know what it is offhand, but I'm sure I looked at Ohio law at the time. So I looked at the law in every state at the time for writing the state law chapter.
I was talking about before testifying today.
Yeah, I wrote the book before testifying today.
You wrote the book when? What year?
I wrote the book starting in probably 2017, 2018. It came out in 2020.
It's 2025 now.
It is.
You were never certified as a police officer here in this state, correct?
That's correct.
Your police training from near a quarter of a century ago is certainly not the same as the police training that Connor would have received more recently.
Boy, I hope not.
On direct examination, you talked about your education and experience, true?
Yes.
Your undergraduate degree wasn't in criminal law, wasn't in pre-law, wasn't in criminal justice, it was in English literature, true?
Yes.
And before you even finished college, you said you spent a few years as a full-time officer in Florida?
I'm sorry, ask that again?
Before you finished college,
Yes.
you spent a few years as a full-time officer in the state of Florida?
Yes.
You said under 5 years?
I was full-time for about a little over 4.5 years and part-time for another 6 months. So yes.
And in those 4.5 years, you never worked for internal investigations, correct?
No, I did that when I left and went to the state office.
You never were promoted to sergeant?
No.
Definitely never promoted to a lieutenant?
No, certainly not.
he never got the chevrons, chat.
No, I left police work to go to law school and then eventually made my way into academia.
Sure. So eventually made your way to academia.
Yes.
Great. Now you testified at grand jury in this case, correct?
Yes.
Now as a law professor, you're aware that in the grand jury, there are no rules, true?
I wouldn't say there are no rules, but I would say that it's a very different set of rules than applies in trial.
There's no judge, right?
Correct.
There's no need for Mr. Collins' defense attorneys, true?
No.
Yes, that's correct.
There's no rules about
Oh Lord.
Broadly, yes.
Okay. This case had to be presented to the grand jury before an indictment came out, right?
Yeah, the grand jury is the one that indicts, so yes.
Correct. And not just anybody can show up and say, hey, I've got some information for the grand jury. Can I testify?
Your
Right?
Honor, objected, and they shouldn't consider the indictment for any purpose.
Councilman approach.
Thank you.
It's about how they obtain the indictment, how they charge him. It's entirely appropriate. It's entirely appropriate. This is good. This is fucking quality shit right here, guys. This is entirely appropriate. This is quality shit. Not to now says counsel fucking sucks. Witness sucks too. Not really. Yeah. Secret Squaff says, goddamn A-logs taking my class. Goddamn A-logs. Anonymous asks a really good question for $5. He says, curious, what is the limit to discrediting an expert witness? It's up to the court. It's limited by relevancy. I mean, really. But I mean, at the end of the day, almost everything that attaches to bias, I mean, you're going to get a lot of leeway impeaching a nationally renowned expert. The more niche and profound that expert is, the more you're going to be allowed to do to beat the fuck out of them. But think about it this way. Ethan Ralph said it. Everything is fair game. It is. It's all fair game. And then arson investigator for $49.9999999999. Thank you. He says, I love this defense attorney. I do too, man. She's swinging hard. And thank you for your support. I'd appreciate it. Good to see you, by the way. Yes. McGall King, he's broken in half. She broke his back. Someone stop the match. Johan's like, McGall, stop the match. That man has a family. She killed him. Why does she make wheelchair hands when she's excited? I don't know. Yes, English major. I know, that's what I thought. It's not the only English major out there. Matt Daddy saying, Matty Daddy is saying, as Drago said, if he dies, he dies. Yeah, this is an ass whooping chat. Here we go. So, but yeah, imagine that $415 fucking an hour. Let's check this guy's weight. That is a thing we do, man. We look at everything. We look at everything.
Sir, I was saying, so nobody can just show up to the grand jury and say, hey, I got some information for you. Let me testify, right?
Do you mean the prosecutors call the grand jury witnesses? I'm not sure what you're asking.
Any random citizen can't show up to the grand jury and say, hey, I've got some information I would like to testify right here, right now at the grand jury.
I mean, they can approach the prosecutor and say that. Whether or not they get to is up to the prosecutor to call them as a witness.
Sure, it's up to these guys who to call as a witness at the grand jury, right?
Mhm.
Just like it's up to
Sorry,
them.
yes.
Just like it's up to them who they get to call during their case in chief. True?
Yes.
Okay. You would agree with me that you were called to testify by these prosecutors at the grand jury, yes?
Yes.
And you were retained by these prosecutors on April 29th, 2024, correct?
I'd have to go back and check the date, but I think that's right.
I can get the date for you, sir. Do you remember testifying at the Daubert hearing?
I do. I just don't remember the specific date, but I'm happy to accept your representation if that was the date of retention.
Appreciate that. So that's April 29th, 2024, true?
Sure.
Are you aware of when this case was indicted?
No, I don't remember.
You don't remember us talking about it at the Daubert hearing either?
Not offhand.
Okay. So if I told you, would you accept my representation that it was not indicted until August 13th of 2024?
Sure.
Okay. So you were retained by them though in April, right?
Yes.
And you testified at the grand jury before the charges came out here, true?
Yes.
Your report was dated July 31st, 2025, correct?
Yes.
Now, when you testify or write reports as an opinion witness, you testified on direct examination that the term of art that you choose to use is officer-created jeopardy, true?
As a way of referring to unjustified risk taking, yes. I use a couple of phrases. That is one of them. Sometimes I just use the phrase, as mentioned in this report, unjustified risk taking, unsound tactics. The point is similar with all of those.
I'm talking about just in your conclusion.
Guys, his name is down below. Steph Stoughton. He is the state use of force expert. His name is down below.
You only use your term, officer-created jeopardy, true?
I mean, in opinion one.
Yes, sir.
I describe it as unreasonable, as contrary to generally accepted police practices, as officer-created jeopardy, and as foreseeably contributing to the shooting.
Sure. Can we just pull the computer out? I'll pull the slide up for you.
Sure.
Where it says officer-created jeopardy. That's the term of art that I'm focused on for the line of this questioning, okay?
Sure, yes. I also use that term, yes.
Okay. You see where it's highlighted in yellow?
Yes.
Constituted officer-created jeopardy, true?
Yes.
Now you're aware that the Supreme Court of the United States has held on the use of deadly force, has listened to a couple different cases, true?
Yes, a number, yes.
Okay. Tennessee versus Garner is one.
Sure.
Graham versus Connor is the other.
It is another, yes.
Scott versus Harris is another, true?
Yes.
Now you testified about how the case of Tennessee versus Garner, the facts of that case. Do you remember that?
Yes.
About shooting a fleeing felon, true?
Yes.
Okay. But the facts of that case certainly don't mirror the facts of this case, correct?
Yes.
Okay. You would agree with me that Connor Grubb got hit by a car, correct?
I have no opinion as to whether he got hit or not hit by a car. He was certainly in front of the car when it started moving.
Sir, you can see on the video that he got hit by a car, no?
I can't see on the video a point of impact. I'm not saying he didn't get hit. I'm just saying I can't testify to my degree of expert certainty in my area that he was struck by the car. Was there contact? Absolutely, there was contact. He put his hand on the car, among other things. But I don't know whether he was impacted or hit.
I'm just asking you to use your eyes, sir. I'm not asking for any expertise or anything like that about generally accepted police practices. Just watching the video, you're telling these ladies and gentlemen of the jury here that Connor Grubb did not get hit by a vehicle?
If you're asking for a lay interpretation of the video, that's up to the jury. I testify as an expert. So to a degree of expert certainty, I can't define that he was hit or not hit. That's also not really the point of any of my opinions.
Sir, I get to ask the questions. Remember, we established that on direct examination, right?
On cross.
Yes. And is there a reason why you don't want the members of the jury to know what it is that you see on the video, whether or not Officer Grubb gets hit by a vehicle?
I am happy to talk about that.
I would just like
But the jury gets to decide what the facts are, not me.
Did you review the video?
Yes.
Did you see him get hit by a car?
I did not see a point of impact. I saw his hand on the car. I saw what looks like plausible contact. I have reports that say that he was hit by the car. I have at least some evidence suggesting not. It's not the job of an expert to resolve factual disputes.
So that wasn't my question about what the job of an expert is. I'd really like you to stop wasting time and just answer the question that I asked.
You're asking a question that is outside the scope of my expertise.
You can't use your eyes?
Sure, I can watch the video and I can tell you I don't know from the video, having watched it a great many times, whether Officer Grubb got hit by the car or not. I see his hand on the car. I see what plausibly could be contact between the car and his leg. I also see what plausibly isn't necessarily. I don't know, and I'm not going to testify to a reasonable degree of professional certainty since I'm here as an expert about what happened when I don't have a good basis for it.
Not what I'm asking you again, sir. All I want to know is, did you see Connor Grubb get hit by the car? Yes or no?
He's answered the question at this point.
Council Brooks?
Oh, God, this is getting good.
Now, you've never been a judge, have you?
No.
Certainly never a Supreme Court justice, right?
No.
Judges shape the law. You would agree with that, right?
Sure.
You went to law school, though, so you would agree with me that when the Supreme Court makes a ruling, every court in the country must follow that ruling, true?
It depends on the nature of the ruling. If the court is making a ruling and it's exercising its administrative power over the federal courts, no, it wouldn't apply to state courts. If it's a constitutional ruling, yes.
Okay, so as long as it's applicable, when the Supreme Court speaks, the states follow.
Yes.
Ohio courts have to follow it, true, too?
Sure. Anything that is applicable to constitutional rights or the like, yes.
Even the judge in this case, if the Supreme Court makes a ruling that's relevant to this case, this judge has to follow that, true?
Sure. If there's a relevant ruling, yes.
Mandatory directives from courts are very serious things, right?
Sorry, say that again. Mandatory directives from courts, like injunctions?
Mandatory directives like the law. When the Supreme Court articulates the law, that's serious, true?
Sure.
You would agree with me that the U.S. Supreme Court in Graham versus Connor said that those who evaluate an officer's use of deadly force, people like you and the jury, must not use hindsight 2020. True?
Yes, I think they say avoid the 2020 vision of hindsight.
Thank you. Now, you would agree with me that it's this judge's job to give the law to the jury, yes?
Yes.
And whatever is in those jury instructions, this jury must follow.
I really don't want to get into any position of instructing the jury, but yes, the jury should follow the jury instructions.
Thank you. Now, I've actually sent you a couple different sets of jury instructions that we've used over the past couple times we testified, yes?
In previous cases?
Yes, sir. You don't remember receiving an email from me with prior jury instructions from this court?
Which case was that in?
The Meade case, the Coy case. I've sent you Mitchell jury instructions before.
I've
got the email if you'd like to see it.
Yeah, yes, it sounds familiar.
Okay. Now, nowhere in any of these U.S. Supreme Court cases does it mention your term of art, officer created jeopardy, correct?
Those cases do not use that exact phrase.
And in the jury instructions, nowhere in the jury instructions that I have sent you from prior cases does it mention the term of art, officer created jeopardy, correct?
Sure, the jury instructions do not use that exact phrase.
And actually in OHADA, the training materials that you reviewed, nowhere in those training materials
Fair
does it
enough.
use the words officer created jeopardy, correct?
Right, it does. It certainly reflects the concept, but it does not use that particular phrase, yes.
If you also testified in another case as an opinion witness, do you remember the Taylor v. Holtmeyer case?
I do. I think that was limited to deposition testimony.
Okay. And that court was a federal court, true?
Yes.
And that court held that your opinion regarding the use of deadly force is inconsistent with the Supreme Court's opinion in Scott versus Harris, correct?
Sure.
Now, I want to talk to you about your report, and actually testified to this on direct examination. You stated, it is well known and generally accepted that time is the single most important tactical concept in policing, true?
Yes.
Okay. Now, you say that time is the most important tactical concept, so you're talking about the present tense, yes?
Yeah.
You're not talking about from a quarter of a century ago when you were a police officer.
Then too.
But you're certainly talking right now, true?
Yes.
As you say here today, you believe time is the most tactical, important policing concept, yes?
I think, sure, today, yes, absolutely. I don't think it's just today, right? I think it's actually a very old observation.
I understand. So did you take a poll of all police officers in America to determine that this notion is well known?
No, I reviewed training material, use of force policies, tactical guidance, tactical training manuals going back to the 1970s.
So no, you didn't take a poll.
I did not take a poll.
And did you take a poll of all police in America to determine that this notion is generally accepted?
I did not poll. No, this is not survey research.
Okay. So you have a footnote citation there, true?
Yes, that's a citation to my book.
Your book.
Yes.
Not all of these 1970 policies or anything else you just told the ladies and gentlemen of the jury about. You cite to yourself, true?
Well, those are cited in my book.
So that's not what I asked. You cite to yourself, correct?
Yes. I
No,
cite to myself because the book consolidates, as books do, a bunch of information from other sources. Like I think I have 563 footnotes in the book, including those relating to what I talk about in a more concise way, and then cite to my book because I think I said it better than the other folks did.
Certainly here you cite to yourself, true?
Yes.
That's your own opinion, right?
No, that's not my own opinion. That's reflected.
How do we
from
know?
the
'Cause you
information
cite
gathered
yourself.
for the book?
The book doesn't have your opinion in the book, sir?
It has some opinions of mine in the book. This is not what I would describe as an opinion.
Your book is not your opinion.
That's not what I said.
I'm asking.
The book has things reflected in it about generally accepted practices that I don't agree with, that are not my opinion. The book has things that do reflect my opinions or that align with my opinions, particularly the conclusion when my co-authors and I offer some specific suggestions. That's definitely opinion. But for example, the chapter on constitutional law or state law, no, that's not my opinions. That's just what it is. That's about the state of the world.
Again, sir, redirecting you back to my question, I really appreciate that very long narrative that you just gave the members of the jury, but redirecting you back to my question, that footnote cites yourself, yes or no?
It does. I'm sorry. I thought your question was, does my book have my opinions in it?
Thank you, I appreciate that. Turning to page 39 of your report, you claim that it is well known and is generally accepted in policing that officers should avoid putting themselves into people's path of travel. You would agree with that, right?
Yes.
That's what you write it in your book, or I'm sorry, in your report, true?
Yes.
And you established you didn't take a poll on police to see if it was really generally accepted or well known, right?
Right. Yeah. That's survey research is not how one develops that. But yes, that's correct. There is no survey research underlying that.
And in fact, there's no citation here at all. True?
Right, because that's an introductory sentence to the rest of the paragraph that has a bunch of cites in support of that particular point.
Sir, that's a whole entire sentence equipped with a capital letter and a period, right?
It is truding a whole entire paragraph with a number of sentences on that topic.
And that sentence does not have a citation. True or not true?
That sentence does not have a citation.
Okay.
Yes.
Now, that's an important statement. True?
The what's highlighted there?
Yes.
Sure. Like I spend multiple paragraphs on that point.
Okay. Now, you testified on direct examination about the IACP law enforcement policy, correct?
Yes, that's the International Association of Chiefs of Police model policy or consensus paper. I have a couple of different things from IACP that I cite in my report.
In those sentences thereafter, this one with no footnote cites the IACP model policy for vehicles, true?
One of them does, yes.
May I approach the witness, Your Honor?
Yes.
This is that model policy that you cite in your report, correct?
Yes, that's it.
May I have the Elmo, Miss Cook?
It's like I'm still not done whooping your
Now, on
ass.
page 3 of that policy, this says right here, this document is not intended to be a national standard. True or not true?
Yeah, that's what it says.
That it's not meant to be a national standard.
Sure.
Now, you would agree with me, sir, that generally accepted police practices say that an officer can use force when there is an imminent threat to something that the officer is lawfully trying to do. Yes or no?
Sure.
May I have a moment? Thank you, Mr. Stoughton. I have no further questions for you at this time.
Councilman Brooks? Everybody, join the party. Is everyone okay with do redirect?
Thank you, Your Honor. May I proceed, Your Honor?
Yes.
Professor Stroke, you were asked about that sentence in your report. It is well known and generally accepted in policing that officers should avoid putting themselves into a vehicle path of travel. Indeed, stepping into a path of travel of subject vehicle is perhaps the paradigmatic example of officers.
That was pretty good, Chad.
Having been used as an illustration.
Fuck them up.
And then, right after the defense attorney cut it off, did you actually then go on to provide multiple citations?
Yes, there are 1, 2, 3, 4, 5, 6, 7, 8, 9. Yeah, I like that discussion goes on for the next page and a half.
So, right after you say it's perhaps the paradigmatic example of officer-created jeopardy, where does your report go from there?
It talks about that as an example of officer-created jeopardy. Again, just unjustified risk-taking being used as an example in books. I think that's a cite to the way that we use it in the book. Book chapters, training presentations. It talks about the International Association of, bad capitalization on my part, the motor vehicle policy, which states in relevant part, quote, at no time should the officer or others stand in front of, between, or behind the stopped vehicles. It talks about these articles from 2005 in Police Magazine in 2006 that describe stepping in front of a vehicle or stepping into a vehicle's path of travel as a very poor tactic, placing the officer in a position where if the driver attempts to escape, the officer may interpret it as an attack and shoot. The block quote at the bottom there, and that I think feeds over to the top of the next page, is actually from a 2025 article after the date of this incident, reflecting on the longstanding nature of this particular aspect of policing. In the block quote there, the author is reflecting on, when I was an officer, it was unthinkable to step in front of the suspect's vehicle in order to order them to stop, I do not know when this dangerous tactic began, but it is an ill-advised tactic. It is not an acceptable police procedure. This tactic is another example of officer-created jeopardy because it puts the officer in the zone of extreme danger. That's from a 2025 article in Police Magazine.
So did you actually cite fairly extensively after your assertion that it's well known and generally accepted that an officer should not place himself in front of the vehicle's path of travel?
Sure, that's how paragraphs work, right? You introduce the paragraph with a sentence that tells you what that paragraph's about. You then write some sentences that support what that paragraph's about with citations as appropriate.
And now there's been lots of talk about this officer-created jeopardy. Is there a preoccupation with just the specific terms officer-created jeopardy, those words?
Yeah, there seems to be a lot of focus on the magic words officer-created jeopardy, which are utterly irrelevant, right? Again, it's the concept of unjustified risk-taking that is important, in the same way that when some police agencies refer to the backdrop of a shooting and other police agencies refer to the backstop of a shooting, it's not the disagreement in terminology that's relevant. It's the concept that both of those terms are being used to address. So whether we talk about unsound tactics or we're even more verbose and say unsound tactics that foreseeably increase the likelihood that officers will be exposed to danger that sound tactics would have avoided and thus have to use force, or whether we just summarize that as unjustified risk-taking or officer-created jeopardy, shouldn't really matter.
And if not the words officer-created jeopardy, are there tactics and concepts throughout the basic training curriculum of police officers that deal with officer-created jeopardy?
Sure. If we didn't care about unjustified risk-taking, we wouldn't have tactical training at all, right? We wouldn't tell officers this is the safest way to address a particular situation, or this is a reasonable scope of safe options to address a particular situation, because we wouldn't care about whether the risks they take are appropriate. But we do. That's why we have tactics.
And I know that it's not your job to instruct the jurors on the law that they are to apply, but it was asked about, had you received jury instructions from a defense attorney, and you see anywhere the words officer-created jeopardy? Did you see, while those words might not be there, would the words totality of the circumstances be there?
I would have to look back specifically at them. I think so, but I would have to look back specifically at what they were.
And if they did include the words totality of the circumstances, would that include the decision-making and the actions of the officer earlier in the encounter leading up to the shooting?
I mean, I think that's part of what it means to be totality of the circumstances instead of taking a moment of the threat or a final frame approach.
And now, Professor Stoughton, do you, in your role as an academic, well, I guess you've asked about 5.5 years as a police officer. You were a police officer for 5.5 years, correct?
Yeah, thereabouts, yes.
And have you devoted your academic career to primarily the study of policing?
Yes, exclusively the study of policing. I've been a policing scholar now for 13 years, and that's really the only thing I research is policing.
And are you still active in the actual world of policing beyond academia?
Yeah, very much so. I run a program that provides police training at the officer level and at the executive level around South Carolina and around the country. I actively speak to police audiences all the time. I work with agencies all the time. So yes, I try to take myself out of the ivory tower to the extent that I can.
And in your role as a scholar, as an academic, will you discuss or publish on ideas for what you think would be better officer practices, or even practices that are considered acceptable that you don't agree with?
Sure. Yeah. Part of my work as an academic is to identify promising best practices, to identify whether there's empirical research supporting that or not. The National Institutes of Science commissioned me and several co-authors to write a paper on the empirical evidence that we have about use of force, right? That is what affects officer use of force. Yes, as an academic working in the area, I certainly look for and attempt to promote best practices. But there's a significant difference between my role as an academic and my role as an expert, and the promotion of best practices or cutting edge practices and looking at generally accepted practices, which are really beyond reasonable dispute.
And do you keep those roles distinct when you're asked to review a case to provide expert analysis as to whether an officer's actions were reasonable in terms of generally accepted practices and principles?
Extremely distinct. The way that I sort of analogize it is like the rules for my kids at my house as opposed to my mom's house. They're both rules, but they're different rules, right? So depending on where we are, different rules are going to apply, and they should, because my role as an academic and as someone working in this area is very different than my role as an expert witness. In the same way that like an attorney can argue two different positions in two different cases, right? It's just a different professional obligation.
And have there been times when in your role as an expert, you've reached the opinion that
This is so offside across.
have there been times in your role as an expert where you have found you reached the opinion that the officer acted reasonably consistent with generally accepted principles and practices, even though you didn't necessarily agree with that principle or practice being generally accepted?
Yes, there are situations where I think there might be better promising practices, but that's not my role as an expert to assess better promising practices, right? My role as an expert to say at the time what was generally accepted, and that's the answer. It either is or was not.
So when you're retained as an expert, is it to not analyze whether or not an officer was using the best practices or whether or not the actions were reasonable?
I'm sorry, ask that again.
When retained as an expert, is your role to analyze whether or not the officer performed the best practices or just whether or not those practices were reasonable?
Yeah, as an expert, I do not assess whether the officer acted consistently with best practices. It's just whether they were reasonable, professionally appropriate under generally accepted practices.
And have there been cases where you've been retained where you did find that an officer acted appropriately consistent with accepted principles and practices?
Yes, yes, there have been.
Have there been numerous times?
There have been numerous times. Some of them don't go to trial. Some of them, especially retentions by a prosecuting office, I issue a report or testify in grand jury, and there is no criminal trial because there is no indictment or prosecution, right? Or in cases that do go to trial, there are typically split opinions where not everything an officer does is inappropriate. There are things that might be entirely appropriate in the scope of the actions that I'm reviewing. So that's part of the overall opinion too, even if what tends to get focused on in litigation is the specific things that officers may have done wrong.
And Professor Stoughton, it's been talked about how you were a police officer in Ohio and you're not an Ohio guy. Does that have any relevance to determining the generally accepted police practices and procedures?
No.
Would that vary state to state?
In the context of this case, no. Cars run over people in South Carolina and Ohio.
And you were shown during cross-examination a quote or a head note from State v. White when it talked about experts not engaging in armchair reflection and about what an officer could have, should have done. Is it also generally accepted in policing when evaluating the use of force not to use that type of armchair reflection?
Yes, absolutely.
Does that mean there can be no consideration about what an officer should have done?
No. So there are two different reasons that policing might review an officer's actions, one of which is to see whether the officer or any other police employee did something wrong. Separate and apart, we might look for whether there are things that the agency as a whole might do better, whether there are changes to training or policy or equipment that might improve future outcomes. The way that I understand White and the general prohibition on the sort of armchair quarterbacking is don't confuse those two things, right? Just because there could be something that was better that would have led to a better outcome, that does not necessarily mean that an officer did something wrong. Sometimes an officer does something wrong, and if they hadn't done that thing wrong, it probably would have led to a better outcome, but the focus is on whether they did something wrong, not the sort of alternatives.
And in this case, what did the defendant in fact do?
He stepped in front of the car. He stayed there for a total of about 10 seconds. When the driver of the car turned the wheel, he drew his gun and remained in front of the car for more than another 4 seconds. As the car started to move, he continued to remain in front of the car for another 2 seconds, and he ultimately shot and killed the driver.
And were those actions consistent with generally accepted police practices?
No.
Can we have a moment, Your Honor?
Yeah.
Nothing further, thank you, Your Honor.
Any questions as we go this?
None necessary, Your Honor, thank you.
All right, you can step down.
Thank you.
All right, ladies and gentlemen.
All right, chat. Well, there we go. That's it. There she goes. So that's the entire case. Right there. I think that was absolute horse shit there. But the rules were the rules at the time. Yes, that is basically what he's trying to argue. Which is absolute fucking nonsense. Yeah, 4 whole seconds. So we have more. What we have are the closing arguments, and we're going to do those tonight. So let's bring those up. So here are the closing arguments.
Ms. Clayton and Ms. Stevens were able to review.
Fuck, just load up. God damn. Making this way too hard, YouTube. All right, chat, here we go. Closing arguments. She's like, my baby stole tequila. My baby didn't do nothing wrong.
All rise.
No, okay. No, guys, this case is over. This case actually ended last Wednesday. We're just catching up. So we'll get through closing arguments and then we'll go through the verdict here. But this is not 4 hours long, so don't panic. Here we go.
Along with me,
Also,
the arguments of counsel.
we are not going to do the jury instruction, so let's skip ahead. Okay? This is like 18 pages of bullshit. Okay? We're not doing this. We're not doing this. Okay?
Defense of justified in use previously been defined for to establish this defense of justification. The defendant must prove that he was justified in using deadly force by preponderance of the evidence. Preponderance of the evidence, deadly force, and reasonableness have previously been.
So remember, he's only got to prove it to the 51% threshold. Okay, it's a preponderance of the evidence. All right? And the state has to prove it beyond a reasonable doubt. So he's actually got a chance here. Like the odds are in his favor. And we're going to skip ahead here to the actual. Remember, this is the prosecution going. So here we go. See, chat, we already skipped 30 minutes. Stick with me. I'll help you out.
Good morning, Your Honor, my co-counsel and defense counsel, and ladies and gentlemen of the jury. This case is before you because on August 24th, 2023, the defendant, Connor Grubb, used deadly force against Takia Young when he shot through that windshield.
No, that's not bad when you can't say your name right. That's awful.
And by ending her life.
That's kind of shitty, actually.
The evidence has
That's pretty
established
bad.
that the defendant did shoot and kill Takia Young. And in this trial, we learned about what happened on August 24th, 2023, in that Kroger parking lot. You've been to the Kroger parking lot. It feels like it was a while ago now. But you've seen the two videos that captured the incident in the parking lot. And you've seen the body-worn cameras of both Sergeant Eric Moynihan and the defendant. And many of the facts in this case aren't in dispute. There's no dispute that this happened on August 24th, 2023. And there's no dispute that the shooting happened in Franklin County, Ohio, out of that Kroger, 5991 South Sunbury Road in Westerville.
Yep, that's a
There's also no
nose.
dispute that the defendant was the one who fired his weapon into the windshield of the Lexus, striking Takia Young. And the evidence supported that. The state presented the evidence that Officer Ryan Schleve from the Westerville Police Department found the casing, the spent casing in that parking lot. It was eventually marked with a cone, marked with a placard. You also learned from Dr. Hirschberger from the coroner's office that a projectile, a fire bullet, was recovered from the body of Takia Young during that autopsy. And you learned that Special Agent Tackett collected the firearm of the defendant from him at the Blendon Township Police Department. And then you heard from Andrew McClellan from BCI, who was the firearms examiner, and he explained to you how he took that firearm from the defendant, and he compared it to that fire bullet in the autopsy, he compared it to that spent casing in the parking lot, and they came from the same gun.
We already knew that. Nobody's challenging that.
There's also no disputing the objective evidence that was shown to you
in the videos that were presented. And these are the 4 videos that came
Aaron,
up during this case. That you
what are you talking about? None of this is that was it. There's no more to like. If there's something, I don't see it listed. What did I miss? I need like. There was nothing else they argued about. So I don't know what you're talking about. Apparently, Channel 10 didn't cover this. The people who covered it didn't bring it up. Let me. Yeah, I can't. I don't see. I don't know what you're talking about. If there's something that happened, so, yeah, I don't know. I don't know what you're talking about because there's nothing here that shows it. Yeah, I don't see anything that covers that. So I don't know what happened. The state's rebuttal closing. The rebuttal closing. Ah. Oh, I thought you meant like their rebuttal. Okay, like they had a rebuttal argument. Sorry. All right, we'll watch that. Yes, I was told about that too.
seen throughout this trial.
Sorry.
That Kroger parking lot video, the Kroger lockup video, and then the body-worn camera videos of the defendant and Sergeant Eric Moynihan.
Don't do that.
The judge has just read to you the jury instructions, and you will have a copy of those that go back to you with you to the jury room. And he explained to you what charges this defendant has been charged with. And it's easier, I think, sometimes to visually see how those elements play out. So I'm going to start really with the murder counts. Those are counts 3 and 4. And they're based upon the felonious assault counts, which are counts 1 and 2. And remember back in jury selection and voir dire, I talked to you about, maybe you didn't know this at the time, but there are different offenses that meet the same behavior, and the state can charge each of those. And that's what we're talking about here. So you have murders based on different kinds of felonious assaults. So here are counts 3 and 4. The defendant caused the death of Takaya Young as a proximate result of committing or attempting to commit felonious assault. And that is a felony of the first or second degree and an offense of violence. So then you have to talk about the underlying offenses. And what the underlying offense is, that's going to be that felonious assault, which is the count 1 and 2 in the indictment. So to the left, the count 3, murder is based on a felonious assault, serious physical harm. On the right, in count 4, that underlying offense is a felonious assault, deadly weapon. Now let's talk about proximate result. Judge just read this to you, but I want to point it out again. The defendant's responsibility is not limited to the immediate or most obvious result of this act. It's also responsible for the natural and foreseeable consequence or results that follow in the ordinary course of events from the act. So what does that mean? When the defendant shot Takaya Young, that is how she died. It's not an intention to kill, it is a knowing shooting of Takaya. And so that is what the proximate result means. And the doctor explained to you that that's how she died. So let's move on then to the felonious assault counts, which are 1 and 2, and talk about the elements for that. So knowingly applies to both. And the count 1 is cause serious physical harm. Count 2 is cause or attempt to cause physical harm by means of a deadly weapon. In this case, that's going to be that gun to Takaya Young. So the harm is different for each count, but there were about 6 different ways that serious physical harm can be proven. You need to look at B, any physical harm that carries a substantial risk of death. That's the most applicable in this case. We know that she died, and therefore serious physical harm was caused to Takaya Young. And then the other kind of felonious assault requires physical harm, which is any injury, illness. Obviously, if we have serious physical harm, we're going to have physical harm. Now, knowingly. Person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result. You heard from Dr. Harshbarger about how the bullet wound took the life of Takaya Young. And when you shoot the gun, you know what's going to happen when you shoot the gun. That's what knowingly means.
I hope it hurt.
And how do you determine it? You can't look into the mind of another person, but you can take the facts and circumstances around it to determine what knowingly is. So the question is, when the defendant pulled the trigger of his gun, did there exist at the time in the mind of the defendant an awareness of the high probability that Takaya Young would suffer serious physical harm? That's going to be count 1 felonious assault, count 3 murder. Or that Takaya Young would suffer physical harm by means of a deadly weapon. And that's count 2 and count 4. And how do we know that? We know that from the defendant's own words. What did he say in his typed statement that was presented in this case? My backdrop was the interior of the suspect's car. My target was the suspect's center mass. So you heard some questions of officers who took the stand. It's not an intent to hurt somebody, is it, when you're shooting for center mass? Please do not get confused over the word of intent, because what the state has to prove to you and has proven to you is knowingly. When you knowingly aim at and shoot at center mass of a person, then you know what the result will be. That's the purpose of your result. And how do we know that that was what the defendant was trying to do, shoot center mass, cause serious physical harm, or cause or attempt to cause physical harm with that gun? Because where he was aiming. So
Yes, it's a little
screenshot from the body
fast,
worn camera,
1.35
and there's
speed.
Takaya. There's the bullet hole in the windshield. And then to the right is a close. Special Agent Tackett recovered from the body of Takaya at the hospital. And look at the holdings. And then you heard from the coroner about that specific injury. He removed that bullet during the autopsy. It entered her lateral left breast. It hit her left rib. It struck her heart. It went through her aorta. Dr. Harshbarger told you that's a major vessel, and it lodged in her spine. The holes to her heart were fatal in and of themselves, and then the blood loss and the decrease in her blood pressure was also fatal. You also learned that the direction of that bullet was left to right, front to back, and downward. So again, the person has knowledge of circumstances when the person is aware that such circumstances probably exist. You can't say, oh, I didn't intend to kill, I was just stopping the threat. But by stopping the threat, you are knowingly causing serious physical harm. So let's talk about counts 5 and 6, the involuntary manslaughter counts. And this is for the termination of Takaya Young's pregnancy. The judge read to you, it's in your instructions, what termination of pregnancy means. But yet again, we have the elements of the involuntary manslaughter charges. And these are based upon a approximate result of, again, committing those two different kinds of felonious assault. Count 5, the felonious assault, serious physical harm. Count 6, the felonious assault, deadly weapon. Now, the coroner explained to you that the baby died because of this gunshot wound to Takaya. The baby hadn't died in utero beforehand. And we also know that because in her car was an ultrasound. And that was taken the day before this happened, August 23rd, 2023. And it gave 26 weeks, 2 days. That baby died because of this gunshot and no other reason. Dr. Harshbarger also told you, in his opinion, that fetus was 25 to 28 weeks and there was no evidence of the baby dying before this happened. So just like the approximate result in the first counts of murder, now we have the felonious assault ended the pregnancy of Takaya. And I want to point out, in those jury instructions that you have, nowhere in those jury instructions requires the state to prove the defendant knew she was pregnant. That is not something the state has to prove in the counts before you. So, did the state prove beyond a reasonable doubt that the defendant committed the 6 offenses he's charged with? The murder? Yes. The felonious assaults? Yes. The unlawful termination of a pregnancy, involuntary manslaughters? Yes. And so since the state has proven the 6 counts to you beyond a reasonable doubt, then you must move to the affirmative defense of justification in this case. And this is the defendant's burden. Our burden was to prove beyond a reasonable doubt the 6 counts, and now it is the defendant's burden by a preponderance of the evidence to prove to you he was justified in using deadly force against Takaya Young. Here's the definition again. It's in your jury instructions. The greater weight of the evidence. That is, evidence that you believe because it outweighs or overbalances in your minds the evidence opposed to it. And it is a tipping of the scale. This is the legal definition of it. But it is the defendant's burden, and you can consider all the evidence when making this examination. It doesn't matter who produced the evidence, you can evaluate all of it. That's in the jury instructions. So I want to be clear about something when you are going over whether or not the defendant has met the burden. If the weight of the evidence is equally balanced on this issue, or if you're unable to determine which side of the issue has the preponderance, then the defendant has not met his burden, and you must find the defendant guilty. So what comes up in this defense of justification? Well, the use of deadly force. And it is an objective analysis. reasonableness. The test for reasonableness is an objective one in light of all the facts and circumstances confronting him at the time. But you don't put yourself in his shoes. It's the position of a reasonable officer on the scene. What would a reasonable officer have done? And again, it's only what the defendant knew of at the time. So the question is whether his action was objectively reasonable in light of all the facts and circumstances confronting him, without regard to his underlying intent or motivation. And you've heard about these Graham factors. You've learned more case law in this trial probably than you'll ever learn about again. But those Graham factors were brought up many times during this trial. But you are not limited to the Graham factors. Those are specific things that the law has said you must consider, but that's not what you're limited to. I want to remind you of that. So what do we have? The severity of the crime that the officer was addressing, whether Takaya Young posed an immediate threat to the safety of the defendant or others, and was she actively resisting arrest or attempting to evade arrest by flight. So let's talk about some of those. Severity of the crime. We told you from the beginning, Takaya Young stole liquor from that Kroger store. And the Kroger employee had gone out and informed Sergeant Moynihan, hey, she stole. That's the information that Sergeant Moynihan would have had at the time. And then the video, the body-worn camera videos of both Moynihan and the defendant showed that Officer Grubb would have been in a position to hear Moynihan confronting her about that theft. So that's all the information he would have had when you watched the video. And you heard from Sergeant Eric Moynihan in this trial. He testified in the defense case. And he told you, I was investigating a theft, and it was a misdemeanor. And he was asked more questions, which wasn't cooperating with you, and she wasn't. But there's no disputing. She was not doing what Sergeant Moynihan wanted her to do. She was not getting out of the car. But Sergeant Moynihan told you that's still a misdemeanor. So they are investigating a misdemeanor. Now, the defense wants to make that into a felonious assault or an aggravated robbery, claiming that she's fleeing the scene after taking those liquor bottles. But again, you have to go back to some of the questions asked of even Kevin Davis. This was not a felonious assault, serious physical harm, because the defendant did not suffer serious physical harm. So then the other felonious assault would be she was attempting to cause him harm. What was she doing? Turning her wheel the whole way to the right, away from him. And remember, he's the one who walked in front of him. But she's turning the whole way away from him. So trying to turn her act into a felonious assault is a stretch. And the same thing goes for the aggravated robbery claims. They were investigating a misdemeanor theft that maybe turned into the obstruction for not listening and getting out of the car. This isn't about Takaya taking the alcohol. This is about what the defendant did next. When I talk about Takaya turning her wheel, remember the clip of that was played for Kevin Davis. I mean, she hand over hand over hand. And then you can see in the video, I think it was even paused at times, her wheels are going the whole way. She was going to the right. And this also goes into whether or not then Takaya posed the immediate threat to the safety of the defendant or others. And the state asserts that she wasn't trying to hit him, she was trying to get away from him, which maybe goes into that third factor of trying to evade arrest, but it definitely does not elevate those first two factors. It's not reasonable to stop someone for a theft at all costs. And you heard that Sergeant Eric Moynihan even testified, if she'd gotten away, we wouldn't even be allowed to pursue her. That is the severity of this crime that they were investigating. It was a theft, a misdemeanor theft. Now, you've also heard a lot of law and comments about hindsight. It's in the jury instructions, the issue of 20/20 hindsight. We can't go back with things that we know now and apply that to a decision made earlier. But that does not mean that an officer's claim of justification can't be reviewed. That is what this process is for. That is what you are here for. The state is not saying that the defendant woke up that morning and wanted to discharge his firearm. But the state is saying when he made that decision, it was not a reasonable one, which means it was not a justified shooting. And you are not limited to those Graham factors. And one of the things that goes into your determination of reasonableness in this case is the defendant's own statements. The statements he made at the scene, the statement he made to the medic at the Blendon Township Police Department, that typed statement that was submitted 2 months later, and then there was an email with some follow-up questions and answers, I think a month or so later. So let's talk about the defendant's claim of these injuries to his legs. You heard from Officer Peter Ferguson. He was with the Minerva Park Police Department at the time. And when officer saw him, he told you that he said, "Are you good?" And the defendant said, "It's not mine." There was never a word about any injuries to his legs when officer heard Ferguson asked if he was good. Officer Schlebe also testified, and you saw a video of his interaction with the defendant after the shooting. And again, he's asking him, "Are you okay?"
Think so?
Yesterday, prior to all reporting,
Got yours? Got yours? I'm not sure.
you're dangerous.
I'm gonna have another medic come in and check you out. 59.
What did he do when he asked he's hurt? He looks at his arm. And we know from the evidence that injury would have been caused when he broke that glass in the driver's side door. But he never once looks down at his legs. He never once complains about injuries to legs. But he wants you to believe through some pictures and some expert witnesses that those injuries were caused when he was struck by the car. Well, let's get into the blame. His own statement, the defendant said 2 months later that when he attempted to get Takaya out of the car started moving forward again and I fell to the ground. So when I was talking
Fell to the
defense
ground.
he never put anything about that in his report. He just made a statement, "Oh, the injuries were caused when I got struck by the car." But he did ultimately admit, okay, it would have been caused, it could have been caused when he fell to the ground. And the body worn camera shows that this happened in addition to these words. So the defendant is taken to the Blendon Township Police Department, comes into contact with Special Agent Taggett. She documents his body, where the camera was, these marks on his legs, injuries to his legs and his arm. And then a paramedic from the Westerville Fire Department also comes, because you heard Officer Schlebe say, "I'm gonna send a medic to you, just make sure you're okay." And he checks him out. And the defendant says, when he was hit to the car, he fell to the ground. But that is not on the video. That's what he claimed that night. That is not what the video shows. But the videos do show that he was able to run back and forth to his cruiser and then run back again when he moved it. No issues with his legs at that time. Facts and circumstances to consider in this reasonableness determination. The video evidence shows Officer Grubb placed himself in front of the car. And you've seen the video of him doing that. It's on all the videos. He walks around Sergeant Moynihan, who was calmly dealing with Kaya, and he puts himself in front of that car. But there's also lots of questions about, wasn't it really important to know it's dangerous out there? And it is. But there was discussion about how, with the change in our laws about carrying weapons in Ohio, officers are concerned there's going to be a lot more guns out there, and that is a risk to their safety. But what does that mean an officer is going to be doing? An officer is going to be watching the hands. Watching the hands. And in this case, from Officer Grubb's
Remember,
position,
the hands are what
we
hurt
can
you.
see through his body
The hands carry
her
weapons.
hands are
They
right at the
hurt.
top of that steering wheel. So he would be able to see her hands, which means he would be able to see her turning to the right. The body worn camera of the defendant captures her hand dipping down, and immediately the body worn camera shows that turn signal go on, and then she's cranking it. And that's something that the defendant's body camera showing what is facing that way captures, but we know he's looking that way because he ultimately shoots Takaya at center mass.
He shoots her on the
The video
ground.
evidence contradicts the defendant's claims about his feet being completely off the
Crank
ground,
that,
his waist
soldier
being on the hood
boy.
of the car, his body being carried by the car, the statement to the medic that he was thrown to the ground by the car. What does the video show? It shows him stepping forward and putting his hand on that hood. He steps to the car. He puts his hand on the car. The car is not putting itself on his hand. He is making a decision to advance to the car, put his hand on it, and he draws his weapon. That's not consistent with what his statements are. So let's talk about Professor Seth Stoughton. He's a professor at the University of South Carolina Law School. And he is an expert on police practices, use of force. And he talked to you about this case. He explained to you about the practices that he examines as a standard. Now, it was interesting how the defense tried to attack him. But let's talk about his opinions. So in his opinion, as a scholar on police practices and use of force, that it was the defendant's decision to move to and remain in a position in front of her vehicle, and that it was unreasonable. Contrary to generally accepted police practices, constituted officer-created jeopardy and foreseeably contributed to the shooting of Ms. Young. And second, under the circumstances of this case, his decisions to draw his firearm and to use deadly force instead of removing himself from the cab of the vehicle was unreasonable and inconsistent with generally accepted police practices.
Very true, Karen. Very true.
Now, the defense had Kevin Davis. So they kind of contrast each other. And Kevin Davis told you, I was an officer here, he worked for many years in the state of Ohio, and now he's retired and he's a consultant under use of force. And boy, did the defense go after Seth Stoughton because he was never a police officer in Ohio.
Well, it's kind of important.
In that attempt to attack,
it's kind of fucking important to be a police officer in Ohio.
Here, remember when Kevin Davis was
Also checking here,
himself his experience, he was telling you how he testified in lots of different states. So I guess it's good enough for Kevin Davis to testify in other states, even though he's not been an officer in them. Not good enough for Professor Stoughton. You know, it's interesting, when Sergeant Moynihan testified, he talked about how he put his hand on the window, and in opening statement, you were told that Sergeant Moynihan was dragged along with his car. But when you take the testimony of Sergeant Moynihan, he said, I could have taken my hand off that window at any time. So that's even inconsistent. He was not dragged by the car. Sergeant Moynihan also told you he was surprised when the shot went off. So clearly he wasn't expecting this to turn into a deadly force situation. And he also did not perceive a threat from Zakai. He told you that. She wasn't a threat to me. But the defendant chose to walk past Sergeant Moynihan, who was trying to take care of the situation, and put himself in front of the car. So Professor Stoughton was asked pretty much directly, like, is it a good idea to step in front of a motor vehicle? What should you do? And he said, don't. But you know who also agrees with that? The Blendon Township Police Department has policy on it. Now, a policy violation can be used to evaluate this question of reasonableness. And so you were presented with that Blendon Township Police Department use of force. And when feasible, officers should take reasonable steps to move out of the path of an approaching vehicle instead of discharging their firearm at the vehicle or any of its occupants. It also says shots fired at or from a moving vehicle involve additional considerations and risks and are rarely effective. There's a lot of talk about, well, that was the best place for this contact and cover concept, and there's some disagreement about that too. But by placing yourself in front of a vehicle, you're not going to stop the vehicle. The physical presence of a body does not stop the motor vehicle from going forward. And shooting the driver of the vehicle, again, does not stop that vehicle. In fact, it makes the situation more dangerous because now the driver is out of control. And I think you heard testimony, the car almost becomes like a missile. But Kevin Davis wants you to believe, and other witnesses want to tell you, that it was fine for him to be in front of that car. Now, let me also talk about the defense cross-examination of Professor Stoughton. He was confronted with this statement here, a little bit small. You don't have any citations in here. You don't have any citations. He tried to explain, it's an introductory paragraph. You don't have show me the citations. But ironically, if you give the whole page of that report, the defense counsel cut off the sentence 2 words short, and then what happened? Citation, citation, citation. Well, that's a little disingenuous in a cross-examination when you didn't even give him the whole quote. And then an attack.
Wait, you didn't do that either, bitch.
Was rate my professor evaluations. That's what they got. That's what they got to attack Seth Stoughton. None of that at all.
It's kind of important.
Support their burden of justification.
It's kind of important, honey.
Now, there was also some attacks on witnesses for being paid. I didn't even ask Dr. Desmolin if he was getting paid. Is it really surprising to you that experts are getting paid for their testimony? I didn't even ask. Of course he's getting paid, all of them. And in fact, Professor Stoughton and Dr. Bauer put their rates in the report so the defense knew what to ask them about, how much their hourly rates were. Again, just another way to try to distract you from what they're going to tell you. Oh, they're getting paid.
Really?
So were their witnesses for Dr. DeBolin.
That's scummy. Scummy.
Now, Dr. DeMolin, when he testified from Canada, came up with this animation. The night before, he said.
He
Never
came
did it
with an
once,
animation
to try to show
station.
you what happened. And then Dr. Bauer did get a chance to review that before he testified, and he showed you, in contrast to the video, how that animation does not match up with the objective evidence shown on that video. Just another attempt to distract you from what's on the video and what you know to be true. And why do you even need an animation when you have those 4 videos? And then
Because you
talk
do.
about timing. Dr. DeMola and the defense wants you to believe this is all this magical, like 1.66 second, snap your fingers decision. But they're not starting timing when it started. And Professor Stoughton had a chart that was shown to you about timing, and here it is. So the timing from the defendant stepping in front of Takaya's car, 10.467 seconds until he fires weapon. All right, let's start the clock when he drew his firearm. There are still 4.334 seconds there. But the defense narrows it so much because they need that timing to be smaller. Obviously, if you back up the timing, there's more thought, more chance to get out of the way. It goes to reasonableness. Let's talk about Kevin Davis again. I think he was, whenever talking about getting paid, he charges less than other people, he says. But I think it's kind of interesting, his report, until the
agree.
weekend
She got
before he
11 seconds.
testified, had the wrong defendant's name in it and the wrong victim's name in it. That's curious. So Dr. Jeremy Bauer, he's looking at this question of reasonableness of the acts in a scientific way. Human performance, the biomechanics of the body, the car, and he synced the videos, like Kevin Davis and Seth Stoughton also did. But he went through that video to show you the actions are not consistent with the defendant's statement. And here it is. 2 months later, in a typed statement, he said, "My feet were completely off the ground, my waist was on the hood of the car, and my body was being carried by the car as she continued accelerating." The simulation, the animation might attempt to show you that, but the videos do not. And when Dr. Bauer played it for you, it was the cropped up version. You can see him step forward. Switching over. Hold on. There we go. Okay. So take a look here. The one on the right. What do we see? You have Officer Grubb in front of that car. He steps forward and puts his hand on the car. Again, he is approaching and making contact with that car, not the other way around.
This is a weak argument, chat. Absolutely garbage argument, really.
In the defendant's statement, it's also important to know that he said he had watched the body-worn camera prior to making his statement, and he still wasn't.
Objection, Your Honor.
Take,
Absolutely.
That is
100% approach.
Well, the objection is sustained. And ladies and gentlemen, closing arguments are not evidence. You've heard all the evidence, and it's just a guide by the attorneys.
Mm.
And so,
Doesn't change my opinion. You can read whatever.
Okay, we need to go back through this and see what she just went through here. So,
prior to making a statement, and he still
I'm
wasn't.
touching you.
He said, in the defendant's statement, it's also important to know that he said he had watched the body-worn camera prior to making a statement, and he still
I'm
wasn't.
touching you.
and I think that's fair. He hasn't been talking. It's not fair to go to this point. So, yeah, once in a while you do object, and it's one of those times you have to. On a wall says, do people not write closings? You're kind of like making them up as you go based on what happened. So, a lot of it's more bullet pointed than anything, especially in cases like this, where you don't come back another day.
Absolutely.
And it's just a guide by the attorneys.
All right, I'm gonna read it then.
Doesn't change my opinion. You can read whatever you want.
All right, I'm gonna read it then. So,
Same objection.
in the statement of Officer Connor Grubb that was submitted to you as evidence, it's typed, I have now had an opportunity to review the body-worn camera footage of the incident. Those are his words in the statement.
And absolutely, Your Honor, that does not mean that he saw it before he wrote it.
I know your objection.
Strike the word, Your Honor.
Overruled.
It's a good objection. It'll be
Defense
harmless
has
error,
not
though.
presented sufficient evidence to meet the burden of preponderance of the evidence, even at the standard it is. Their witnesses and the evidence heard in this case does not get them there. And because the evidence does not support their burden of justification, you must find the defendant guilty of the murders and the felonious assaults and the involuntary manslaughters. Thank you.
I have to read this one more time. Carmen will scream at me if I don't give her a break. Do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it is finally submitted.
All right, we're going to skip ahead to the defenses. Here we go. Here we go, chat. This is going to be good. I'm looking forward to this one a lot.
May I proceed, Your Honor? May it please the court. I'm the court reporter, Madam Ballot. Ms. Stevens, Connor Grubb, Mr. Glenn, Mr. Claypool, Mr. Brandt. Good morning, ladies and gentlemen of the jury. The first thing I'd like to take note of and thank you is for you stood up in the beginning of this trial when the judge swore you in, and you swore to take an oath not to form any conclusions or opinions until you've heard all the evidence, the opening statements, and the closing arguments. I've tried to watch you as much as I can, being as busy as we are, but I do believe you kept that oath. And I thank you for that. And I know we all in the court will thank you for your civic duty, because without you, we wouldn't have the best criminal justice system in the world. So thank you. The second thing I'd like to take note of, ladies and gentlemen, that on August 24th, 2023, it was a terrible day. It was a tragedy. The young family lost a child, a grandchild, a cousin, a niece, a friend, a relative. Their pain is real. The hurt is real. That family's life will forever be changed. That's just a fact. All of us in the court have been affected by that. August 24th, 2023. But your role, ladies and gentlemen of the jury, goes far beyond your sincere sympathy and understanding for that tragic day. Because when you walk out of this courtroom to go to the jury room, the law and justice demands that you set aside that sympathy, no matter how difficult that is. And I believe you can do that. We talked about that. Closing arguments. It's a chance, ladies and gentlemen, for each side to argue the facts and make inferences from facts, to let you lead you down a path of what we believe the evidence showed or what we believe the government didn't show, didn't prove versus prove. So let's start first thing and foremost. First thing and foremost. First and foremost, in closing arguments, this is the defense of Connor Grubb. That person there, no matter how many times they call him a defendant, his name is Connor Grubb. He's a human being, and he served his country honorably in the Marines and received an honorable discharge and immediately went into serving his community as a police officer. His name is Connor Grubb, no matter how many times she calls him a defendant. The basic analysis of the closing arguments, ladies and gentlemen, is first and foremost, you have to decide whether or not the government met their burden, okay? If they don't meet their burden of proof, your analysis stops. If they meet their burden of proof, then it shifts to us, okay? That's the basic premise here. If we meet our burden, the lower burden, I'll go over that, that trumps their burden, no matter what, okay? It's that simple. So let's examine each of the burdens, ladies and gentlemen. The prosecution, ladies and gentlemen, has the incredibly high burden, it's the highest in our system, of proof beyond a reasonable doubt. Proof of such nature, you will rely upon it in the most important of your own affairs. Surgery for a loved one, care for an elderly parent, who to watch your child, those types of things, all the way over there when we were talking about it. And it's not close. The government doesn't have to partially do it. They don't have to come close or even tie. It must be proof beyond a reasonable doubt. Doubt based on reason and common sense. They can't almost prove it, and they must prove each and every element. And again, we're not contesting almost any element except the mental element here, ladies and gentlemen. The mental element. It's a very hard thing for the government to do, as the judge will instruct you. And if they fail, there's only one verdict, not guilty. And all the elements are required to be proven not guilty. You can feel, ladies and gentlemen, in your conscience and that common sense, that inner thing that helps you make decisions, something doesn't feel right in their case. That's what you can feel. The reason why, ladies and gentlemen, is because most of their testimony from fact witnesses helped counter Grubb. They made his actions legal. The factual witnesses that the government put on made his actions legal. There are other witnesses, the opinion witnesses, contradict the law and contradict common sense. Their case in chief contradicts common sense. They don't want you to use your eyes and ears for what you see and watch and interpret. And that's why, ladies and gentlemen, they haven't met their burden. Contradicts common sense in key details. And then you wrap that together with two witnesses, opinion witnesses, who are professional second guessers. Their basic case, ladies and gentlemen, is to take a video showing life-saving measures, take a photo of an unborn fetus, wrap that together with two professional second guessers. That's their case. That's what it is. Now, if you feel, ladies and gentlemen, absolutely, if you feel both individually, okay, that they did meet their burden, all right? If they did meet their burden, both individually and collectively, if you believe they met their burden of proof beyond reasonable doubt, then you must go to our burden. Then the case shifts. Remember? Okay. And what is our burden, ladies and gentlemen? Our burden is proof beyond the preponderance of the evidence. A feather more than 50%, as Ms. Stevens told you at home. Okay, that's all. Yeah, I think it's that way. That how much? Proof beyond the preponderance of the evidence. The lowest standard we have in trials in the criminal world. Not the highest, but the lowest. Now, our burden and how we prove it, okay? Our burden and how we prove it, and we accept that burden, and we take that burden seriously. Prong number one, and I call them prongs, but this is a concept that we have to prove, and I apologize if my big head is blocking that. Prong number one, Connor believed his life, or someone else's, was in danger of death or serious harm. That's what we have to prove, prong number one. More likely than not, a tipping of the scales, a feather more than 50%. Prong number two, his decision to use deadly force was reasonable, based on, through the eyes of a reasonable officer, stepping into the shoes of Connor Grubb, knowing what Connor Grubb knew at that time and was experienced at that time. That's what we have to prove as well, those two concepts. Okay? So, how do we do that? How do we determine whether or not he had a subjective belief for potential serious physical injury? This case has nothing to do with whether or not those marks on his shins were serious injury or not. That has nothing to do with it. Okay? That's not it. You don't have to have a serious injury. It's the potential, ladies and gentlemen, for that. Let's examine the first prong, okay? The first prong. What's the first prong? Subjective belief. How is that proved? Well, here, ladies and gentlemen, the government actually proves it for us. That's the type of prosecution we have. They actually proved it for us, the subjective belief. Their expert, Dr. Bauer, I asked him, you testified before September 30th on a roll. Yes. You testified in front of you guys on November the 14th. I specifically asked him, and I quote, about subjective belief. And his answer, and he confirmed it twice, I'm not saying he didn't have a subjective belief of serious bodily injury. That was from their expert, Dr. Bauer. Not once, but twice testifying, I'm not saying he didn't have a subjective belief of serious bodily harm. Their own witness does that for us. Okay? Second way they did it. Second way they proved that prong for us, more likely than not. They, ladies and gentlemen, Ms. Stevens told you to hear words from Connor Grubb in the opening statement. Okay? Never did we expect them. They did the job for us. They put his statement in. They put the words that he wrote down into evidence. They made Connor Grubb their witness. Those words that you hear and see, those are Connor Grubb's words, and the prosecution put those into the fight. No need for us to do that. What were his words with regards to that? Okay. At the time I fired my weapon, I was in fear for my life, as a suspect that had just struck me with her vehicle. That's their evidence that they put in, ladies and gentlemen. Second, I fired my weapon because I believed that I was going to be seriously injured or killed by being thrown from the vehicle and or run over. So have we proven, or have they proven, that the subjective belief of a serious physical injury was in his mind, that it was reasonable at that point? 1,000%, more than a feather, more than 50%, ladies and gentlemen. Their own people did it. Remember the questions that were asked to the different people? What if he tripped backwards? What could have happened to him? What if he fell? What if he was moved off the vehicle in a different way? All the different potential possibilities. Each and every witness said, yes, you can receive serious physical injury. It's not that complicated, ladies and gentlemen. So the first prong of whether or not he had a subjective belief is proven by Dr. Bauer, their witness, and his words. Those are his words, are here, ladies and gentlemen, Connor Grubb's words. Now, did we also add to that? Absolutely. Who did you hear from with regards to that aspect? Each and every officer that they called said, yeah, you've had a threat, you can get hurt. Absolutely. If you believe that, would you respond? Yes. So, have we proven the first prong more likely than not by a feather that he had a belief, a subjective belief of serious physical harm, the potential for that? Yes, ladies and gentlemen, is the answer to that. Now, let's go to the second prong, okay? And the second prong is the aspect of reasonableness, all right? Decision to use deadly force was reasonable through the eyes of a reasonable officer standing in Connor's shoes without 20/20 hindsight. And most importantly, ladies and gentlemen, how we analyze those are the Graham factors, okay? Severity of the crime that prompted the deadly force. Immediate threat, actively resisting, evading. Did you hear Seth Stoughton, the professor, mention those words at all? No. And guess what, ladies and gentlemen? Those three
They're critical.
are in the jury instructions. The judge read them to you. So let's examine each one of them one by one, okay? Because we know that those come from Graham v. Connor. It's not all the legal schooling you're getting or anything like that. That's why your analysis is required. That's why the judge puts them into the jury instructions. That's the law that Seth Stoughton said you must follow. You don't have a choice. Whether you like it or not, you have to follow. Okay? So with regards to that, ladies and gentlemen, the second prong, okay? This is what the prosecution does, ladies and gentlemen. The first one, let's analyze the severity of crime. It's not the severity of petty theft. It's not the severity of shoplifting, ladies and gentlemen. Don't get confused. That's a false narrative. It's the severity of the crime, ladies and gentlemen, that prompted the reaction of deadly force. You don't get shot. Remember we talked about here and that other questions. No one gets shot for shoplifting. That doesn't happen. So to make that analogy and to make your analysis that's just not the right place to do it. So how do we do the first aspect, severity of the crime? Again, the government proved this for us more likely than not, a feather more. How did they do that? Special Agent Douglas. Special Agent Douglas was on the stand, and I asked him, hey,
he's on this man is on a tear, chat.
You have to swear to an affidavit. And on that affidavit, he said, I swore that there were true facts, that the person was potentially committing a robbery or felonious assault on the officer. That's their witness and their lead agent. The specially trained elite force of BCI that responds to officer critical incidents and goes there, and that person said, yes, I swore to a judge of those potential charges. Now, you have to, the trial's not about that robbery or that felonious assault on Connor Grubb. It's whether or not that's a severe potential crime. And each and every law enforcement officer that they called, and Sergeant Moynihan, as well as Kevin Davis, all agree that the potential of fleeing in a car or coming in a car with an officer is a severe crime. Now again, whether she's turning that way or she's knowing what she's trying to do, that's not the issue. That's a false narrative. Is the actual concept. And their own witness, ladies and gentlemen, told you that when he swore to another judge and said, these are true facts. He swore to a judge and said that. And remember what Special Agent Douglas said, I am the collector of facts. He doesn't have an opinion. He's not trying to balance it, unbalance, or anything like that. Lieutenant Rutherford confirmed it was a serious nature. Officer Ferguson from River Park, Officer Sleevey, their witnesses. Again, they proved more likely than not that it was a severe crime, but a serious crime. It's not jaywalking. It's not a traffic ticket. It's not petty theft. It's what prompted the reaction. The reaction of his use of force wasn't prompted because of the theft from the store. It was the car coming at him. It's just not that complicated. All right. Now, we put also Sergeant Moynihan, who said, yeah, I investigate thefts all the time. And yes, absolutely. If someone flees, that's a type of aggravated robbery. Yes, that doesn't mean there's a set of trial that we have to prove that. That has nothing to do with our verdicts. Next was the suspect resisting arrest. We'll break it down, resisting versus fleeing. Have we proven more likely than not that the suspect was resisting arrest? How do we do that? First with Connor's words. How they do it. Sergeant Moynihan told her multiple times, get out of the car. I drew my weapon, ordered her, get out of the car. She did not, and I again told her to get out of the car. Instead of complying, she accelerated the car towards me. That's resisting arrest. You heard from each of the officers. If someone doesn't comply with your orders, you have to now go to the next step. That's resisting arrest. So has the government proven more likely than not that she was resisting arrest? Absolutely. Second, Lieutenant Rutherford. Rutherford is the lieutenant who was in charge of all the videos that they gave the prosecution. He also was in charge of the use of force policy that they gave the prosecution. And he watched all the videos. Simple question. Lieutenant, was she complying? No. That's resisting arrest. Special Agent Douglas, again, watching and listening to everything, indicated she was resisting. And we thank the government for doing that, but then we called Sergeant Moynihan. They didn't. We called Moynihan, and he said between 8 to 10 times, did you hear her? Get out of the car, get out of the car. The prosecutor just claimed that that interaction it was pretty calm. You think it's calm when Sergeant Moynihan is banging on the thing and takes out a weapon to try to break the glass to stop her from going? Would you call that a calm interaction? Oh, gee, maybe they're helping the person undo the car, unlock the car. That was a calm interaction. That's what they do. That's how they shape. It has to fit their narrative because they start from a premise and they work backwards. Also, ladies and gentlemen, we proved it through her actions. What do I mean by actions? Through Ms. Young's actions. We've all been in the grocery store. When an alarm goes off, what's the first thing you do? You stop. If it's you, you're like, oh man, you check your bags. Did the first set of alarms stop her? No. You heard that Mr. Giebler testified from the Kroger. There was a second set of alarms. Did that stop her? No.
Nope.
Did the person chasing after her, the Kroger employee chasing after her, stop that her actions? No. Did Sergeant Moynihan on the side of the car, hanging onto it, banging it, did that stop her actions? No. Connor Grubb standing in front of her? No. She was resisting arrest and not complying, ladies and gentlemen. Why though? Why? It's the question. Why didn't she stop? Oh, okay, here's an inference. She backed into a spot, a handicap spot with no license plate. It is the closest spot to the front door. She doesn't have a handicap placard. Mr. Giebler told you that there was 2 cars that did the exact same thing. We brought that out from Mr. Giebler, not the prosecution. That part. She asked him, did you see the other car? He was like, yes. They don't show you that because they don't want to give you the full picture. So she's back in the spot with no handicap placard or anything like that. And what else, ladies and gentlemen? If she complies and if she says, okay, I won't resist arrest, what happens? You'll have this back there. It's the defendant's exhibit H. What happens? These are her personal items that were on her in the car. There's an ID there. There's a license there. They find out who she is. That's why she resists arrest, because they'll find out who she is. Did they find the other 2 people using facial recognition? They said no. Same thing. No license plate backed in because the setup is there, ladies and gentlemen. None of them are ever going to stop regardless. That's the why. Why not just, okay, officer,
Boom. Exactly.
Why? All the detergent bottles in there, let's make an inference. Do you think that that's for personal laundry? Those 8 or 9 detergent bottles back there, all the how many bottles of tequila in there with the locks on them? You saw all the people in the videos. And you watched those videos back there before, go a little bit before when they started. All the different people.
It's a lot. It's important to care.
Everything like that. It wasn't stopped. Was the suspect evading or trying to flee? Pretty straightforward, right, ladies and gentlemen? Pretty straightforward. Mr. Giebler, he watches each and every video. In his report, he writes, yeah, she tried to get away and hit the officer. Connor's own words, their witness, they put these words in there. Whether or not the suspect was attempting to evade by flight. After Sergeant Moynihan told her multiple times, I think she did not. And again, instead of complying, she accelerated the car towards me. Down here, I stood off the driver's side, right corner of the car. The car continued west towards the Kroger. It veered, leaving. The foot's on, when she was going, the foot was on the gas. And of course, ladies and gentlemen, you see that. You see that in all the videos. You see it. You use your own eyes. We really have to go through this analysis when you know she's fleeing. You know she's resisting arrest. You know that the severity of the crime has been proven more likely than not. We haven't proven those factors more likely than not. They all come down our favor with way down, ladies and gentlemen, with a ton. 3,560 pounds worth, ladies and gentlemen. That's how the scales are tipped here that we've proven that more likely than not. Sergeant Moynihan, yes, she was trying to get away. The special agent, yes, she was fleeing in his report. And why? Again, why? You do that because there's no, you know this video. You know this video in the store. You know this video outside. There's video. So, ladies and gentlemen, the 3 gram factors will be in the jury instructions, I promise you. And Professor Stoughton didn't mention one of them. He did not mention one of the gram factors. because he doesn't believe in the grand factors, and he gives opinions contrary to the grand factors, and we'll get to that. Next, ladies and gentlemen, whether a reasonable police officer placed in the shoes of Connor Grubb, based on what Connor knew at the time, believed the need to use deadly force. It's not should have, it's not could have, it's what that individual reasonable officer could have believed. And again, it's not one choice, this is the only choice. There's multiple, but is that belief reasonable? It's not the action, it's the belief and the need to use force. Is that belief reasonable? Again, the government helped us with this one. Specifically, we asked Lieutenant Rutherford, Officer Ferguson, Officer Sheevely, hypothetically, if they perceived a deadly threat coming towards them, or if it hit them based on their training, what would they do? They would all said they would discharge their weapon and respond to the force coming against them. That's what they said. They all indicated, ladies and gentlemen, that that's how it works. You have a split-second decision to make. I submit their witnesses were reasonable police officers and are reasonable police officers. Sergeant Moynihan, ladies and gentlemen, let's talk about him for a second. There's a man who served his country in the Air Force honorably. 9/11, he goes into law enforcement. 9/11 happens, he goes back into the military, comes out, and for how many years he's been dedicated to serving his community, okay? The important thing there is he trains the people on his force. He trains them. He trains them in Opata. And it's not whether Kevin Davis testifies someone else. Again, that's a shiny object, that's a distraction. It's whether or not Kevin Davis trains in Ohio. Whether or not Kevin Davis trained cadets and recruits in Ohio, police officers in Ohio. Because Ohio has different curriculum than other states. And that's the difference between Seth Stowe and Mr. Davis. It's not about where you testify, it's about where you train people. Where reasonably officer believed the need to use deadly force if a 3,500-pound vehicle was coming at them and hit them. Younger people, when they're being trained, ladies and gentlemen, they learn what is right. They learn what is expected of them. They learn that from the people training them. So when Sergeant Moynihan, who again we called, they didn't call, he's the person with the most interaction with Ms. Young in the entire case. And they don't call him in their case. They don't want you to hear what he had to say. We had to call him. And what does he say about the tactical position that Connor Grubb took? What did he say? He said, quote, it was an effective position, okay? Based on where Sergeant Moynihan was on the side. I said, would you go to the side? No. What are you gonna do there? I'm already there. Other side? No. Crossfire. Behind? No, you can't see anything. Based on the position he took, that was an effective position. Lieutenant Rutherford said that, Officer Sheevely said that, Officer Ferguson said that. They all said the exact same thing. And that's their witnesses. But they don't want you to believe those witnesses that that's a good tactic because the professor says it's not. Okay? That's the issue of the case. They contradict their own witnesses, ladies and gentlemen. They put the law enforcement officers up. And each of them said, well, that's a fine tactic in that situation. Yeah. Are there other tactics? Sure. Is that an effective tactic? Yes. Did they know why Connor Grubb took that position? Yes. They told you why Connor took that position. What was your purpose and reason for standing in front of the vehicle? I positioned myself in front of the vehicle for 3 reasons. First, to convey to Young that he was backing and not free to leave the scene. Effective, and all 3 said that that's appropriate. All right? Second, to provide cover to Sergeant Moynihan as he was positioned on the driver's side of the vehicle and Young was in the driver's seat. Okay? So tactically, now he can see in. If there's an issue with illegal fire, unfortunately, ladies and gentlemen, they have to do these things in their mind when they approach cars. They have to start from the premise that something bad is going to happen. That's how they're trained. They have to try to anticipate situations. So that's why he takes the position. All right? I did not know if she had access to a weapon inside the vehicle. I would need to provide lethal cover to Sergeant Moynihan. Third, with Sergeant Moynihan on the driver's side and the female on the passenger side, as well as other civilians in the busy parking lot, the front of the vehicle is the best position from a tactical standpoint to avoid crossfire. Is it the only position? No. But in Connor's analysis, based on his training and his experience, that's the position he took. And his sergeant who trained him said it was fine. The lieutenant who's in charge said it was appropriate, as well as other officers, as well as Kevin Davis. The only person who didn't was the professor. If a training officer is responsible for giving guidance to other officers below him, and they say it's a proper position, who is a paid witness, an opinion witness? Do they supersede that? No. But that's what they want you to do, ladies and gentlemen. They want you to supersede the people who are on the street every day, who continue to be trained, who go through the process, who deal with the society. They want you not to listen to them, listen to a person who's an academic scholar, a policing scholar, an intelligent academic reviewer. All of them said, ladies and gentlemen, that it was reasonable to take that position. Next, ladies and gentlemen, the other grand factor we have to talk about is a perceived threat. So let's walk through the analysis of, can a car be a perceived threat? Okay. So how do we do that? All right. Can a car be a perceived threat? their witness, Connor Grubb, their witness. At the time I fired my weapon, I was in fear for my life as the suspect had just struck me with her vehicle. My feet were no longer on the ground. My top and body was on the hood of the car. Immediately before I fired, the suspect had ignored repeated commands to get out of the car, and instead of complying, accelerated her vehicle and hit me. The vehicle hit him before he fired, ladies and gentlemen. Okay? That's a fact that they can't controvert. All the math works, all the pictures work, that there was a strike of him and he fired. So a perceived threat in the car, Connor Grubb proves that more likely than not with his words. Okay? But it's not just Connor Grubb, their own expert, an expert. I asked him. A stationary car is not an actual threat, right?
Correct.
A car moving, as you indicated on direct, that the car moved towards Connor Grubb, correct?
Yes.
A car coming towards someone is no longer not a threat, a perceived threat. It can be an actual threat, correct, sir?
True.
Again, the state doing the job for us. Their expert agreeing that can a car be a deadly weapon or a deadly threat? Pretty simple, right? Who else testified to that aspect? Special Agent Douglas, Lieutenant Rutherford, Officer Fergus, Officer Schliebling, Dr. Bauer, we called Moynihan and Kevin Davis, as well as Jeffrey DeMille, okay? It's not rocket science, ladies and gentlemen. Okay, absolutely, a 3,500, 3,600 pound car can come towards you and give you a risk of serious physical harm. So now in the analysis, could a reasonable officer in Connor Grubb's shoes believe that a car moving towards them is a deadly weapon? Based on Connor's words and their own expert, yes. Can a reasonable officer believe that a car moving towards them is a pre-threat? Yes. They put Connor's testimony in, and Dr. Bauer said that, okay? Now, let's talk the perceived threat becoming an actual threat. That's the logical next part of the analysis, right? Okay, I have a perceived threat. It becomes an actual threat, ladies and gentlemen, when there's contact, okay? So the issue is, did the car hit Connor? Okay. Again, state's own witness, Connor Grubb. Instead of complying, she accelerated the car towards me. I tried to move to the right, to the east, to avoid being struck, but the front bumper of the car hit my legs and shins. Okay. But their professional second guessers can never concede that.
And chat, you may laugh at this, but it's about remember, it's sales, it's narrative, it's presentation. You need to be flashy and dashy when you can afford to do it. So having a somewhat sophisticated PowerPoint slide never hurts.
Yeah, because that blows up their whole theory of the case. All right, what else do you see? Their evidence. Special Agent Douglas, lead agent of the elite team, after watching everything, had to write a report. He wrote, rapid accelerate and struck the vehicle, or struck the officer, I'm sorry. Rapid accelerate and struck the officer. Giebler, again in his report, the car hit the police officer. Bauer, under oath, on September 30th, agreed, yes, both feet were off the ground at one point. Obviously, it had to come from the car, all right? And again, on the 11th, or excuse me, when he testified here, November 14th, he said the same thing. But that's, now they realize, ooh, if I say that to the jury, I got a problem. And we'll get to it. If I say that to the jury, why? What did he say, ladies and gentlemen? The word he used, I was standing right here. You don't think you said it contacted him in September 30th? Well, it was more of an interaction. Remember that? I responded, interact with people verbally. You don't interact with a car. Interaction, you look it up, interrelate, interchange, interconnect. Synonyms of interact are
interlinked,
communicated, engaged, collaborate, cooperated, synergy. Do you really think there was synergy between that car and Connor Grubb that day? Do you really think there was collaboration and cooperation?
Synergy.
But that's the word their expert uses because they can't go concede that point. And that's what makes them biased. Do you really think that that's what happened? And ladies and gentlemen, everybody, all opinion witnesses get paid. The difference is your tax money pays for theirs. And you should be insulted with their testimony. Your taxpayers pay for theirs. That's what Dr. Bauer wants you to think, that there was an interaction or synergy. That's an example, ladies and gentlemen, of the government doesn't want you to use your own eyes. They don't want you to use their own ears. They want you not to even use your common sense. But listen to Bauer and listen to the professor on that. No, you heard when Stevens asked him whether or not the car got hit. He goes, I can't say that with a reasonable degree, my level, all that type of stuff. And the other guy said, I'd have to go back to the video. Are you kidding me? It's not that complicated. Ask yourself this when you go back there. It's real simple. Don't you think if Connor Grubb could have gotten out of the way, he would have? Do you think he started off that day helping all these people and the stuff he did, and then decided, oh, you know what, I'm not going to get out of the way of this car on purpose. I'm going to shoot this person on purpose. That's the case. Don't you think if Connor could have gotten out of the way, he would have? Of course, ladies and gentlemen. The test of reasonableness is you have to step into someone's shoes at the scene. Here, ladies and gentlemen, you have to jump into his shoes because his feet aren't on the ground. And that was shown to you. You don't step in them. You have to jump into them. And you're going to have to do it after you've been hit by a car, ladies and gentlemen. After you've been hit by a car. interaction versus common sense. Ladies and gentlemen, we have proven more likely than not that absolutely he had a subjective belief of a threat of a potential serious physical injury. Not the actual injury, a potential serious injury. What else do we have to prove, ladies and gentlemen? More likely than not, the grand factors. And we have proven each of those grand factors to you more likely than not that it was reasonable. Let's go to opinion witnesses. Prosecutor has a curious question. Curious, get one name. It's pretty straightforward that Dr. Bauer and Mr. Davis need to proofread their reports before they send them. You miss a parking spot for Mr. Name? Yeah. Proofread your stuff. But with Dr. Bauer, ladies and gentlemen, why? Why? Why the reason the answers?
Why?
The questions asked. Why?
Why?
How many hours did you work? Oh, I couldn't possibly tell you that. Why? Of course you do. How many hours? I had about 10 hours, maybe more 20, 30. Why? Okay. Did you submit bills? Yes, I submitted a couple bills. How much have you submitted so far? He's not going to tell you. Why not? He knows. Compare that to your everyday life. Compare that to your common sense. Which one of you have submitted a bill and not know how much it's for? If I owe someone money or pay, we know that. That's how we live our lives. You take the number of hours times the number of the bill. It's not complicated. But we can't give you information, ladies and gentlemen. The wordplay. No wordplay. Interact. The hood of the car. Get to that. Hours. Okay, 30 plus. There's 30 clocks there, right, ladies and gentlemen, plus the other times they do that, right? And I talked to each of them about looking at the video back and forth, slowing it down, right? Okay, now Sutton, whatever time he got home yesterday, he gets paid until he gets home and flies, whether the plane gets delayed or whatever. So 40 plus hours, right? That's the time they've had to look at this stuff. That's the time they've had to come up with a decision, an opinion to give you, to testify to. That's the time. How much time did Grubb have to react to a situation? 1.66 seconds from the time the car moved towards him to the time he fired his weapon. That's 1.66 seconds. That's the time, ladies and gentlemen. Connor doesn't get to go back and look at the tape. Connor doesn't go, hey, wait.
And honestly, while he's in the middle of this, I'd sit there and try to do, I've seen this before, and I've tried to do it before when you have like measurable amounts of time. You sit there and be like, put that on a stopwatch. And you sit there with a stopwatch and you're like, deet, deet, and you try to time it out like that. Like, that's how much time he has.
Wait a minute. Hey, what's going on here? Can you comply? Or, do I need to get out of the way of the car? That doesn't happen. That's not how life is when you're an officer. You leave every day and you leave your house and you leave your family knowing you might not come home. That's what they're trained with, ladies and gentlemen. That's the starting point. Wordplay. How about the hood example? I will go over that again with Dr. Bauer. Dr. Bauer, is the left hand near the center of the hood? No. Is it to the left? Wouldn't answer to the right? No. Okay. I can't say that's the center. Well, is it to the right of the center? You all saw the picture. But he can't give that up because if he gives that up, that means that the car hit him. Okay? So he can't give that up. What did he say? I got to go back and look at the tape. There might be some pixel distortion. That's their expert. There might be some pixel distortion when I ask that basic simple question. He would agree with me that the hand is in the center of the hood. Why? There's no why. You know why? It's not complicated. The government started from the premise. They started with Seth Stowe testifying at grand jury, the initial point of potential charge. They had a person testify at grand jury. They came up with a premise that they thought he was wrong. So they start from there and then they went backwards. That's why it's twisted. That's why they can't give you full answers. That's why they can't do that because they're tied to a theory now. You won't do that. You will follow the facts as they lead you and apply the law and keep an open mind because you're not starting from a premise and working backwards, ladies and gentlemen. Let's go to Dr. Desmuller. Okay? Fascinating. Fascinating when I asked him, should I call you Jeffrey or Doctor? Please call me Jeffrey. That guy has 2 doctorate degrees, not just one in biomechanics and kinesiology. He has another one in engineering. 2 times, 2 doctors. No, call me Jeffrey. Okay. What did we ask him to do? Pretty. This is a pretty intellectually hard thing we asked to see. Hey, did Connor have time to get out of the way? You already know that he didn't because he got hit. Okay. But what does Dr. Newman do, or Jeffrey do? He takes math and he takes studies and he compares them and he does it to the synchronization of the evidence that he's reviewed. Okay? What did he do? What did he synchronize, ladies and gentlemen? Okay? What did he synchronize? Okay. He took the 4 cameras and found contact points, the different people stepping, or the shadow of the young person pushing a cart that was right near the area. He synced those up. Then he synced them up with the audio from both body-worn cameras. So those are the different lines. The bottom is he synced up, get out of the car. The black and the blue make those. Okay? Now what's important here, ladies and gentlemen, is he was asked, well, did you start your analysis at 10 seconds? The time when Connor...
Oh, no, chat, they shut it off.
Contact on the hand was 2.5 seconds before the shot, okay? The next one, the vehicle starts moving. Remember, that was continuous movement. Continuous movement, because the car had started and stopped. So he didn't start from them. He started from when he put his hand on the hood, and then there was continuous movement. And then there was body impact. They couldn't ask him, are you sure? He didn't think it was an issue. And he actually said no one's contesting the car contact hit him. It was like revolver. And so then it was 1.6 seconds, ladies and gentlemen, from the time of impact until the shot. And then remember when he depressed the left hand in the hood, you see the depression go down in the hood. So that was 0.8 seconds. So that's the timeline he worked with. Sure, you could go back to 10 seconds, but it's not relevant. Sure, you can go back to a minute and a half where he was before that, but it's not relevant. And that's what he told you. So what does he do at that point, ladies and gentlemen? Well, he synchronizes the videos. And what does this video show, ladies and gentlemen? Remember this one, okay? And look at the time thing up top. This is the time from when the car started the continuous movement until it hit Connor Grubb. Now he's slowing it down frame by frame, okay? He's slowing it down frame by frame. Watch the body. Now, they claim he stepped forward. Dr. DeBoer, Jeffrey, said, no. He said, the way the body is constructed, the way you're connected, because there was force down here, that's why you see this going forward, but the other part going back. This going forward, but the other part going back, because that's how the biomechanics work with the body, okay? So he had to determine a time of contact from the first continual use of force, okay? So we have roughly 0.47 seconds. Everybody with me? Okay. So then he just used math, ladies and gentlemen. He just used math, okay? There was a study. It was turned over to him, the footnote in the expert report. In the study, they did young people and the time that they can take a step, okay? In that study, they said a time that someone can lift their step to take it, okay, was 0.53 seconds. It's not a step forward, because he said that wouldn't apply here because he didn't step forward, the body got hit. It's not a step backward because you might fall or trip. So that's why they did it to the side. And a young person, a fit young person, it was 0.53 seconds to do that, okay? Now, what do you do in that situation? You have to know from the center line of the car, that's why I asked the question, center line of the car to the end of the right side of the vehicle was 91 centimeters. And this chart showed in order to move 91 centimeters, you'd have to take 2 steps, 1, 2, to get out of the way, okay? And you have to do that within 0.47 seconds. What's larger, 0.47 or 0.53? That's 1 step. What's larger, 0.47 or 0.53 times 2, which is 1.06, 1.06. So mathematically and physically, the video, he's showing you that it's impossible to get out of the way. He couldn't have gotten out of the way. But you already know that. Now, so in Connor's case, height weight is 0.73 seconds. 0.73, 1 step, another step, it would be 1.46 seconds to go. Again, much bigger than 0.47. It's not complicated, ladies and gentlemen, and you see it with your own eyes. And that contact, that hitting of him, doesn't have to cause serious physical injury. That has nothing to do with this case, ladies and gentlemen. It's the potential to cause that. So what did we ask him to do the second time? What was the second analysis? What was the second analysis? The second analysis, ladies and gentlemen, was, is there a risk of serious physical injury from being hit out of a car or being carried in a car, moved by a car and stuff like this? Yes. Okay, you got the chart. Now, again, the distraction, that car can go from 0 to 20 miles an hour in 1.8 seconds. And that fits the timelines here. Is he saying it went 20 miles an hour? No, no one's saying that. But at 20, it could be this type of injury. At 15, you get at 10, 6, 4, all the way down. And even at the least amount, ladies and gentlemen, that car could run over his foot. That car, if it trips and does something, can cause serious physical injury. But how else do we know that in a practical, everyday sense? So that's math and videos and studies. Let's apply the practical sense. Who'd you hear from that we call? Sergeant Moynihan. What Sergeant Moynihan tell you? Hey, yes, unfortunately, I know that a car can cause serious physical injury because I was on my thing and I went to take a turn. I went through a crosswalk and I bumped somebody in a crosswalk. How fast are you going? Because I think I was going about 8 to 12 miles an hour. And then I found out the person had a fractured leg. I was worried about the head because the person got knocked over the head. But so again, you know that. Practical stuff from a reasonable officer who tells you, yeah, if I bumped into somebody and caused serious physical injury to them. It's common sense, ladies and gentlemen. Other opinion witnesses. Let's go through them. Kevin Davis. It's not the testifying where it's the years in law enforcement. He has done every single thing that you can do in law enforcement. He has trained, he has been heads of things, different divisions, but more importantly, he's trained at Ohio and he trained at different places across the state of Ohio. He told you how many times he consulted. Most importantly, he told you he's testified for officers and against officers. Both. He's turned us down when we've set in the use of force. He's testified against both, for and against. You think it's hard for him to testify against an officer saying it's not a good use of force? No, he said he compartmentalized. And he told you under oath he testified for officers in trial and against officers in trial. He's told you how many things, but the most important thing he told you, ladies and gentlemen, was the Graham factors, because he's required to. He's required to go over those. Seth Stone doesn't believe he's required to go over those. Seth Stone, a part-time law enforcement officer in total of 5 years, who says, I'm a legal scholar, I'm a policing scholar, I'm an academic scholar, okay? he's never trained any law enforcement officers in Ohio. And the prosecutor said, do you train people now? And his first answer was, yeah, I don't train line officers anymore. I train management. Management is like Lieutenant Rutherford and Sergeant Moynihan, because those are the people that have to review and discipline officers. Okay, discipline officers. Right? So that's what they train. That's what he trains. He doesn't train line officers. That means the everyday training, the people who come into contact with society. And Davis said no. Stoughton said no. Bias? We'll get to the bias, ladies and gentlemen. That's easy in this case. When you compare the professor to Kevin Davis and experience in training and use of force, it does bring to mind the review of the professor. Those who can do the job, do the job. Those that can't do the job and choose to leave law enforcement and go in academia, they teach, okay? They teach. That's Seth Stoughton. Kevin Davis lived it, experienced it, learned it, trained it, and kept going with it. That's the person they had testify at grand jury. You heard about grand jury. There's no judge. There's no defense attorneys. There's no common court. There's no anybody. They control everything that happens at the grand jury. And the burden of proof, the lowest probable cause. And that's how we're here, ladies and gentlemen. The biggest hypocritical situation is that he contradicts, ladies and gentlemen, what the law is. He sat there and told you. Ms. Stevens asked him, you're aware of State v. White. State v. White is a case that allows criminal cases in Ohio, the grand factors to be applied, and they have to be applied. And she put a footnote up there. And the footnote said, yes, you cannot use tactics that say you should use another tactic. You cannot do that because that's hindsight 2020. That doesn't matter to him. He contradicts the law. A federal appeals court told him, Ms. Stevens put the thing up there, this court, an appellate court of multiple judges said, your application of the law is incorrect. And his answer was, yes, it was incorrect. That's their witness. No matter what he says, ladies and gentlemen, Hunter Grubb had the right legally to be there. And you'll never hear anybody argue against that. And you won't. You'll hear about policy and tax. And they don't. The one thing you won't see in the jury instructions is policy. The one thing you won't see in the jury instructions is tactics, ladies and gentlemen. That's his phrase. If Professor Stoughton wants his theory and his phrases to use, ladies and gentlemen, then he needs to become a Supreme Court justice. He needs to convince 4 other Supreme Court justices of his way. But until then, he has to follow the law just like he told you guys have to follow the law. It's wordplay, ladies and gentlemen. That's what they do. They twist it and fit it. Wordplay. Let's go over some of the prosecutor's wordplay in their opening. They have this theory that somehow Connor Grubb got his injuries on his shins from falling on the ground. Okay? Ms. Claypool asked the medic, the Polish medic. This is a medic now who trains every day of his life to help people, treat people, think. They call him a medic for a reason because they give service. They respond to emergencies, and they have to bandage them. They have to get him to the hospital. They have to report and stuff like that. And she asked him, could he have gotten those if he fell to the ground? And there was a pause. He said, "Man, you don't fall on your shins." Okay, she wasn't expecting that. They don't fall on your shins. Okay, well then, geez, how could they have got the injuries?
It's very good.
All right, you know what? The glass. We see Neil in the video, so there must be glass. It must be from the glass. Okay. Well, I asked their expert, Dr. Bauer, in that picture where he's kneeling, my client's right knee's on there. Do you see any glass? No. Who is kneeling longer? He or Sergeant Moynihan? Sergeant Moynihan did most of the life-saving measures once they removed Connor. Okay? And again, it just keeps going and going, ladies and gentlemen. Connor Grubb, you'll have this back there. Blood on the right knee. Close up, blood on the right knee, right? Sergeant Moynihan. Blood on the right knee. Blood on the right knee. Both were kneeling in the same area. You'd expect that, right? It's collaboration. It's confirmation. Okay. What's the difference between the two? One got hit by a car and one didn't. So you really think Connor Grubb is going to get these injuries by falling down the way he did, even though he fell on his hands? The video show. That's the word play. Well, geez, they debunked the glass. They debunked the falling on the shin. So it must have happened when he fell to the ground in that video. You see the video, ladies and gentlemen. His hands hit the ground and his feet, his knees and shins never touch it. It's a distraction, ladies and gentlemen. It's a false narrative.
Absolutely kicking ass.
To the ground. You saw the video, ladies and gentlemen. Multiple examples. This is again, we talked about this briefly, more wordplay. Twisted, because they start from premise and we're back. Where is his hand there, ladies and gentlemen? It's pretty much near the center line. Maybe to the right, absolutely. And what did Bauer say? Oh no, I have to go back and look at the cameras.
Oh, I agree. That's about centers the hood. He's about it as middle of the car as you can be.
Distortion. Even their own expert, Stone said, no, dead center car. He was dead center. Because he needs to use the word dead to tell you guys that. A fair witness wouldn't play word games like that, ladies and gentlemen. You shouldn't believe a witness who plays word games like that would evade the truth. And the judge already instructed you, if you don't believe part of it, you can disregard all of it, believe whatever part, never not part you want. Timing and reaction is a huge part of this case. Whether it's 10 seconds that they want, whether it's 1.66. In this case, is that every officer, when they're faced with a critical threat, they have to decide whether or not to respond in an emergency type situation. Davis and DeNewland say it's 1.66 seconds. I think Stoughton has it about 2.06 from the time of the contact or him walking around, they're experts, to the time he fired the shot. Okay? Now, but the difference, when officers go to train, you heard me ask them about the shoot, don't shoot scenarios. They know they're going. Hey, time to train, guys. They drive out to the course. And they know what the concept is, and they do that. When they leave their house every day, they don't know they're going to be in an emergency situation. And nor do we, ladies and gentlemen. We don't know that as well. We all think we'd like to respond properly in an emergency situation, right? We had one of those last week, ladies and gentlemen. We had one. Take a look at our response. We have volume up to this one. Thank you.
Oh no, chat! Another fire alarm. They're trying to stop you. Oh no, chat! They're trying to stop us. That's pretty embarrassing. Here we go.
In the back.
Attention! The prosecutor is gay.
Emergency. In the back, you hear that. Is there any way to turn that up?
DSP is incoming. Yes. N-word alert! N-word alert!
Relax. What's going on? How much time is it? No, everyone's looking around. Yeah. Finally. Think about emergency. Good go. 5 seconds, 30 seconds. You guys, that puts it in context, ladies and gentlemen, what officers have to deal with versus what we have to deal with in our everyday lives. How many times have you been drilled?
T-Rock bad 3,000 inbound.
Kindergarten, grade school, middle school, high school, church, work, different buildings you work in, colleges. They all have fact that you've been trained. We all think we would do better. No, ladies and gentlemen. But they want Connor Grubb to be superhuman. They want Connor Grubb to take a position somehow maybe above the car so he's not in the way of it and somehow be able to see everything. And how dare they try to say that what he can see or can't see. He put in his statement what he could see. Ladies and gentlemen, I showed you in the report here a divided attention thing. I had you focus on something. And half of you didn't see the grill going through. Okay? That's how the brain works. Their own expert talked about narrowing, talked about what happens. Just because it's on a camera mounted here, it doesn't mean that Connor saw it. It doesn't mean that he saw any turning of the hands. It doesn't mean he saw a turn signal. And how dare they try to say that he did it? That leads us to Connor's words. I'm almost done with this one. That leads us to Connor's words. Okay? It's important. The objection personally, it's important. Connor's words and actions. Okay. Everyone in this case, we talk about hindsight bias. We talk about here about that, right? Everyone in this case testified using hindsight bias, except when they put Connor Grubb's statement, because everyone else reviewed and watched the video ahead of time. Connor gave a statement. It's part of the protocol that they do between these types of officer-involved critical incidents. Okay? Connor gave the statement he remembered based on that situation, that time. And you heard, especially you say, we don't make them do it right away. She keeps saying 2 months later. They do that on purpose because when you're in a traumatic situation, you don't remember things correctly. So he gave a written statement, and you'll have it back there. And then the bottom of the statement, he says, I had the opportunity then to listen to watch the body-worn camera and to listen to it. These are the things I don't remember. Did he put the statement? How do you know he's telling the truth? Because under the prosecution's theory, if you watch the video and audio, aren't you going to put down exactly what happened? No, he's so truthful and honorable that he gave a statement first. Then he said, oh, I watched it after an audio, they allowed me to. This is what I missed when I watched the video in that. He's being a human being and honest and truthful, but they don't want you to believe his words. And they want you to try to believe that somehow he watched it first, then did it. No, ladies and gentlemen, they can wordplay all they want on that. That didn't happen. And important, the timing. Seth Stoughton was retained at grand jury. A year later, the case gets indicted. And remember what the special agent said about timing? All the reports he gets, November, he writes reports in November, December, all this got to him. Connor Grubb's words in November, early December. Okay? It doesn't get indicted until next August. We don't get any discovery or anything until they give it to us. Because the special agent has to give it to them. They then have to give it to us. We give it to our experts and stuff like this. Every single person that testified saw all the evidence before they testified, except Connor Grubb, and they made him a witness.
Objection. Overruled. Closing argument.
their witnesses.
They're also the defense, so I don't give a shit if they break the
Because
rules.
it's consistent, it's confirmed, and it's the truth, and he tells you. I don't know how many people would say, yeah, here's what I missed in my statement that I now see didn't do that. But they want to use that against him. Not just his words, ladies and gentlemen, but his actions. What were his actions after the use of force? That he was forced in that situation after the use of force. Did he sit around and no. He ran as fast as he could to his thing to get the medic's kit, to put a chest seal on. He ran as fast as he could and back. Those are his actions. Afterwards, she tried to run me over. You hear one and say, yeah, I know. Duh. Then afterwards, he tells the fireman, yeah, look, do you have any injuries? Yeah, here, these, they're minor. He asks them, he shows them to you. Ladies and gentlemen, they took a video of life-saving measures, and they took a picture of an unborn fetus at an autopsy. No one's contesting how they died, ladies and gentlemen. And there's a reason they did that, ladies and gentlemen, because they don't have anything else. And they wrap it up with two professional second guessers, because they started from a premise and went backwards. Now, we talk and we're here. No matter, ladies and gentlemen, how much I try to tell you in advance, the effect that the video is going to have on you and the picture is going to have on you, I can't do it. Ever gas? Ever people crying? Absolutely. And you're human, and you should. Because that's real and wrong. That's what you should. But if you find yourself thinking about that, you committed me to here that you will take a breath and go back to the law and the facts. If you see another juror using that in their explanations, law and facts. And there's two tables in the jury room, whether it's law and facts or sympathy, empathy, frustration, sorrow, sadness. That doesn't come into it. And we put you in impossible situations because you're human beings. You saw the corner test. Oh, good. Passes this. Doesn't affect it. Okay? It affects us. How did we get here, ladies and gentlemen? How did we get here? We get here because they built a case around bias. They started with hindsight bias that Connor did something wrong, legally he was allowed to be, and every single police officer testified there was a proper tactic. They built their case around that. Why? Because they had bias from their main witness, the professor, okay, who testified at grand jury. You heard what Ms. Stevens asked, right, ladies and gentlemen? Pretty simple question. Do you think this is biased or not? How many times have you testified against the police officer saying that their force was not reasonable? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. 15 times. One, in the Kroger case, there were two officers. The officer got shot and killed. He still said it was an improper use of force. That's their person. Ms. Stevens kept asking about, what, don't you think expert witnesses can have throw bias to the jury? No. Okay. Easiest question that was asked of him. Easiest question. Have you ever testified on behalf of a police officer in a criminal case? Zero times. And did you see how he tried to squirrel out of it? Oh, well, with these kind of constraints, with these kind of restrictions. It's a pretty simple question she asked him. Have you ever testified in a trial on behalf of a police officer? The answer, real easy, is no. When he says, oh, don't stand in the vehicle. How about answering, yeah, no, 0. Sorry, haven't. 15 versus 0. You don't think that that's bias? You don't think that that's starting from a premise and working backwards, ladies and gentlemen? They started, who did a thorough investigation? Agent Douglas. He gathered all the facts. But because they started from a premise, ladies and gentlemen, they can pick and choose what they give you. Agent Douglas listed for them the 4 most important persons or witnesses that were pertinent to this case. Sergeant Moynihan. Did they call him? No. The Kroger employee outside the car that you see, did they call her? No. The suspect's, the deceased sister, did they call her? No. The only person they called who was listed in top 4 was Connor Grubb. They used his words and made him their witness. Ladies and gentlemen, there were 25 civilian witnesses that were interviewed. They were interviewed, either they were in the store, in the area, just outside the store, or in the area. 25. They put up a witness that was facing the wrong way and didn't see anything, but heard something. Doesn't know what she heard. She heard some loud stuff, and then she heard a shot. That's the civilian witness they put up. Because they pick and choose, because the other witnesses don't match their starting from a premise of working backwards. The person that had the most time with Ms. Young was Sergeant Moynihan. They didn't want to have a full picture. They won't. Mr. Stevens told you in opening that this is basically the whole theme of the case, ladies and gentlemen. This is the theme. An immediate threat to an officer or others of serious physical harm or death will permit to respond with deadly force. That's the question. That's the theme. The next paragraph, if you read it to yourself right now, that's in your jury instructions, word for word. You know what's not in your jury instructions? You know what you won't find in your jury instructions, ladies and gentlemen? Professor Stout, officer created jeopardy. And he kept saying, well, it's just a term. It's not relevant. If it's not relevant, don't use it. You know what else is not in the jury instructions? 16 different phrases he used to call Officer Grady Jeffrey. I just gave you 5 or 6 of them here in different topics. Tactical restraint. He used tactical restraint. Tactical risk. Tactical benefit. Unjustified risk taking. Least intrusive. None of that will be in your jury instructions. None of that. None of it. None of it. You know what will be in your jury instructions? The grand factors that the judge already read to you. The severity of the crime, immediate threat to the safety of the defendant, the police officer, or others actively resisting or attempting to evade arrest by flight. There's a reason they're in there, ladies and gentlemen, because it's the law. Their own expert doesn't even cite the law or tell you about it. He uses different phrases to couch it. And you just go, why? Why, ladies and gentlemen? Why would he do that? Why would he do that? Because they now want to say, oh, because there's a policy, because there's some kind of policy that, that can go. No, ladies and gentlemen. And you know what? Their own witness, who they put on to get the policy into evidence that they I can show you, was asked, is this a violation of policy? Their own witness said, no, he's lieutenant in charge of it because it wasn't feasible for him to get out of the way. Their own witness. But again, their witnesses collide with one another, but they don't care. If something doesn't, as a moderator, if they conflict, ladies and gentlemen, that's not proof beyond reasonable doubt, and it definitely shows that we've proven more likely than not our burden. Every officer testified. Lieutenant Rutherford, Minerva Park, Peter Ferguson, Western Officer Sleepy, Sergeant Moynihan, that it was reasonable. They all told you you're committed to use force when you see an immediate threat. And they told you the car hitting you was an immediate threat. Why? This is why I don't understand why. Then, figured it out. The last question that they asked their professor, their legal scholar, their last question, ladies and gentlemen, it was the only time that he was scholarly honest, academically honest, policing expert honest. And I was shocked when I heard the answer. So just be sure, I got the transcript from the court. And I apologize, I have to put my glasses on to read this. This is why they can't concede on that the car came in contact with him. This is why they can't do an assent. This is why, because if they say he got hit, this is what happens. Question by Mr. Glennon. Is there a time, according to generally accepted practices and principles, where it would be deemed reasonable to shoot at a moving vehicle? Answer, yes, absolutely. He gives 3 examples. The other possibility is when there is no feasible option to address the threat of being hit by a moving vehicle. There's no feasible option. That's this case. Their own expert just proved the case for us. Is there any other option feasible before being hit? We know there wasn't here because he was hit, ladies and gentlemen, because he was hit by the vehicle. So their own expert confirms for us that it was reasonable. Is there a time, according to generally accepted practice and principles, where it would be deemed reasonable to shoot a moving vehicle? Yes, absolutely. The possibility is when there's no feasible option to address the threat of being hit by moving the vehicle. Being hit, that means before you get hit. Here, it was 0.47 seconds till he got hit, ladies and gentlemen. And we've proven to you both by video and by math in the studies that he could. We have met our burden more likely than not. We have proven that he was allowed to defend himself because he believed he was in danger. He perceived the threat that became an actual threat. He was hit by the car. Defending himself with reasonable, in the eyes of a reasonable police officer, not standing in counter-struck shoes, but in his shoes, being struck by a car. That's your analysis. You now have to put your analysis, not standing in the shoes 10 seconds ahead, but standing in the shoes when you get hit by a car. There's only one verdict here, ladies and gentlemen, and that is that our client, ladies and gentlemen, is not guilty because we have proven to you, more likely than not, that it was reasonable belief and that he acted reasonably. I thank you for your time. I thank you for your patience, and I wish you Godspeed in your deliberation. Thank you very much. Thank you, Ron.
Armin, how are you doing?
Well, that's one way to end it. I mean, that's one way to end this. Ooh. Well, let's keep going. We're almost done. So here we go. That was very effective. That went on long, but you know what? I don't know how long he went, and it didn't feel like he went that long. And that's how you know it's good. It didn't feel like it was that long, even though it really was long. That's a sign of a good cross.
To put this piece of paper away. Do not discuss this case among yourselves. Do not permit anyone to discuss it with you when you're present. It is your duty not to form or express an opinion in the case until it's finally submitted to you. Probably about 10 or 15 minutes.
All rise.
Okay, we got some comments to catch up on here. Shredder S07 for $4.99 says 1.6 seconds interlinked. Yes. Bella is correct. When there were more lynchings, stuff didn't happen. I agree. Can you imagine if that was your my professor post? Yeah, that would be hilarious. It's like the meme goes, I did that. Manny B says, I don't understand sausage and dressing. You mean sausage like it's stuffing? Oh my god, 2.0 stuffing. I don't know if you call it dressing. Oh my god, it's so good. Oh, it's got sausage in it. EDW says, rip Erica. Rip to a real one. So, yeah, sausage and stuffing, yeah, is amazing. Okay, nice is a short trial for once. Well, we're not done. The state gets to go and shit up everything with their rebuttal argument. So here we go. Which I don't think they should get. But
Good afternoon. Check my watch there for a second. Before I get too far into what I have to say, I don't think you'll be too surprised that Mr. Collins and I don't agree on a whole lot. I want to talk about something that's fresh in my head, and that's the last thing that defense counsel talked about before he sat down, and that was the testimony of Seth Staunton, Professor Staunton, one of the state's experts in the case, and he had transcript in his hand, and he had read off a question to you that Mr. Staunton was asked about something to the effect of, is there ever a time when it would be reasonable to discharge your weapon at a moving vehicle? And first, let me say this: you are obviously the jurors in this case, and you will all use your collective memories as to what the testimony was and was not. There's going to be instances where the parties disagree as to what the testimony perhaps was, what a question was, what the wording of an answer was. But you, as the jurors, part of your job will be to determine, based on your collective memories, what exactly was the testimony in this case. But when we talk about this question that was asked of Mr. Staunton, is there ever a time that it would be reasonable or justified to discharge your weapon at a moving vehicle? Mr. Staunton had answered, when there's no feasible option to address the threat. He also went on in that answer, I believe if you use your recollection, to describe scenarios that he was talking about where there would be no feasible option. One was, I think, a mass crowd or someone just plowing through a crowd of people was one of the scenarios. And the other scenario was when someone is in an alley, that's the one that defense counsel had referenced. But the rest of his answer wasn't just when you're in an alley. He described it as being when it's a narrow alley and you have no other way out. In other words, there's a back to your wall, a wall to your back, and two narrow walls on either side. And essentially, discharging your weapon is the last resort. You're going to get hit no matter what. So let's discharge our weapon, I guess, just in a prayer that it may do something. That's the way he described it in his answer. I think if you use your recollection. But that's something that we're seeing a lot in defense closing. And when I say we're seeing a lot of not giving the full answer, cherry picking words and statements to fit their purpose. It's disingenuous, but more importantly, it's a distraction. I want to talk a little bit more about that. You also heard defense counsel talk about the video that you saw at the very beginning of the trial during voir dire, or jury selection that the defense did. They showed this, I guess I'll call it a kind of a social experiment type video with the gorilla. And I think we all remember that. You were told to concentrate and watch the people in the white shirts. And you were told specifically to concentrate on counting the number of times that the people in the white shirts passed the basketball back and forth. You remember that? And I think we played the video, or defense counsel played the video. And when you focused your attention solely on the people in the white shirts passing the basketball and attempted to count those number of times, many of you, I think it's fair to say, did not see the gorilla enter the room. However, something very different happened when the video was shown for the second time, if you recall. Because before it was played the second time, you were told what? You were told, look for the gorilla. Look for the gorilla. You remember that? After you were told to look for the gorilla, you no longer focused on the distractions created by the people in the white t-shirts. You were not focused on those distractions. Many of you could clearly then see the gorilla on that second time. The point being, ladies and gentlemen, when you're told ahead of time to avoid those distractions, you're able to focus on what really matters. And that experiment that you were showing, that video, it was the gorilla. And when you kind of ferreted out those people in the white t-shirts because you knew they were distractions, you were able to focus in and see the gorilla. And there's a parallel going on in this trial. And there has been for the last 3 weeks. What do I mean by that? The gorilla, for purposes of this trial, I submit to you represents this defendant's actions. His unreasonable and his unjustified use of deadly force in shooting and killing Dakaya Young and terminating her pregnancy. That's the gorilla. The people in the white shirts, the distractions, those are represented by the things the defense attorneys are asking you to focus on in an attempt to distract you from the important evidence in the case. What types of distractions am I talking about? Well, I just spoke of one a few moments ago, and this question and answer was that stopped and not giving you the full answer, distracting you away from what the actual full answer was. And it revolved around feasibility. What else is a distraction in this case? Defense expert, Dr. Jeffrey Desmond. We all saw the animation. You remember seeing the animation. The animation created at the last minute that wasn't in his report. Regardless, Dr. DeMolin admitted that his animation was not created based on measurements, not created based on data, but rather was created based on his quote unquote observation of what he saw in the video. I think you'll all remember that. And if you remember, when Dr. DeMolin played his animation, it showed the defendant's feet just kind of gliding over the ground. In fact, in the animation, the defendant's left foot never even touched the ground. Now, Ms. Claypool alluded to this, but first I guess we have to ask ourselves, why would we need an animation to depict for us something that we have multiple angles of video, actual video of the incident? It shows us what happened. We don't need an animation to show us what happened. We've got the video. Why would we have an animation? Because the defense does not like what the video shows, ladies and gentlemen. They're the ones that don't want you to believe your own eyes. They want to replace the video evidence in this case, literally with a cartoon. That even their expert admits is not based on measurements or data. It was especially striking when we listened to Dr. DeMolin's testimony and his animation was shown that he never bothered playing his animation side by side the actual video in the case. That was striking to me. We had to rely on Dr. Bauer to do that for us. If you recall, Dr. Bauer said that he, although that animation was created at the last minute, did have a chance to review it and compare it to the video. And he played both. Dr. Bauer played both for you, one right after the other. And he compared and he contrasted the cartoon with the actual video. And what did we find out when he did that? We found out that the actual video doesn't show the defendant's feet just gliding over the ground. The actual video evidence in the case showed the defendant taking steps to the side. I think Dr. Bauer termed them as like shuffle steps or something to that regard, but you'll use your collective memories to recall his testimony. And not only did we see him taking steps to the side, but we saw something even more definitive. We saw the defendant's left leg planted on the ground, stationary. And as the car moved, it stayed stationary on the ground, planted, not hovering, not gliding, not touching the ground, planted on the ground. And then it would lift to take a step and then plant again. And then lift to take a step and then plant again. That's how we know he was taking steps. That's how we know he wasn't gliding like was depicted in the cartoon. And what did Dr. Bauer tell us about the animation? Remember his words. Compared to the actual video evidence in the case, it's not even close, were his exact words. It's not accurate. Why would the defendant have an animation created? It's not accurate. Why would he present that to you as a jury and try to supplant that for the actual video evidence in this case? You have to ask yourself that. Because of the distraction. It's an attempt to distract you from the actual evidence in this case. Do not allow yourselves, ladies and gentlemen, to be detoured and go down the roads of these distractions and waste your energy on them. Because when you do that, you're not going to be led to a true just verdict in this case. What else is a distraction? Well, if we continue with Dr. DeMolin, the defense counsel talked about this as well. We saw that other chart he put up with injuries that could be caused if a vehicle is traveling at a speed of greater than 20 miles an hour. Well, we know that's not this case. I mean, to be fair, there's not been testimony as to the exact speed of Miss Young's car as it was traveling and moving forward. To be fair, there's not evidence of that. But I think the video shows us it wasn't going 20 miles an hour. In fact, it had just barely started to move. And it inched forward at one point and then stopped, become stationary. She's cranking that wheel to the right before it begins moving again, rolling forward, ladies and gentlemen. It's not accelerating at 20 miles an hour. So why are we talking about injuries caused at speeds over 20 miles an hour? Has nothing to do with this case. Can a car cause serious physical harm to someone if it's going 80 miles an hour? Yeah, but that's not this case either. It's a distraction. We heard questions from multiple witnesses about doing second laser scans. Remember that? Replace the car, like repark it back in that handicapped spot. And defense counsel had asked Special Agent Matthew Austin, the lead evidence technician, if you will, in the case, well, why did we put the car back and do a laser scan? And what was Special Agent Austin's answer? He said, well, a laser scanning device is a precise instrument that measures in millimeters. And we can't just replace or repark something. It wouldn't be fair. It would be a guess, basically, guessing where something was located. It wouldn't be accurate. Defense counsel didn't like that answer. They pressed harder with Special Agent Austin. Until finally, Special Agent Austin said, well, I guess I could have just made up evidence, but I wasn't willing to do that. We've seen a little bit of a theme here in terms of the defense wanting to create or make up evidence to fit their narrative. Thankfully, Special Agent Austin wasn't willing to do that. It would have been accurate. It's a distraction. You heard talk about the car being backed into a parking space. There's no question that Ms. Young backed her car into a parking space. The video shows that. I don't think that's up for dispute. A lot of people back their cars in their parking spaces, but we also know that Ms. Young, to be fair, stole liquor from inside that store. But we told you that in opening statement. No one's contesting that. Is it possible she backed in so she could make a quicker getaway, if you will? Absolutely, that's possible. We don't know, but certainly that's possible. The question is, how does backing into a parking space make your shooting and killing of her more justifiable? How is that more justifiable than if she would have just pulled in front of criminals? It's ridiculous. It's another distraction. In opening statement, the defense spent a lot of time. They had a slideshow. Ms. Stevens had a slideshow, a PowerPoint, I guess I'll call it. And she spent several slides showing you individuals in the Kroger parking lot whom the defendant had to discharge his weapon and shoot to Kaya Gum because he was in fear of all these people in the parking lot being in danger of death or serious bodily harm. Remember that? She circled like, I don't know, 7, 8 people up on her photographs. Why did they do that? That kind of fizzled out. The notion that he fired at Takaya Young because he was concerned with other people's safety in the parking lot. Probably because in his own written statement, he never mentions being in fear for someone else's safety, to include Sergeant Moynihan's. But why would you do that? Why would you take the trouble of circling people and making that claim? Another distraction. We also heard a lot of talk, ladies and gentlemen, about the concept that the defendant did not have enough time to avoid being struck by the car. How much he would allegedly need in terms of time to step out of the way, relying again on Dr. DeMolin and his charts. We've heard 0.53 seconds for a step, 1.66 seconds between the time the car moved for the second time and the time that the shot is fired. First of all, the math, well, you do 0.53 plus 0.53 is 1.06, it's less than 1.66. Okay, that's for starters. But set that aside because it doesn't really make a difference. What did we find out on the cross-examination of Dr. DeMolin? We found out that his starting times were based on the time the car moved for the second time. And we know the car moved twice. We found out that he conceded, yeah, if I would have started my timing previously, for instance, whether it's when he moved in front of the car physically himself, or whether it was the time the car moved for the first time, it would have added more time for him to be able to get out of the way. He also conceded because the car was actually turning to the right, as opposed to going directly at the officer, that would also add more time for him to be able to react and move. And we know that the car turned to the right. We have eyes, we can see the steering wheel and the tires and the angle it's taking. At the end of the day, the timeline of Dr. DeMolin is worthless, ladies and gentlemen. It's conjecture and it's speculation. And what's more, what are we even talking about here? They're asking you to believe that somehow the defendant would not have had time to move out of the way before being seriously injured by this vehicle. but we know he did just that. He did move out of the way. The video shows us that. Distraction. We also heard talk about how motor vehicles are the #1 cause of death to officers here in the United States of America. I think that was asked by defense counsel of every officer that got up on the stand. Are you aware that motor vehicles are the #1 cause of death? And the officers, without hesitation, yes, sir. We saw that. But we then saw their own expert, Kevin Davis's chart, which tells us that's not true. Do they cause deaths of officers? Absolutely. I don't mean to downplay that. I think his chart in the last 10 years even showed that 47 officers were killed by motor vehicle. The point being that firearms killed 480, okay, over 10 times more. And it's not fair to get up and ask officers, isn't it true that that's the #1 cause of death? When you know it's not. Your own expert gave you a report saying it was like 4th in line. Why would you do that? Let's talk a little bit about the experts in the case. Both sides obviously presented expert witnesses in the case, ladies and gentlemen. You'll have to decide what they believe and what weight to give to their testimony. That's your prerogative. Kevin Davis, in his opinion to you and his testimony to you, essentially told you that everything the defendant did was appropriate. He said that everything the defendant did was well within accepted police practices. Everything the defendant did was within the Blendon Township policies. He basically accepted everything the defendant said had happened as being true without even going back and looking at it. He picked and he chose portions of the defendant's written statement to include in his report while leaving other portions out. I think you'll remember that. And then he cherry-picked still photos from the body cam video to support the portions of the defendant's statement that he chose to put in his report. When I asked him about the portions of the defendant's statement that he failed to put in his report, do you remember his explanation? I asked him, well, what about the defendant's words in his own written statement when he says the top half of my body was on the hood of her car? We didn't see that in any of your still photos, Mr. Davis. And he said, well, I interpreted his words to mean that his torso was over the hood. He was now floating over the hood. He's now interpreting the defendant's words for us. I also asked him about the defendant's words in his statement to Nick Adams, the medic, which at nowhere appeared in Kevin Davis's report for a reason, by the way. I look at that in a minute. But wouldn't it be important if you were Kevin Davis and you're being paid this money to evaluate the words that the defendant states as to how the events transpired and what happened to make him fire his weapon and kill a person? Wouldn't it be important to have all of those words and evaluate all of those words to the video and the still shots that you're going to be producing in court and testifying about? But he didn't want to do that. He didn't do that. In fact, he left out the statement to Nick Davis, the medic, entirely. And that was when the defendant told Medic Davis that he was thrown off of the hood of the car and onto the ground. And I asked Kevin Davis about that. Help us out, Mr. Davis. That's not in your still shots. Nowhere in the video you see him being thrown off of the hood of the car and onto the ground. Did you remember what he told me? He had a little trouble answering that question at first, and then he finally stated that he interpreted again those words to mean that the defendant was, quote, repelled by the vehicle and thrown onto the ground by landing on his feet. I don't even know if that's a serious answer, but that was his answer to the question. This is an example, ladies and gentlemen, of someone who, no matter what the facts are, no matter what the video evidence shows, he's going to twist it and interpret it as being consistent with what the defendant said happened. That became very clear. Kevin Davis is not an expert, he's an advocate on behalf of the defendant. And there's a difference. Experts are here to provide information that may be useful to you. Advocates twist the facts. What else did we see? We saw in his report, again, this has been talked about, but those names, I put it side by side. He had an officer, Anderson, and a Mr. Lewis as the deceased. And then he had switched it to be Officer Grubb and Takaya Young. And I asked him, is that just a cut and paste there? Because what was probably more interesting than the different names was the verbiage, and the opinion was the exact same. The exact same from some other report that he'd done in one of these types of cases. He finally did concede at one point when I was cross-examining him, and that was he admitted that if the defendant's description of events that led him to fire his weapon until killed Takaya Young were determined to be untrue, that would affect the reasonableness of the threat that he claimed to receive. He did concede that point. And that's exactly what we're dealing with in this case, ladies and gentlemen. We're dealing with an attempt by the defendant to justify his actions after the fact. What did Kevin Davis not tell you? What did he not tell you? He didn't tell you what an actual reasonable objective officer would have done. We had to wait for Professor Stoughton to come in and give you that information. And there's been a lot of criticism of Professor Stoughton because he didn't testify as to the Graham factors that you should consider, or what Ohio law should be put into the jury instructions. But Professor Stoughton was very straightforward. He said, I'm not here to testify as to what the law that the jury should use should be. That's the judge's job. I'm here as an expert in policing and generally accepted police practices. If you want to ask me about that, you're going to get my answers. But I'm not here to tell the jury what law they should apply. He's very honest. He didn't want to go above and beyond what he was here to do, unlike the Kevin Davises and Demolins of the world. And they want to criticize him for that. That's fine, I guess. Well, at least let's be honest about it. Professor Stoughton told you that in his opinion, the defendant's decision to move in front of Ms. Young's vehicle was unreasonable and not consistent with generally.
This is just hot garbage, chat. This is flailing around. Damn, you guys couldn't hear me for a while now.
Bad idea. Mr. Blake will talk about this. I'm not going to go into it, but essentially he said there's literally no good reason for an officer to position themselves in front of a vehicle if we're talking about generally accepted police practices. And guess what? Blendon Township policy agrees with him on that, despite the fact that they're in Ohio and he's in South Carolina. What else did Professor Stoughton tell us? He told us that just because a suspect leaves doesn't mean the investigation is over. There's other things that can be done, whether it's checking video or getting witness statements, trying to identify the person and going out and perhaps making contact with them and arresting them if that's what's going to happen at a later time. Officers are not authorized to stop persons at all costs. You're a police officer. You investigate the crime, you gather your evidence, and you apprehend the person later if need be. He then quoted State v. Garner, the Supreme Court case, that stated it is not better that all felons should die than one should get away. Officers have to utilize their training to make reasonable decisions, ladies and gentlemen. Reasonable decisions. This defendant did not do that. And his unreasonable decisions actually contributed to the situation that led him to use deadly force. We heard all about that from Mr. Stone. He should not have stepped in front of the car. He should not have drawn his weapon. He should never have remained in front of the car when it became clear that the car may move. And he should never have fired a bullet through the windshield. Not in these circumstances. Professor Stoughton testified it was his opinion that the defendant's decision to draw his firearm and use deadly force instead of simply moving out of the way of the vehicle was unreasonable and, again, not consistent with generally accepted police practices. Now, the defense doesn't like those opinions. I get it. I understand why. And they try to, I guess, disparage him through the teacher reviews and things of that nature. Talk about Sergeant Moynihan just for a moment, because the defense counsel talking about Sergeant Moynihan. Like all officers who testified in this case, Sergeant Moynihan, to be fair, was put in a kind of a unique and difficult position. They're being asked to come into court and testify in a case where another fellow officer has been criminally charged. That thin blue line is being stretched a little bit. Many of them are from smaller departments with just a handful of officers, single digits that work there, that back up Blendon Township on calls. They work together daily, backing each other up. They have to come in here and testify in court, and then probably go right back to their departments to work with their fellow officers, potentially backing up Blendon again that same day. If that's not enough, there's a TV camera in the courtroom broadcasting their testimony to other officers, to other departments. It's not an enviable position to be in as a fellow brother of the other people, let's be honest. Sergeant Moynihan is a member of the Blendon Township Police Department, the same exact department as this defendant. A department that has, I think we heard, single-digit officers employed there. He's a supervisor there as a sergeant. In fact, he was the defendant's own training officer for a while. He worked with the defendant, we heard, 3 days a week, he and the defendant together. I'm sure after he testified, he was probably going back to Blendon Township he was in a difficult position on witness stand in this case. So he admitted the state had tried to reach out and speak with him, but that he had declined to speak with us through his FOP attorney. And that's his right. That's his right. So he came in and he testified for the defense. In his testimony, though, ladies and gentlemen, he said some very interesting things. We have to kind of slow down and think about this a little bit. Sergeant Moynihan had said that when the Kroger employee came out of the parking lot and told him that Ms. Young had stolen something from inside the store, he felt, his words, duty
What the fuck is this? They're trying way too fucking hard here.
bound to investigate it. And he said, I knew it was a misdemeanor theft. It didn't seem like that big a deal to me at the time. He talked about telling Ms. Young, ordering her to get out of the car, and telling her she wasn't listening to him, she wasn't doing that. And he talked about the fact that if Ms. Young had just driven away and left, they would not have even been able to pursue her because of it just being a misdemeanor theft offense. He stated while he was on the driver's side of Ms. Young's car, he recalled the defendant passing him on his left, what he has left on the driver's side, and positioning himself somewhere to the left or front of him, but he wasn't exactly sure where. Sergeant Moynihan told us that he himself did not perceive Ms. Young to be a threat at all. He didn't even have his weapon drawn. He stated that it surprised him when he heard the sound of a gunshot. He said, I wasn't expecting that. And he told us again, I didn't even have my gun out prior to the gunshot. Why are those statements important? It tells us that Sergeant Moynihan did not perceive Ms. Young as a threat. And the fact that he was not expecting to hear a gunshot at all tells us that he was not perceiving a threat the likes of which would cause the defendant to have had a reason to fire his weapon.
That is not what that means.
Sergeant Moynihan also testified that after hearing the gunshot and seeing the defendant with the defendant's gun out, he said, I did the same thing, thinking I might have missed something. Thinking I might have missed something. Why are those words important? Again, it tells us that Sergeant Moynihan saw no reason to have his gun out, but that after the gunshot went off audibly, he pulled his gun out thinking he might have missed the reason why. I submit to you, ladies and gentlemen, that Sergeant Moynihan was surprised to hear the gunshot because he did not observe anything on that day that an objectively reasonable officer would have perceived as a deadly threat from Ms. Young. He thought he missed something for the same reason. Now, we've heard, and you'll have the defendant's written statement with you in the jury room. And let's think about this. Who in this case has a motivation to perhaps lie, perhaps exaggerate about what actually happened in that Kroger parking lot on that day in August? Does the defendant have a motive to do that? If he can convince investigators or jurors that he was justified in his actions, might he avoid accountability? How many of us are really surprised that in his written statement, he writes that he fired his weapon because he believed that he was in imminent danger of death? I don't think any of us are surprised to see that in the written statement. That's not a shock. What would you expect him to say, knowing that he shot and killed someone, terminated pregnancy?
Oh, wow.
But think about this. In order to believe what the defendant puts in his written statement, as well as the statements that he makes in actions, you'd have to not believe what you see in the body-worn cameras. You'd have to not believe what you see in the Kroger videos, because none of those videos support what the defendant says happened. There's been a lot of talk about hindsight, and it's interesting because the person using hindsight in this case, I submit to you as the defendant. What do I mean by that? The defendant is attempting to justify his actions after the fact. He's attempting to tell a different version of events than what the videos show in order to explain his unreasonable use of force in this case. How? Well, after the shooting, we've talked about this, within less than an hour after the shooting, he's whisked away from that scene at Kroger and taken to Blendon Township Police Headquarters, where he meets with the medics. They're there to evaluate him of any potential injuries. And while being evaluated is when he makes that statement to Medic Atkins, which Medic Atkins documents in his, we call it a run report, medic report. Medic Atkins wasn't at Kroger when this happened. He doesn't know what happened. These are the words of the defendant. That he, quote, was thrown off of the hood of the car and onto the ground, end quote, when the car hit him. Those were his words. Now, the defendant knew that didn't happen. Why would he say that? Because he knows the person that he shot is seriously hurt, probably going to die. Don't know if he knew she was dead at that point, but we know it was pretty serious and he knew that. He knows he has to justify the choices he made and the shot that he fired. And that's the story he came up with at the time. But there's a problem. There's video. Not only body-worn camera from him, but also from Sergeant Moynihan, and there's also Kroger surveillance video. At the time he tells medic Atkins his claim of how he was thrown off of the hood onto the ground, he hadn't seen that video yet, obviously. 2 months later, to the day, October 24th, 2023, the defendant submits his written statement to BCI investigators. And after these 2 months have passed, he's now got a different story, a new version of events if you will. Why? He knows that no one is ever going to believe he's thrown off the hood onto the ground once they see these videos. So there's a different version. He uses different words. We no longer see being thrown off the hood onto the ground. We now see words like both my feet were completely off the ground and my waist was on the hood of the car and my body was being carried by the car as she continued to accelerate. And my feet were no longer on the ground and the top half of my body was on the hood of her car. The suspect was trying to flee with me being carried on the hood of her car. Those are his words. His second attempt, if you will, to justify his actions. But the defendant still has a problem. And that problem is, how is he going to get a jury like yourselves to believe that's what the video shows? Answer: hire experts. And you have your experts, and we've heard this term before, work backwards in an attempt to show that what you said happened, defendant, actually is what the video shows. And we see things when they do that. For instance, Dr. Desmond Mullen's animation that distorts what the video actually shows, attempting to simulate to you all that his body was being carried on this hood, gliding, his feet never touched the ground, which we know is not accurate, because we have the real video. And we see things like Kevin Davis picking and choosing comments out of the defendant's own statement and trying to shoehorn those into the cherry-picked still shots that he wants to present to you, while totally ignoring other statements by the defendant about being thrown off the hood and on the ground. We won't even talk about those if you're Kevin Davis. And if you do want to talk to him, then I will tell you the story about how I'm going to interpret what those words actually mean. Kevin Davis is an advocate and he's an interpreter. And then after you have your experts, you put the blame on the victim. You claim that she was committing violent offenses.
Would the council want to approach?
Okay, here we go. I'm sure the judge said, like, fucking wrap this up.
Side cases, by their very nature, are difficult because we always have one witness who can't come into the courtroom and walk up into this courtroom, take that witness stand, and testify as to what happened. Takaya Young can't walk in here, and she cannot tell you what happened on that day of August. Takaya Young no longer has a voice in this case because of the defendant's bullet. But she still speaks to you through the evidence, ladies and gentlemen. She speaks to you through her activation of her turn signal. And she tells you, I wasn't trying to run this officer over, I was turning to the right. She speaks to you through her vehicle and the video of her turning her hands, hand over hand, on that steering wheel to the right. And she tells you, I was not trying to run him over. I was turning as far as I could to the right to avoid hitting him. I wasn't trying to hurt him. She speaks to you through her front tires on the video, turning at that right angle until the rims disappear, and she tells you, I was steering away. She speaks to you through
Hold on here, let's see.
Disappear, and she speaks to you through her front tires on the video, hitting him. I was not of her turning her hands, hand over hand, on that steering wheel to the right, and she tells you, I was not trying to run him over. I was turning as far as I could to the right to avoid hitting him. I wasn't trying to hurt him. She speaks to you.
Yeah, fuck that. That is a completely, I don't even know if that's the thing they're objecting to, but I think that's insane. The victim speaking to you. I wasn't trying to hurt nobody. I just wanted to go home and drink my tequila with my baby. What the fuck? What the fuck with these people? I was done trying to be good.
You through her front tires on the video, turning at that right angle until the rims disappear, and she tells you, I was steering away. She speaks to you through
Yeah, this is... She wasn't speaking. She was saying, "Give me that."
Takaya speaks to you through the slow roll of her car, her inching forward, stopping, and then starting again, and tells you she's not accelerating towards him. I was moving slowly. She speaks to us through the wounds on her body, the bullet lodged in her spine, and tells us she couldn't move her legs. That's why her foot was still on the gas. And she speaks to us through the fetus.
Good. I hope it fucking hurt.
And tells us that he took the life of her daughter. Ladies and gentlemen, Takaya is no longer with us, but she still speaks to us through the evidence. Please listen. No objectively reasonable officer would have believed that Takaya Young posed an imminent threat of death on that day in August. Do not allow yourselves to be sidetracked by those distractions we spoke about. The defense attorney said in his closing that no one gets shot for shoplifting. Ladies and gentlemen, Takaya Young did. Evaluate the evidence. Watch the videos. Trust your own eyes. And apply your common sense. And the state is confident that you will come to but one true and just verdict in this case. And that is that the defendant is guilty of the charges against him, and that his use of deadly force against Takaya Young was not justified. Thank you.
Ladies and gentlemen, back to your initial conduct upon entering the jury room is important. It is not wise to express.
Okay, let's just listen. Blah 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 blah.
Do you have over?
Unfortunately, Your Honor, we have prosecutors who never prosecuted a shooting on a police officer case. Your Honor, this is where we're at. The record was completely devoid, zero, nothing of what anything with regards to evidence of Takaya Young speaking or Takaya Young or any interpretation of that. It's actually precluded, Your Honor, in the case law that her intent you can't even consider. This court has ruled multiple times against them that they could not ask questions of Dr. Bauer and other people about the intent of our client or the intent of her, only what they observed. This was pre-planned, it was done, and unfortunately, I have to ask for mistrial because this was calculated and done knowing your rulings earlier, Your Honor. The case law is clear. If they don't know the case law, I'm sorry. I understand it's closing arguments, but in order to make an argument in closing, you have to have an inference from a fact that's in evidence. There's not one piece of evidence that goes towards her speaking or interpretation of her act, any type of speaking. To use that word, Your Honor, that crosses the line. They don't get immunity. They can't just say it's closing arguments. They don't get to cloak themselves in that. It is a guardrail that's in place that no one ever goes near, and they just did. And we're asking for a mistrial. And at the least, we need a curative instruction in instructing the jury that what she speaks, how she speaks, it can't come in a justification case. They can do whatever they want in a homicide case because there's no guardrails on that. But when you have a justification case involving the use of officer, the case law is clear, the courts have spoken, and they violate it, Your Honor.
The state's argument was toward obvious things that are in evidence. Video of returning a wheel to the right. Video
Well,
of
that's no
tires
bullshit.
to the right. Video of
I agree. Absolute horseshit. Amon Rose is saying, where was that energy during the closing? They had energy. I don't know what you're saying. I've been asking about her blood alcohol night. Nobody's answered me. She didn't have a blood alcohol level. She had weed in her system. But she stole a shitload of booze, so I'm sure she was going to go get lit up.
the car moving slowly. Photos of her injuries. Testimony from the coroner. The statement was that she speaks through the evidence. And then whether that be a video of her hands turning the wheel, video of the tires turning, photo of her injury, it's argued. There's nothing improper about it. Inferences made on items of evidence that have been admitted and testified to.
Your Honor, when he uses the words, speaks to me, saying I'm not trying to hit him, or speaks to us, saying I'm not trying to hit him. It speaks to us through her turn signal, saying I'm going to turn away from you. When he uses the word speaks, that's what's illegal, Your Honor, and that it's inappropriate and it's unconscionable.
Thank you, sir.
I know that they don't like it, Your Honor. I don't know what the word illegal. There's nothing illegal about it.
The case law says you're not to consider her intent in any way, shape, or form. That doesn't give you absolute.
Do not speak over each other. We're keeping this down. At this time, I'm not going to grant a mistrial on the matter. But if we can come up with a curative instruction, I would consider that.
Best of luck to you. Best of luck. Best of luck.
He's just like, fuck you, and fuck you. Yeah, so there we go, chat. I don't think the car is registered insured. What would make you think that? What would make you think that? And chat, then we have the verdict. Verdict came in. I think this is it here. Actually, here we go. Got the verdict. They have jury deliberations. They had a verdict after 3 days.
The windshield of her car hitting Young. Murder trial. All right.
Is we the jury.
Here we go.
The first verdict is we the jury, upon our oaths and law and evidence in this case, find the defendant not guilty of felonious assault as charged in count 1 of the indictment signed this 21st day of November 2025 by each and every juror. Second verdict, we the jury, upon our oaths and law and evidence in this case, find the defendant not guilty of felonious assault as charged in count 2 of the indictment signed this 21st day of November 2025 by each and every juror. Third verdict, we the jury, upon our oaths and law and evidence in this case, find the defendant not guilty of murder as charged in count 3 of the indictment signed this 21st day of November 2025 by each and every juror. Fourth verdict, we the jury, upon our oaths and law and evidence in this case, find the defendant not guilty of murder as charged in count 4 of the indictment signed this 21st day of November 2025 by each and every juror. Fifth verdict, we the jury, upon our oaths and law and evidence in this case, find the defendant not guilty of involuntary manslaughter as charged in count 5. Sixth verdict, we the jury, upon our oaths and law and evidence in this case, find the defendant not guilty of involuntary manslaughter as charged in count 6 of the indictment. Do you want the jury pooled?
No, Your Honor, thank you.
Ladies and gentlemen, on behalf of the community in court, thank you so much for doing your civic duty.
All right.
You're all free from admonitions and instructions.
All that stolen alcohol for nothing.
Everyone can have a seat. Mr. Grubb, Mr. Grubb, you're.
She shouldn't have done what she did. I mean, it's sad she's dead, but she shouldn't have done what. If she had done what she did, she'd be alive. It's not hard.
Mr. Grubb, you're hereby discharged. What? Yes, that's fine. Are we going to get a deputy assistant for the jurors?
Yes.
Well, there you go. Connor Grubb with the dub. Did this judge not give a please? I'm sure he gave one already. So, yeah, she's probably crying about the no-go in the civil suit. Oh, I think so. I think so. And then there was another thing here, guys. This one here, you're just like, are we fucking serious here? But okay. Here's this one.
A jury found him not guilty on Friday in the murder of Takaya Young. 10 TV's Libby Cathy is live outside the Kroger where that shooting happened. There was an event there. Libby, tell us what was going on there tonight.
That's right, Jeff. The family and friends of Takaya Young have gathered here at this Kroger every month on the 24th to celebrate her life. Now, tonight was the first since a jury acquitted Blendon Township police officer Connor Grubb of all charges in her fatal shooting.
So, chat, they literally just met on Monday. Oof.
Say her name!
Tonight, Takaya Young's family, friends, and supporters gathering for a vigil in the same place she was shot and killed 2 years and 3 months ago.
Lord, please, we asking you to bless each and every one that came out here tonight to show love for Takaya, Monet, Yvette Young, Lord.
Young's grandmother, Nadine, leading the group in prayer to celebrate her life.
We need your comfort right now because it's still so disturbing and we're still going through turmoil, trauma, and drama behind her death. It's still so fresh, God. Her spirit is shining bright. She's got a twinkling star up there for each of us and her babies. She's watching over us. Her blue wings and pink wings are flapping.
On Friday, a jury found Blendon Township police officer Connor Grubb not guilty on 6 charges, including murder. Attorney Sean Walton, speaking for the family, says they are still processing the verdict.
This is re-traumatizing. It is something that they're going through all over again, just knowing that there's not going to be any criminal justice.
He says tonight's gathering shows
that despite what the system says, despite what a jury may say, that Takaya's life mattered, that her unborn daughter's life mattered, and that they're not going to stop fighting.
Walton is also representing the family in a civil lawsuit filed in August against Grubb, this Kroger where the shooting happened, and a Kroger employee.
We're going for.
Well, why are they suing? Like, okay, what are you going to do at Kroger? How dare they get the police to stop a shoplifter? How dare they? How dare you not give Takaya this delectable tequila liquor? How about you? Why don't you let her drink all the liquor she won't? Yeah, the Kroger employee too. Yeah, I don't know how that works. I don't know how this works.
Forward, full steam ahead. We are in discovery, and so we are very, very eager to find out more information.
In the meantime, this group releasing star and heart balloons while chanting Young's name.
And I hope the whole Blendon Township hear her name.
Taekwondo Smith came to remember the life of her late god sister and to mark her first time returning to the space where Young was killed.
I love Kaya. We had a close relationship, and if the shoe was on her other foot, she was.
Wait, since she returned, does that mean she was one of the girls stealing liquor with her? Makes you wonder.
Show up and be there for me.
Her message:
don't forget her, always remember her, the good person that she was, caring, loving, and was there for everybody. Like, no matter the mistakes that she may have made in the past, nobody deserves what she got.
And I spoke here earlier with Nadine, Takaya Young's grandmother, off camera. She said that what she hopes people take from tonight's vigil is that Takaya's life mattered and that her light continues to shine. Reporting in Blendon Township, Libby Cathy, 10 TV News.
New details tonight. We're learning more about a crash involved.
Well, there you go, chat. That is the that's the saga of Takaya Young and Connor Grubb. Now, Connor Grubb's, being found not guilty, probably in Ohio a lot of times. That kind of defeats any wrongful death lawsuits because you're like, hey, jury acquitted me. It's actually interstate law, statutorily. So, yeah, I'm not sure how it's going to work. Yes, get out of the car 11 times. Yep. You said you wanted to see her obituary. Have you guys not seen it? I don't know. Let's see what's there. Okay. All right, so here's her obituary. So, Takaya Monet. God, that just waste that, intellectual painter's name. But anyways, this her and all her ratchet glory. God, born after 9/11. Jeez. With deep sorrow, we announce a passing, a loving daughter, sister, mother, and cherished friend. She was a vibrant spirit who touched the lives who had the privilege of knowing her. She departed this world in Sandusky, Ohio at the age of 20. What? Did I get the wrong Takaya Young? I thought this is the right one. Why did she die in Sandusky? That's not the... That doesn't make sense, but this is the date she got killed. What the hell? What the hell? No, this was in Columbus. This doesn't make any sense. Yeah, this doesn't. Zarity says, member 15 months. Thank you for being here. I appreciate it. Says, found out she was pegged, goes straight to the booze. Yeah, sure. Not doubting that. Pushmaster says, good stream. Thank you. Well, thank you. Yeah, I know. We're never gonna cure cancer now. That's the sad part. But no, guys, this was in Columbus. If you guys don't understand, yeah. Triple kill. Flown to Sandusky Hospital? No. No, because I don't know what hospitals they have in Sandusky, but the capabilities of the hospitals in Columbus, you have the OSU Medical Center, probably one of the best hospitals in the state. You have Riverside Hospital. Like, where she got killed, she got killed up here on the north side of Columbus. Like, there are very good hospitals in the Columbus area. And if she couldn't go to Columbus, guys, here's Sandusky. And even then, if you couldn't get to the hospitals in Columbus, Cleveland, you have the Cleveland Clinic, you have Metro Health Medical Center. Probably Metro Health is probably one of the best hospitals in the state, especially for traumatic injuries, especially getting shot. They've consolidated a lot of the hood hospitals. So, but Metro Health gets all the nasty shit. But no, the idea she would go to Sandusky, no, they don't have the kind of stuff there you need. Like, you'd want to go there. I mean, hell, I'd rather. There's like anything in Sandusky, they would like if anything bad happened in Sandusky, they'd immediately send you to Cleveland, or they'd immediately send you to Toledo, or maybe up to Detroit. They would not keep you. That's like a Band-Aid station. That's like if you're up in these towns out here, like basically if you have a baby and you live in these areas, they send you into Cleveland to have the baby because all the little hospitals have closed down. I mean, like, Ohio's having a lot of hospital issues. So, no, I don't think they sent her there. That doesn't make a whole lot of sense to me. Yeah, they messed up the obituary. Did they dump her ashes at Cedar Point? Maybe. I don't know. Sandusky is the name of her car. Oh, she worked in Sandusky, I guess. Oh, keep reading. Okay, we'll go back to this and keep reading. Okay. She enjoyed her role in customer service. Okay. Oh, she worked at Cedar Point. All right. Well, she worked at Cedar Point with all the Eastern European chicks. She was at Champion Middle School, Bridgescape, loving mother to her true cherished sons. Jacoby and Kenley. Jacoby? Fuck, those kids are toast. See that fucking name on a business card. Oof. 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 Shit. I mean, they took all the Jedi names, yeah. Yeah. Oh my god. Her legacy lives on through the enduring member of her family, her dad, Timothy Young Sr., grandmother, Nadine Young, her sister, Tanila, her sister, Talea, her brother, Tim Jr., her brother, Lazarus. Okay, well, that's kind of a base name. Her great-grandmother, Johnny Rouse. She's preceded in death by her mother, Danica. Following, though we grieve the loss of Takaya, Damn. Well, there you go, chat. There she be. So, all I can say is shit. Getting hand jobs behind the toilets? No, I'd rather the Eastern European chicks there do it. So, that's the thing they have her. That's the best picture they have of her? Yeah, kind of. So. So, well. When I don't want to be A generated. Yeah, well. Anyways, chat, I mean, like, honestly, yeah, not guilty. I'm okay with that. So, was Grubb fired by the department, or is he still an active and sworn officer? I don't know. And I actually reached out to his attorneys to see if they could tell me. I kind of get the feeling he probably got fired in the meantime, but he still holds an OPATA certification. So, I don't know. I don't really answer that officially. Actually, hold on. We could check real quick. Is Connor Grubb still a police officer in Ohio? Okay, so the trustee. Okay, here we go. Here's an update. So the township trustees voted to place him on paid administrative leave, which is weird. He's back on paid leave after the not guilty verdict, which is like, I don't understand. I don't understand how that works, but okay. He's back on paid administrative leave, so he's been getting paid the whole time. Stacy said, I'm officially retired. Well, congratulations. But yeah, it's like, what the hell? The chief says, they have due process. Yeah, okay. So they have a meeting between him and the representatives, a review of his actions, a presentation of those to a use of force review board. So yeah, they could do all that. They'll determine whether they were appropriate. Now, yeah, he could still get fired. It all depends on who they can have sit and talk. So, well, there you go, guys. Well, what the hell is this? We're going to watch this real quick, chat. Here we go. A Delaware County Common Pleas judge, Judge James Shuck, is listed as a defendant in the civil stalking protection order after pressuring an assistant county prosecutor. What? Whoa, buddy. Okay, so the county prosecutor said her office received an anonymous letter alleging improper relationship between the judge and assistant prosecutor who has tried dozens of cases in the court. Okay. So the case has been reported to the Supreme Court Disciplinary Council. The prosecutor's been removed. Yep. The assistant prosecutor, whom we are not naming, told a visiting judge that the judge forced her to engage in sex acts back in May in chambers. She testified in court that the judge then bombarded her with what she called tens of thousands of messages, pressuring her for sex. Yes, he probably said, "Hi, dear, will you open up your cloth?" Yeah, okay. On the stand, the prosecutor said that on October, Shuck showed up to her apartment where she let him in and let him sleep overnight in her bed. The detective testified the woman was interviewed by detectives, but the criminal investigations have started. The judge, who's in his second term, he's got his own attorney. So the Supreme Court has already appointed somebody, a special assistant prosecutor there. All defendants have been notified of these allegations through their attorneys. Wow. Okay. Whoa, that's fucking ridiculous, man. Wow. Okay. Well, there you go. Wow. Yeah, that's did she do the needful? Yeah. Who, buddy? Oh, and then what are the names of the baby elephant? Oh, God, that thing looks ugly compared to a full-grown elephant. After receiving 11,000 names, there are 4 finalists. So here are the 4. Theo, Oliver, Ozzy, and Frederick. Okay. Not Elephant McElephant Face? Oh, yeah, you want to name her Takaya? Well, here we go. Here's the pictures. Aw. Oh, there's a little baby elephant. Oh, there we go. There we go. So there we go. Schnauzosaurus, yeah, Trunky McTrunk face. Yeah. God slave. Jesus Christ. Yes. Elefante. We just had a base New Zealand acquittal today. Chat might like. Well, send it to me. I'll take a look at it. Let me know. Something worth looking at. Oh, you did send me something here. Okay. Huh. We'll take a look at this. Oh, I gotta open it up. I gotta do it in a archive or something like that. But anyways, just did. If no guns, then boring. All right, chat. Well, that's it. Connor Grubb is done, and I'm not sure what we're gonna do tomorrow, but we'll do something. Busiest bar night of the year. Maybe we'll drink a couple of beers. I don't know what we'll do. We'll hang out. We'll hang out, chat, and I will talk to you guys tomorrow. So until then, chat. Just remember, till next time. Just because you did it does not mean you're guilty. And that includes Connor Grubb, not guilty. Rightfully so. Congratulations, Connor. Go be a free man. Good night, chat. And Connor, enjoy your Thanksgiving.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty. But please talk to a local attorney. Was that the fat guy Rick Hayden yelled at? Why, yes it was.